Yes. Good morning.
Good morning,
Your Honor.
Your Honor.
Good morning, Your Honor.
Now, so I think do we have Mr. Moorkath with us?
Yes, I see.
Yes, sir, Your Honor.
He just needs to switch on his camera. Sorry, Your Honor. Yeah.
Could you move your camera a little bit, Mr. Moorkath? I've got only half of your face at the moment.
1 second.
That's better. That's better. Thank you.
Okay.
All right. Now, Mr. Moorkath, I'll remind you that you remain under your oath that you took yesterday.
Okay.
And now we're going to have some re-examination, some further questions from Mr. Costello. Mr. Costello.
Thank you, Your Honor. Mr. Moorkath, you were asked a number of questions yesterday, and I'm going to introduce the topic that you were asked about to try and remind you and ask you some more questions about them, okay?
Okay.
Do you still have the bundle in front of you?
Yes.
Good.
I have the bundle with me, yes.
Okay, great. You were asked yesterday questions about an email at page 156 of the bundle. This is the email from Tariq. 156.
Yes.
So this is the email from Tariq Hamza Rahmatullah to yourself.
Yes.
Okay, great.
Yes.
You've been through this already, but just to remind you, this is the email where you were asked to withdraw $1 million to be handed to Husham, and then instructions need to be treated with high level of confidentiality. Okay?
Yes.
So, and yesterday, some of your answers were as follows. You accepted that this email doesn't mention Sudatel. The email didn't mention what the payment was for Sudatel. And one of your answers was that this is just an arrangement of cash. Okay.
Yes.
Now, did
Yes.
you understand for whom the arrangement of cash was for?
In this time, it's mentioned hand to Mr. Husham, is our admin manager.
For EXPRESSO or for Sudatel, or which one is it?
EXPRESSO.
Okay. Yeah. Did there? I think you said also in evidence yesterday that there were conversations that arose as a result of this email.
Yes.
With whom were those conversations with?
With Mr. Tariq Rahmatullah, and also I received a call from Mr. Sami Yusuf.
Okay, and just to remember, Sami Yusuf was the Vice President of Finance of Sudatel.
Yes.
And Mr. Sam, did you say, and did you also say,
Rahmatullah.
Tariq Rahmatullah was the CEO of the dependent of EXPRESSO?
Yes.
Okay, now in those conversations, what was said about anything, if anything at all, about the money?
No, the initial discussion, it was arranging the money.
Yeah.
Just arrange the money and keep the money USD 1 million ready. That was the initial discussion.
So that was the initial discussion. When was that?
The same day, I think May 30.
When you say initial discussion, that sounds like there may have been more discussions. Were there more discussions?
No, it was like the instruction was very clear for me. Arranging money, like, withdrawing money from our account and arranging in US dollar.
Yeah.
So the instruction was clear. Then I start communicating with Wall Street Exchange. So meantime, I was communicating with Mr. Sami Yusuf also.
Yeah. When did you become aware that the money was for Sudatel?
Immediately after I got instruction, of course, I discussed with Mr. Tariq Rahmatullah. So the instruction came to him, I believe verbally, because I have not received any other instruction through email. So Mr. Tariq Rahmatullah explained to me this money we are arranging for Sudan.
And when was that?
Same day, 30th May 2016.
Okay. Were you and Tariq Rahmatullah sitting near each other in the office, or how far?
Same office.
Same office.
Same office, different cabin.
Okay. Now, one of your answers yesterday was also that you accepted that the email asked you to treat the instructions with a high level of confidentiality, and you also said there is reason for this. What I want to understand from you is what was the reason for this?
Reason, normally, if you're arranging a large amount of cash, this type of instruction always there. For example, sometimes we will go outside the office to collect the money. So we cannot communicate with many people during this stage. So that is the confidentiality which they mean. That's what I understood.
Mm-hmm. At the time at which you sent the email and had your follow-up conversations with Tariq Rahmatullah and Mr. Sami Yusuf, at that point, that just so I've understood, you're aware that the email is confidential. You're aware that the cash is for Sudatel, but did you know what Sudatel was going to do with the money?
In that stage, I'm not aware about that.
Okay.
How they're going to use.
Yeah. I think you said yesterday that you became aware what Sudatel would do with the money much later, around the time of when the money was being handed over. Before
handover, I received the.
Oh yes, sorry, the WhatsApp. Yeah. You mentioned the WhatsApp yesterday. Okay. Just want to quickly look at the intercompany transactions themselves. So if you open up page 140,
Excuse me. 100, right?
yeah.
Yes.
This is the intercompany. This is the Sudatel. Sorry, the EXPRESSO intercompany statement.
Sorry, the page number you mentioned 104, right?
140.
140. Sorry.
This is the accountancy entry.
Yes.
And you see on the 15th of June, we've got two entries. One is in green, one isn't in green.
I'm sorry, Mr. Costel, if I could interrupt you. I think you asked, but Mr. Moorkant didn't answer. Whose intercompany account is this? Whose
record? I'm
record?
sorry. Yes. I took it as read, but I shouldn't have. Mr. Moorkant, have a look at page 137 of the bundle.
137. Yes.
We've got at the top left-hand corner at what looks like a title, EXPRESSO Telecom Group Limited, and then underneath it says due to STG as at the 31st of December 2016. Yeah.
Yes.
Now, just so I understand, I don't think there's a dispute, but this is the company, this is the accounting record for the payments made from EXPRESSO to or for STG.
Not only payment made, these are the transaction, but we can say this is the extract of statement of account for EXPRESSO Telecom. So these all transactions we recorded in EXPRESSO Telecom.
For EXPRESSO Telecom, but it was ultimately to do with STG, as in the payment was ultimately to do with something. For example, payment.
Yeah, that is the technical word we use. Due to
Right.
STG means the balance appearing as due to STG. The
Oh,
amount
okay.
we payable to STG.
I understand now. Now, if you look at the 15th of June transaction,
Yes.
page 140.
Yes.
Now, I was going to ask you questions about the 15th of June, the second 15th of June transaction, which the $1 million transaction. The wording here is cash for, I'm emphasizing the word for, STG. Is there any significance on the in relation to the word for, FOR?
No, this is like we arrange this cash for STG.
Yeah. Let's do it another way. If you look down the page and you see the 30th of June, same page, but if you look further down, you'll see a payment called cash to STG from Chinguitel. So I'm just asking, in terms of the entry and what it means for you, is there a difference between the wording cash to STG and cash for STG?
Yeah, actually, this transaction came from Chinguitel. Chinguitel is our subsidiary. So I received the same narration or description from Chinguitel. That's why I put the same narration there. The 15.6 the cash for STG, that was I entered myself. I put the description.
Yeah, you put that one down.
Yes, yes.
And I think you said yesterday that cash was essentially gathered, and the date of the 15th of June is the date that the cash was gathered itself, in a literal sense. That's the day it was prepared, but it wasn't the date it made its way to STG. Is that right?
Yes, when I received this transaction from Chinguitel, this is almost same. I have no idea about how they spent, but later on, I came to know they use the same amount for the same purpose. Because
yeah, sorry, I think my fault. I think I may have confused you. Just specifically on the $1 million money that was to be sent to Sudatel, that entry says cash for STG on the 15th of June. Do I understand your evidence to be that money was gathered and prepared on the 15th of June? It didn't actually make its way to Sudatel on the same day.
Not the same day.
So when you look at this, the whole point of this is, so when you look at it, what do you understand this entry to mean? To someone who looks at this, what does this mean? What happened in relation to that money?
I believe I explained yesterday, but I can repeat.
Yeah.
When I release a check and the money or the check has been appeared in our bank statement, I have to pass the entry in my book of accounts. The entry is we have to debit wherever it's going, like this money for STG. That's why I enter one entry in Sudatel account and the second entry in bank account. So this date, 15th June 2016, the money has been withdrawn from the bank.
Yeah. So that's the date of the withdrawal. It doesn't say.
Koshtel, just a minute. Yes. I'm sorry to trouble you again, Mr. Moorkhath, but I keep losing the right-hand side of your face. I wonder if it's possible for you to just move your camera a little bit.
Let me check. 1 second.
So I can have the pleasure of seeing the whole of your face.
1 second. Actually, I'm using iPad.
Yes, all right, that's better.
Is the left.
Yes,
it might be, Mr. Moorkhath, that it might be easier if you physically try to move. So you move your chair across, leave the iPad, you move yourself slightly to your left a bit more. I don't know if that helps you, Your Honor.
Yes, I've got you.
Okay, leave the iPad. Don't touch it anymore. Okay. Fine. So you explained that that was the date where the money was withdrawn and ready. What I was going to then go on to ask you is, when you made the entry, cash for STG, did you at that point of making the entry know what the use of the money was going to be for?
Yes, I have no idea how they're going to utilize the money.
Okay, fine. Just bear with me one moment whilst I just find another. Oh yeah, the paragraph's here. Yes. Can we just have a quick look at page 192 of the bundle?
192. Yes.
You may recall you were asked some questions about this email yesterday. And obviously, as we know, Sam Youssef was the Vice President of Finance of Sudatel. Now, in his initial email, there was an email sent from yourself to someone called, I think it was Ustaz, is that? Sorry, it's to Sam Youssef, but it's directed to Ustaz. Do you see that?
Yes.
Just so I understand, who is you, Ustaz?
Ustaz, this is the common salutation which we use to salute the people, like higher officials in Sudan. Ustaz.
Yes. Now, it says that the current balance is 2.1 million, including 250k in QNB, and then from Ghana money 3.25 million paid as below. Kuwait 1.75, cash 1 million, Guinea 500k. It's the cash I want to ask about. What is that? What is that in relation to?
Yeah, this is the exact amount of $1 million which we arrange for Sudatel.
Right.
So this email, basically, I'm explaining to him. Actually, we received around $5 million from Ghana. So how we utilize those amounts, out of that amount, Ghana money, 3.25 million we utilize in this way. 0.75 million we paid to Huawei, 1 million cash we arrange, and 500k we paid to ECOWAS Bank. So this is like, weekly cash flow update to Mr. Sam Youssef.
Yeah, and so Sam Youssef replied back to you on the same day, saying, asking for other balances, and then you responded again on the same day, explaining the total available balance, including Ghana, and then you asked him to have a quick look at the details below. But were there any other emails in response to this?
No. This was clear. Like, he was expecting some other receipt. So that's the reason he was asking, I need the other balance also.
Okay. I just want to move on slightly to a different topic now. Do you remember the payment procedures that you were taken through by Mr. Doherty yesterday?
Sorry, payment?
Do you remember the payment procedures that you were taken through yesterday? I don't want to go through the detail, obviously, but is there a difference between procedures in relation to payments where the money is going to be received by a third party, sort of like a disbursement, and money that was going to be moved over to the parent company from EXPRESSO?
Yes, there is.
Okay. Now, in relation to the former, meaning a disbursement or third-party payment, those procedures that you were taken through, were those the appropriate procedures to be used in relation to those sorts of payments?
For third party, there is different procedure, yes.
Yeah. in relation to an internal movement of money, is there a set procedure or a defined procedure?
There is no defined procedure. There is no set of procedure. So normally, we will act as per the instruction.
Mm-hmm. And when you say as per the instruction from whom?
From Sudatel. If the money, the money belongs to Sudatel, so of course we will wait for the instruction from Sudatel.
Yeah. And
for me, I'm reporting to Mr. Sami Yusuf, VP Finance.
Yeah.
So normally I'm getting instruction from Sami Yusuf, and President also giving instruction to me, Mr. Tariq Zaid.
Yeah. Okay. That was going to be my next question, which you've anticipated already. Moving on then. Yesterday you were asked a number of questions about the handing over the money and receiving a receipt from Tariq Zain, which approved the use of money in Mauritania. What my question was going, you also gave evidence that you were given the approval memo after handing over the money, and there was evidence also about the WhatsApp. My question is a bit more specific. For you, is there a difference between memo and receipt? Are they the same thing? Just explain that to the court, please.
When I received the memo, there was no additional notes. It was just a memo explaining the utilization of money.
So pause there. It might be easier if we then look it up whilst you explain. So if you look at page 316 of the bundle.
Page?
316.
Yes.
Is this the memo you're referring to?
Exactly, yes.
And you were saying when you received the memo, you didn't have a receipt.
I don't have
the note. Excuse me, notes. I don't want to misquote. You said notes. Now, yes. Just looking at this document, and there are differences in color, if that helps you. Tell us how it looked when you first received it, what was then added, etc.
Well, can I I'm sorry to interrupt, but Mr. MOORKATH, the document at page 316 is a translation of the document at page 317. What did do you read Arabic?
I can read Arabic, but I cannot, I cannot understand the complete meaning. I can read.
Which one? What did you receive? Did you receive an English or Arabic version?
Arabic version.
Right. Thank you.
So that's at 317.
Yes.
So maybe I think there may be a way of getting there, but if you look at the one at 317, how did it look to you when you first received it?
Sorry. When I first received this memo, there was no handwritten notes.
And in terms of the handwritten notes in the Arabic version,
yes.
Can you identify where the handwritten notes are?
There are two notes.
Mm-hmm.
The first note, number 1.
Yeah.
It mentioned the CEO indicated that he would submit a receipt for the amount from the Presidency of the Republic.
So cross-referencing that to the English version, which is at page 316.
Yes.
Scroll up. Where it says you've read out the CEO indicated it will submit a receipt. That wasn't there, is what you're saying. Is that right?
No, there are 3 notes.
Yeah.
2 notes, they put 1 and 2 in circle. Actually, that number 2 they wrote in Arabic. Mm-hmm. So these 2 notes written by Mr. Sami Yusuf, you can see the signature just above Sudatel Telecom Group Limited.
So above the stamp
in the memo.
Yeah.
Okay. So that signature by Mr. Sami Yusuf, and he wrote 2 notes. first note, as I explained, he mentioned the CEO indicated, the CEO means Tariq Zain.
Yeah.
Okay, indicated that he would submit a receipt for the amount from the Presidency of the Republic.
Mm-hmm.
And second note, for the disbursement of this amount, the registration of the amount is suspended until it is approved by the administration or the executive committee to disperse and classify the amount.
Mm-hmm.
So these two notes written by Mr. Sami Yusuf, I'm not sure when he wrote, but when I first received this memo, these two notes are not there.
Mm-hmm.
Okay. And we can see another signature in the right-hand side that is signed by Mr. Tariq Zain.
Yes. So we have Mr. Sami Yusuf on the bottom left-hand side, and Mr. Tariq Zain on the bottom right-hand side.
Right-hand side. And Mr. Tariq Zain, he wrote, it is deducted from the social contribution approved by the General Assembly.
Is that the diagonal, slightly adjacent writing?
Writing, yes. That's like writing.
Slightly slanted.
Yes.
Yeah. When did you first see these notes, these three notes?
This is, I cannot recall, but I'm sure this is after handing over.
After handing over.
But I cannot recall, but this was the document which I attached with the physical document.
Okay. So when it comes to the document recording, these are the notes that you used.
Yes.
This document, as we see it, is the one that you used.
Yes, this was the final document I communicated with Sudatel.
Okay, understood. I want to move on to a different document now.
Just before you leave that.
Yes, of course.
On the Arabic version on page 317, you see towards the top, you've got two boxes there. The box on the right-hand side, just above it, is that another signature?
Yeah, that is same Mr. Tariq Hamza Zain Labdi, his signature.
All right.
That's Tariq Zain. Okay.
Yes.
And did he sign that at the same time that he signed the note that's at an angle, the diagonal angle at the bottom?
Yeah, that is same signature of Mr. Tariq Zain, but I'm not sure he signed it on the same time.
All right.
Okay. What I would like you to look at is page 240, please, of the bundle.
Yes.
This is what you've called the approval memo from the board of directors.
Of Sudatel.
From Sudatel, yes. Now, I understand that your evidence was yesterday that you obtained this not from, sorry, only from emails. Is that right?
Yes.
Yeah. Now, you don't have an approval memo like you have for 2016. So my question to you is, following the questions you asked yesterday, is what was the purpose of you presenting this document to the court?
Yeah, the purpose of presenting this document, I'm trying to explain the investigation has been started in 2021, but this memo dated 2019. As per this memo, the dispatchment of those transactions already approved by Sudatel board. Then during that time, even during this approval process, I'm not received any query. And in 2019, I came to know they already got approved this transaction. Then 2021, I really strange about the investigation of the same transaction. So I'm trying to say that the transaction already approved in 2019, then there is no reason for restarting another investigation on the same transaction.
Yeah, okay, understood. Bearing this memo in mind, can you just have a look at page 252, which you were asked about yesterday as well?
I'm sorry, Sash,
Yes.
what page?
252.
Thank you.
This is the minutes of the investigation meeting, Mr. Moorkhath, on the 6th of May 2021. Do you see that? You have that? Okay, great. If you look at the bottom of that page, you'll see a question from Mr. Moala. I think Moala is how you pronounce it. Moala.
Mr. Moala.
Where he says, but the documents before us indicate that the money intended to go to Mauritania. Do you know which document that was a reference to?
I couldn't see, that time I didn't see the document, but I believe this is the same document of this memo which is referring to, because that memo clearly explained the money is going to Mauritania.
Okay. Final questions. I'll just wait for the learned judge to take a note.
Thank you.
That's right. It's easier in person because you can see. After you were dismissed, you gave evidence yesterday that you were looking for employment. Okay. Yes. And I think Mr. Doherty explained to you the normal sequence, which is you make application, you send a CV maybe separately, but either way, you make your application, you may be interviewed once or twice, sometimes, unfortunately, maybe even 3 times for certain jobs, but then you may get an offer, and then once you've accepted, you give your notice, and then you go through the process then, which may include visa cancellation. Okay?
Yes.
Your situation, please explain to the court. You were already dismissed. I don't think that's in dispute. Is it correct?
Yes.
When you were making approaches to employers, did employers ask you any questions about your current situation?
Yes. First of all, I just want to explain the situation which I was going through that time. I was under suspension almost 10 months. In the month of May 2021, I got suspended, and almost 10 months I was under suspension. So I know, Sudatel. First, I was expecting maybe after investigation, Sudatel will reinstate me to the same position. But unfortunately, February 2022, I got dismissed.
You mean March? March.
March 26, yes. Then within 6 days, I sent my reply to the dismissal notice. So I clearly explained, I'm not agree the cause which you mentioned, and I can give all the supporting document which you are looking for. And also I requested to cancel my visa.
Yep.
So in reply to my notice, they ignore about the visa cancellation because they are not mentioned anything. And when I discussed with Mr. Mustafa Abdul Malik and the admin manager, Mr. Husham, what I came to know, the visa cancellation under Sudatel approval.
I'm just interrupting only because I'm just conscious that you want to give certain answers, but in fairness, you have to answer the question, and I can't let it carry on if I know that you're not answering my question. But we'll get there. Don't worry. My first question is: when you were dismissed, and you said yesterday you were approaching. I use the word employers, but I think you said yesterday recruiters to try and get another job.
References.
Yeah, sorry, you said references. Yes. To try and get another job. But were you asked by anybody what your situation was? And by situation, I mean your employment situation.
Yes. This is, previous question. If you approach any person regarding job, of course, they will ask about our current situation. and I'm compelled to explain my current situation.
Yeah. So what did you tell them?
I inform, I basically, I say I resigned from the company, and I'm waiting for my visa cancellation. So that is the common answers. Like, they will, when they inquire about my situation, I will explain in that way.
Yeah. Did you tell them that you're not working at the company anymore?
Yes. I informed them, by end of March, I got released from the company, previous company.
Okay. Yep. When it came to your visa situation, you've already given evidence yesterday. I'm not going to go into it again, but you made a request through a first legal notice, then there was a response, there was a second legal notice, then there was another response. I don't think it's disputed, but in between the second legal notice and the second response, there were the emails sent about the cancellation of a visa by you of your family members. And that was on the 28th of September 2022. Do you remember that?
That was after third notice. I sent my third notice on 22nd September.
Yeah, you're calling it third notice because when you received your dismissal letter, you then replied back. So that's number one. Then you sent a legal notice. That's number two. There was a response to that. Then you sent what we call the second legal notice, but that's your third notice. Just so we understand. I think that's what you're referring to.
Yes.
Before receiving the final response, which came from Sudatel in October 2022, there was an email sent to you about cancelling your family's visa. Do you remember that?
Yes.
Now, I just was trying to understand, was anything said to you about cancelling the visa before that email?
No, that was first time I received an email or communication regarding my cancellation.
After you received the final response, did you go to cancel your family's visa?
When I received my final reply from Sudatel.
Yes, right? Correct.
That was on 10th October 2022.
Correct.
So after that, I communicate with my lawyer. What will be our, action against the legal notice, the reply to the legal notice. Then we were under discussion, and meantime, he suggests me, okay, if they want to cancel the visa, this up to you, you can cancel, but you have to mention you are not received your obligations.
So then, I don't think there's, again, no dispute on this. You didn't cancel the visa, and there is a document in the bundle, which we don't need to go to now, but there is a document where you don't confirm that you received all of your dues.
Yes, that is one document.
Yeah, that's page 420 of the bundle.
Yes, this is the document.
Who wrote this document?
I wrote the document. This is the procedure in DIFC. If an employer, they want to cancel an employee's visa, employee should declare either he receive his dues as full and final settlement, or he can declare is not receive in dues. So once I give this document, then they can cancel the visa.
Okay. All right. Thank you very much. I don't have anything further. Does Your Honour have any questions?
No, I don't. Thank you.
Thank you, Your Honour.
All right. Well, Mr. Moorkhath, that completes your evidence. You can, of course, remain online and observe the rest of the trial. But your no longer required as a witness.
Thank you, Rene.
So you may switch off your camera if you wish, and
Okay.
please, of course, mute your microphone.
Sure.
So you're now discharged as a witness.
Thank you, Rene.
All right, Mr. Costello.
Yes,
Well,
Your Honour, yes, that's right. That's my case.
All right, thank you. So, Mr. Doherty, do you call evidence?
Yes, Your Honour. I suppose slightly in your hands. I'd much assumed that we would begin by calling Mr. Abdul Malik.
Yes. All right. Is Mr. Abdul Malik online? Can't see him there.
Yes, he is. I understand. Well, I believe he's giving evidence from my instructing solicitor's office, and I've been told he's going to be on in 2 minutes.
All right. Well, we'll sit and in silence in the hope that will speed it up.
Morning.
All right. Good morning, Mr. Abdul Malik. A court officer will now just swear you in. Ms. Norton.
Thank you, Justice Lemiere. Good afternoon, Mr. Abdul Malik. Mr. Abdul Malik, I understand that you wish to give your evidence by swearing on the Holy Book today. Is that correct?
Yes.
Okay, perfect. And can you please confirm your full name and your address for the benefit of the court record?
Mustafa Abdul Malik Muhammad Abdul Rahman. I'm living in Casadora, villa number 123, Serena, Dubai.
Thank you. And Mr. Abdul Malik, can you please take the Holy Book in your hand? Thank you. And if you can just raise that to the camera so the judge can see. Thank you. And if you can please repeat after me. I swear by the Almighty God.
I swear by the Almighty of God.
To tell the truth.
To tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you.
Thank you, Ms. Norton. Yes, Mr. Doherty.
Yes, Your Honour. I was waiting for my page numbers to load on the system, but I finally just got it. Morning. I think it's probably afternoon with you now, just about, Mr. Abdul Malik. You should, I think, have access to a bundle of documents. What I'm going to do is give you a page reference, and if you could type in that page reference, it should pull up the document that I'm referring to. So if we can try that first of all, and if I can ask you to turn up page 105.
Yes.
Hopefully there you should find a document which in the middle of the page says First Witness Statement of Mustafa Abdul Malik. Apologies, Mr. Costello. I think, were you trying to say something there? I saw your hand raised and
No, sorry, no.
Someone in there, fine.
No, I'm speaking to my colleague, sorry.
Apologies, I thought you might be trying to raise something.
No, my fault.
My apologies, Mr. Abdul Malik. Do you have that page that says First Witness Statement of Mr. Abdul Malik?
Yes, I do.
As you scroll through this document, it should run through to page 111. It's 33 paragraphs long. Do you see that?
Right. And yes.
And there is a signature at the end of page 111, and the date 6th of December 2023. Could you confirm, is that your signature?
Yes, yes, I do.
Yeah. And have you had the opportunity to review this statement recently?
The last time I reviewed it, the time I signed it.
Right. Okay. Well, can you confirm that the contents of the witness statement are true to the best of your knowledge and belief?
I do confirm.
Thank you. And second document, if I can take you to page 129.
Yes.
You should see a document which says second witness statement of Mustafa Abdul Malik. And same again, if you scroll through this document down to page 135, this time it runs to 30 paragraphs, and you should hopefully find another signature at the end of this document. Do you see that?
Yes, I do see it.
Can you confirm that that is your signature?
Yes, it is. I do confirm.
And again, could you confirm that this statement is true to the best of your knowledge and belief?
I do confirm.
Thank you. If you'll remain there, there will be some questions for you.
Well, just before you do, so I'll take as read and receive into evidence each of the first witness statement of Mustafa Abdul Malik and the second witness statement of Mustafa Abdul Malik, together with, to the extent they're not already been received, the exhibits referred to in those witness statements with the numbers that they bear, but I think it requires one qualification. Somewhere in here, I think the first witness statement is a reference to the Parker-Russell report. I think that might be
21, I think.
21. Yes, so MA 146-69, is that it?
Yes.
Now, I indicated yesterday, Mr. Doherty, that my provisional view was that that report should be received as evidence that the report was received by at least EXPRESSO, and I think, if I recall rightly, that whether Mr. Abdul Malik did, but it was received by EXPRESSO, but it's not received as evidence of the truth of what is stated in the report. Now, do you wish to say anything about that, or shall I proceed on that basis?
No, I'll bring you to the report in submissions. I don't think that, well, I think it's common ground that this isn't said to be, nor is it relied on as though it's an expert report, as you would probably understand it in these proceedings. It's a report that EXPRESSO, as the employer, had at the time it made the decision to terminate employment, and that's the basis upon which.
Well, I think there is, yes, I think there is probably another not too subtle difference, and that is it's not relied upon as an expert report, hence any opinions stated in it are not received as expert opinions. But over and above that, to the extent that the report contains or puts forward facts, that the report is not received as to the truth of the facts there alleged. Do you accept that as well?
Yes, Your Honour. I think the point you're making is that insofar as the report says on such and such a date, such and such happened, Your Honour would take that in the light of whatever documents we have which underlie that. So you'd be looking at the documentary evidence and what the report says about that. Yes, yeah, I understand that.
Yes, all right. All right, well, I think we can proceed.
Yes, thank you very much. Yes, Mr. Abdul Malik. I'm sorry.
I was just going to tell Mr. Abdul Malik, you've probably understood now what's going to happen is that Mr. Kostel, who appears as counsel for the claimant, he's going to ask you some questions. Yes, Mr. Kostel.
Yes, thank you. Mr. Abdul Malik, how long have you been with EXPRESSO?
Joined late 2015, so it's been 8 years almost.
Okay. So you were there at the time that the 2016 and 2017 transactions took place?
Yes.
And EXPRESSO is a company, we know that it was incorporated many years ago, but it is a subsidiary to Sudatel, is that right?
Yes, yes.
And it is it is majority owned by the Sudanese government, correct?
My knowledge is.
Okay. And am I right that EXPRESSO was the only subsidiary company outside of Africa fully owned by Sudatel?
As far as I recall now, yes, it is the only one by Sudatel.
Yes. And I don't think there's any dispute between us that Sudatel would ask EXPRESSO to make certain transactions on Sudatel's behalf, correct?
Yeah, that's correct.
And there were sometimes occasions where Sudatel would require of EXPRESSO to gather cash for Sudatel's use.
Yes.
And in 2016, certainly that transaction, that was one example, potentially, whilst we may disagree between us whether in fact that was so or not, but on the face of it, that was potentially one of those sorts of transactions. Is that right?
Yes.
Okay. What was your role in 2016, 2017? If indeed there were the same roles in the 2 years?
I was a strategy director at that time.
You were strategy director
Strategy
at that time?
director in EXPRESSO, part of Sudatel Group strategy department.
How many investigations had you conducted into any wrongdoing by any employee?
You mean when I was strategy director or when I became then acting CEO or deputy CEO?
Let's stick to at that time in 2016, 2017.
No, because it was not part of my scope of responsibility.
Let me see if I can ask another way. Was Mr. MOORKATH's case the first time you were asked to investigate any wrongdoing by any employee?
At that time, 2016?
Yes.
No.
But I was sorry, 2021. Sorry, 2021.
Yes, 2021, I received a request from the group to investigate this case.
As part of the investigation...
I'm sorry,
yes.
the question was that the first time you'd undertaken an investigation? You answered by saying, I did do it in 2021. Was that the first investigation you undertook?
No, before that, we had also investigation about Mr. Tariq Rahmatullah case as well. That was before. That was a different case.
So the Tariq Rahmatullah case, you say, was a different case. Is that right?
Yes.
Did I hear that right?
Yes.
We've heard his name mentioned in the context of this case with Mr. MOORKATH. Did you interview or speak to Mr. Rahmatullah or investigate him as part of the context of Mr. MOORKATH's case?
No.
Were you aware at the time in 2021 that Mr. Ramatullah was the CEO of EXPRESSO?
At 2021?
Yes.
No, he left by then. Because then this is how I became acting CEO. Yeah.
My clumsy question. Were you aware at the time in 2021 that Tariq Ramatullah was the CEO at the time these transactions took place?
Yes, he was the CEO.
Yeah.
Of EXPRESSO.
Yes, of EXPRESSO. And you were surely aware at the time that the suggestion was that Mr. Ramatullah had an involvement of some sorts in this case of Mr. MOORKATH.
Please, if you just can clarify the period, the time period you're talking about. So you are talking about the 2016 or after I became responsible of those?
Let me ask again. You must have been aware when you were investigating this case about Mr. MOORKATH's role and actions that he says that Mr. Ramatullah was involved in some way in the 2016 transaction.
Yes.
Right. And yet a decision was taken not to interview Mr. Ramatullah. We agree about that, don't we?
Decision is taken by who?
You tell me. Who decided not to interview Mr. Ramatullah?
It was the Sudatel legal department. When we basically sent them the report of the investigation of FAIZAL, they said that they already have a legal case in Sudan, and they are planning a legal case against all the involved. So our role stopped there as EXPRESSO.
So I just want to make sure I understood. When you sent the investigation of FAIZAL's report, you were told that there is already a legal case in Sudan. Is that right?
I don't recall well either planning to do it or there is ongoing already legal case, but it's just the issue is being taken care of by the Sudan.
When you were investigating FAIZAL, did you consider that you would have to possibly dismiss FAIZAL? You might not need to dismiss FAIZAL. Were you considering that?
When I investigated FAIZAL?
Yes.
No, there was no decision at that time whether dismissed or no. And the investigation committee basically suggested the suspension. And then we were waiting for the instructions from Sudatel, but the investigation committee suggested the suspension because they concluded that there was a mistake in the procedure. And then we were waiting.
I'm only going to stop you because I don't think you're answering my question. When you were investigating FAIZAL, did you have in mind that the possible decision that might be taken? I think your answer was that you had decided not. There was no decision to dismiss him at the time. Is that right?
Before I investigate him, I cannot put a decision in my mind. Definitely, all the options will be open for it. It's a case, it's an investigation, so it's either dismissed or he retained the position. We don't know. That's why the purpose for the investigation, actually.
Right. So as you said it, all options are open. You don't know what you're going to do. Is that fair?
At that time, yeah, before the investigation.
Before the investigation or during the investigation? Or both?
Once we initiated the investigation process, all options were open.
Well, when did you decide that all options were no longer open?
When we received the... first of all, we did not decide as EXPRESSO on the dismissal of FAIZAL. Once I received the investigation committee report, then it was for me clear that the decision at my level is to suspend FAIZAL and to send the report to the group, waiting for their instruction.
Let's just see if I understood this. You're asked to investigate FAIZAL. Sorry, Your Honor, I think it might be easier if I just use his first name. you were asked to investigate FAIZAL. Yes, is that right? Great. As part of that investigation, you interviewed FAIZAL, correct?
I did not myself in person, but I assigned the committee to do that.
Okay, you assigned a committee to do that. A decision was taken that FAIZAL should be suspended. Is that right?
Yes.
Who made that decision?
The committee.
Oh, and the committee, was that, were you a member of that committee?
No.
Okay. Bear with me. Were you the one who actually suspended FAIZAL?
Yeah, if you mean
That's
I was the one who sent the email, yes, I was the one who sent.
That's at page 269 of the bundle. I don't need you to look at it, but as long as you agree, you are the one who sent the suspension letter.
Yes.
My question is this: did you send the suspension letter on instruction?
Actually, I sent the suspension letter because I received from the investigation committee that he should be suspended. And I definitely then spoke to the CEO of the group and the legal department, and they confirmed that I should go ahead with the suspension.
Mr. Ala Alub was the one who emailed inviting the committee to suspend. Is that right?
Yes.
That was by an email, I think, on the same day as the 6th of May.
Yes.
So Ala Alub emails the committee to suspend. Committee decides to suspend. You're given an instruction to suspend. You now say for the first time that you spoke to your CEO and confirmed that you should go ahead with that suspension. Other way around. You are asked to suspend. You then speak to the CEO, confirm you should go with the suspension, and then you suspend. Is that right?
I'm not sure the order you have mentioned, but it's pretty clear when I received the investigation committee report and the recommendation to suspend. That was my recommendation as well. I spoke to the CEO and I told him the outcome of the committee and that we recommend to suspend and then we suspend. So I just received a confirmation. This is how it.
In relation to this investigation over FAIZAL's conduct in the 2016 transaction, was FAIZAL the first person that you spoke to physically, in terms of not physically, in terms of an actual witness? Was he the first person that you spoke to?
About the case in 2016?
Yeah.
Yes, he's the only one.
He's the only
first
one.
And the only one.
He's the only one. Let's look at page 250, please.
Yes.
This is an email from Ala Alub to many others, including, I believe I think you're in this, aren't you? Can't remember. You might not be. But this is an email sent from Mr. Ala Alub, but we can see from the first page, number 1, form an investigation committee with the following members, and you're part of that investigation committee. Yep, you see that?
Yes.
Yeah. 2, the suspension of FAIZAL, and the committee. 3, the committee once formed today will inform FAIZAL due to attend an investigation hearing tomorrow, so that he may offer his own evidence and prepare for the hearing. Do you see that?
Which paragraph?
Numbers 2 and 3. 2 says to suspend FAIZAL.
Yeah.
3 says for a committee that's formed today, which I think is the 1st of April 2021, if I read paragraph 1 correctly. So the committee formed on today will inform FAIZAL to attend an investigation hearing tomorrow so that he may offer his own evidence. Do you see that?
Yeah.
It reads as though the decision was already taken to suspend FAIZAL before his interview.
Yeah, but suspension does not mean your question was whether there was a decision in mind to dismiss or no. But the suspension obviously is very logical at that case because I cannot bring FAIZAL in his critical position and investigate him officially about the wrongdoing, and then I keep him in the office. So that means it's very clear that, and we are sure that, or most likely, we will report, or the investigation committee will report the conclusion to the group, and this might take some time to make the final decision. So between that, we have to suspend him. So that was straightforward before the investigation committee.
On what basis was the decision to suspend him made?
That there is a wrongdoing, there is ongoing investigation, and this investigation will also be involving the group, and he cannot resume his duties normally at the office till this investigation is concluded with a decision.
And he cannot resume duties normally at the office until?
The conclusion of the investigation about the case.
Right. Now, there was a meeting on the 6th of May. If we look at page 251, we can see that what we call a minutes of meeting. Have you read these before?
Yes.
Okay. I understand you can't necessarily comment on what happened on that day, which is fine. But what I want to ask you about, as somebody on the investigation committee, is about the contents on page 254. Just tell me when you have that, please.
Okay.
There's a paragraph that begins with, the committee deliberated for a while. Then an agreement was reached to obtain testimonies from main parties directly involved in the incident under investigation, mainly Tariq Zain, Sami Yusuf, and then there's some emails here about their email addresses. Then it says, I informed Mustafa Abdul Malik before the start of my short vacation, and he explained that according to his knowledge, legal action against parties involved in the incident had been initiated by Sudatel, and I'm not required to communicate with them as Sudatel legal department already commenced the legal action. My question is this: when Ala Alub reported back to you, did Ala say to you that the intention was to obtain testimonies from Tariq Zain and Sami Yusuf?
Yes, when he shared that report, yes, he said that it's recommended by the committee to take the testimonies of the personnel involved in that.
Now, these two, it doesn't say that they're going to only take testimony from these two. It says mainly, so it sounds like it could be more than these two. An obvious example would be Tariq Ramatullah, wouldn't it?
To be honest, I cannot recall, but what's mentioned in the report is Tariq Zain and Sami Yusuf.
Okay, let's cut to the chase. Did you at any point suggest to the committee that there should be testimony obtained from Tariq Ramatullah?
No.
Did you do the same in respect of Tariq Zain?
Yes, we suggested, obviously, here in the report that we should ask Tariq Zain and Sami about their involvement in the case.
Okay, and did you do that?
When I basically spoke to the Sudatel group, they said that they are already taking legal actions against those guys, so they cannot call them and take their testimonials. And this now the whole issue will be managed and handled by the group.
So if I understood your answer, you're saying there was, because of legal action initiated by Sudatel, which I think you mean in Sudan, is that right?
Yes.
Or do you mean in the UAE? Okay.
No, at that time there was no case here in UAE.
Okay, fine. So because of legal action that was initiated by Sudatel in Sudan against Tariq Zain and Sami Yusuf, you couldn't speak to them.
Yeah, the thing is, we did not say we want to speak to them as EXPRESSO. We said that Sudatel Group and EXPRESSO as a one organization, as the next step is to basically speak to those guys involved in the case and ask them and validate what FAIZAL said.
But you say you didn't because of the legal action in Sudan. Is that right?
This was the response of the group.
Okay, and when did the legal action in Sudan conclude, if it has even concluded?
I don't have information about the case in Sudan.
Did you not follow up with Sudatel when the legal action would finish so that you can interview these individuals?
No, I did not.
So before the dismissal of FAIZAL, at no point did you go ask Sudatel what's going on with the legal proceedings? I need to speak to these two individuals and maybe more.
I was not asking specifically about the legal case in Sudan. And as I said, the whole matter then is being handled by the Sudan.
Just hang on. Before the dismissal, or let me row back a bit. In relation, who made the decision to dismiss FAIZAL?
The group.
When you say the group, you mean Sudatel?
Sudatel.
So you can't even give evidence as to the reasons for the dismissal. Is that right?
No, actually, because of the case of the whole case and because of the mistake in the procedures, the accounting and financial procedures, and his involvement, the group decided to dismiss him.
Hang on. You are employed by EXPRESSO, correct?
Yes.
You're not employed by Sudatel. Is that right?
Yes.
You are repeating.
As a legal entity, but as a business entity.
Hang on. Answer the questions, please. You are repeating, aren't you, the reasons given by Sudatel, a company you are not employed by, to give the reasons for dismissal. That's my understanding. Is that right?
It's, as I said, the dismissal is being taken once Sudatel decided to dismiss FAIZAL because of the events and the actions that happen within our own company in EXPRESSO. So it's not about something in Sudatel that I don't have visibility on. It's about the case that happened here in EXPRESSO.
My question is it's a bit more specific than that. EXPRESSO is saying that EXPRESSO dismissed FAIZAL, but you are now saying that Sudatel made the decision to dismiss FAIZAL. Is that right?
Sudatel, I don't know why I'm not getting the question. But by the way, the CEO of Sudatel is the CEO of EXPRESSO. Huh? So
no, that doesn't matter. Sorry, that doesn't matter. Let me ask the question again. My understanding.
I was not the one who made the decision to dismiss FAIZAL. If this is what you.
I understand that.
This is being taken by Sudatel Group Legal Department, Sudatel Group CEO, and he is the CEO of EXPRESSO Telecom Group.
Okay. Can you ever just actually before we do that, in these proceedings, who is giving instructions to the lawyers? Is it EXPRESSO or is it Sudatel?
It's a joint responsibility between Sudatel Legal Department and EXPRESSO Management, represented by me, and the CEO, Mr. Meet.
Okay, so that means you have some say in how these proceedings are being conducted, correct?
Yes.
So then let's look at the defense page 20, please. Actually, go to page 19.
Which page?
19.
Yeah.
This is paragraph 6 of the defense. It's a summary, but we've got C. Can you see the letter C?
Yes.
This is about the This is about the investigation meeting on the 6th of May, 21. And it said that the claimant, that's FAIZAL, didn't provide any justification for these actions. He says he was blindly following. There was an error in judgment. So moving on to the reason why I'm going through this is to give some context. Paragraph D, in the meantime, I think that means during suspension, the defendant continued to make investigations. So, pausing there, those investigations, just so we understand, doesn't include interviewing other individuals such as Sami Yusuf, Tariq Zain, and Tariq Ramatullah. Is that right?
You mean the investigation committee that's been formed in September 2021?
Yeah.
To my knowledge, no.
Okay.
But I was not part of it.
Well, you were part of the investigation committee, though, weren't you?
This is the investigation committee being formed at Sudatel level.
Right.
Our investigation committee was formed in May, and that was at EXPRESSO.
Yeah.
And it's concluded its job by that.
Do you understand that the reference to the defendant is EXPRESSO?
Yes.
So where it says the defendant continued to make investigations into the claimant's actions, and it refers to investigative committee, it looks as though it's saying the defendant's investigative committee. Do you see that?
Yes.
Right. Now you're saying, no, it's Sudatel that continued to make the investigation, and Sudatel's investigative committee did all of this. Is that right?
Yes, but we are wholly owned by Sudatel, and we are part of Sudatel at the end of the day. We are representing them, and we are reporting to them.
Okay. And then paragraph E. Just hold on one moment. Paragraph E is
Yes.
a reference to the Parker-Russell report. Not going to go into the detail of the report, but this paragraph says that the report was commissioned. There were certain details that came as a result of the report. And then F is the crucial point at paragraph 20. As a result of these findings, the defendant had no option but to terminate the claimant's employment immediately. But am I correct that it's not the defendant who had no option? It was Sudatel who decided
It is the defendant. It is the defendant because at the end of the day, we are part of Sudatel, and it's a joint responsibility as it's.
Are you able to give evidence to the court as to the decision-making process that took place in Sudatel?
At the level of Sudatel?
Yeah.
To the part that concerning EXPRESSO, yes.
Part concerning what?
EXPRESSO.
Right.
Sorry, did you want to ask something?
No.
Okay. Right. There were a number. There was the Parker-Russell report that was available to the investigative committee. I think there were some internal audits as well. Is that correct?
True.
It's also true that none of these reports were ever made available to FAIZAL. Is that right?
My knowledge, to be honest, till we suspend FAIZAL, no. When it's being disclosed, I'm not sure if this is being disclosed in the process of the disclosure that happened recently, but to my knowledge, no.
Just to clarify, when you say recently,
point.
when you say recently, you mean the court proceedings as opposed to prior to dismissal?
The court proceeding?
Yeah,
right?
let me clarify.
No, I'm talking about the current proceedings.
Yeah. What I mean is before FAIZAL was dismissed, none of these reports were made available to him at that time. Do you agree with that?
Through me, no. To my knowledge, no.
But surely you would have checked to make sure before you gave evidence today what has and hasn't happened.
To be honest, I'm talking about the facts and what I have seen and what I know.
Okay. Do you
But I
think
didn't check whether he received that or this document? No.
Ala Alou was the HR. Was he the HR director at the time?
He was not the HR. He used to be the HR director at that time. Yeah, he's already been transferred to Mauritania or subsidiary.
Yes. Do you know whether Mr. Alou was involved in FAIZAL's investigation up until dismissal?
Ala Alou was involved in the investigation up till the suspension.
Ah, so after suspension, he didn't have any more involvement?
No.
Okay. It's also correct, isn't it, that after FAIZAL was suspended, he was not invited back to comment any further by the investigative committee?
No.
When was Parker Russell instructed to carry out a report?
I don't recall the exact date, but maybe around September, October. That after the internal auditors came here to, took they started the investigation process and they came here, and then I think they mandated Parker Russell. So I think this is something around September, October, November 2020.
Okay, well, let's have a look at page 665 to see if this will put everything into context. This is an accounting report, excuse me, an internal audit accounting report. Sorry, I'm going to start again. I thought my voice was going to improve by today. It hasn't. This is by Sudatel. It's from the Internal Audit Office. It says an accounting report on financial violations in EXPRESSO Group, May 2017. Do you see that?
Yes.
Okay. This looks as though, although I can't tell from the English version nor necessarily from the Arabic version, but this looks as though it was received in May 2017. Is that correct?
No, I think if I go back to the Arabic version, I think they are referring to the date of the incident, not the date of the issuance of the report.
I see, but I mean, there isn't a date on this, even in the Arabic.
No, I don't see.
It's just if you've got the time. If you look at the Arabic version at 667, we can see the heading al-mawzu', which means subject, and then 2017 right at the end of that sentence, that of the heading. Those are the Arabic numbers for 2017. But that's it. It doesn't say when this report was issued.
No, it does not. It does not, because that's the date. If you look at the paragraph, which the last one is basically mentioning that paying amount of $4 million at the date of 1st of May 2017. So the date mentioned in the subject is referring to the date of the incident, not the issuance of the.
Looking at this now, do you remember when this was provided to EXPRESSO?
I think around the same time when they basically hired Parker Russell.
Right.
As I said, September, October, November, that time, 2021.
Well, you say 2021. I think you even said, just looking at your witness statement, your witness statement. Yeah, you say at paragraph 21 that you, let me give you a page number. The paragraph 21 of your first witness statement is on page 109. Do you see that?
Yeah.
So here you say our legal counsel at the time also appointed an external accounting company. Who are you referring to as your legal counsel? Do you mean Expressos or do you mean Sudotels?
We are managed as a legal, from a legal perspective, we are managed by Sudatel, so it's centralized function.
Yes, fair enough. When one reads paragraph 20 of your witness statement and paragraph 21, it looks as though that after FAIZAL was suspended, Sudatel took over the investigation. Is that right?
Yes.
And then, therefore, it looks as though Sudatel is the one that commissioned the Parker-Russell report. Is that right?
Yes. Yes.
And if one looks at your second witness statement at paragraph 17, page 132, just let me know when you have that.
Yeah, I do have it.
Okay. You say that it is correct that the transactions were not further investigated until 2021. And you say because prior to 21, the Sudatel management considered, I think you mean the individuals that were involved in the transactions, they would of course not conduct investigations into these withdrawals. Leaving aside the way it's written, it reads as though you tell me that the Parker-Russell report, so far as you're saying, was commissioned in 2021. Is that fair?
Yes.
But when one looks at the Parker-Russell report, just in terms of its commission date, sorry, just bear with me. That's at page 467. You have that?
467.
Yes,
yeah.
467. The date of the report is the 26th of September 2020. Yes?
Yeah.
Just double checking to make sure the Arabic was also, yes, the Arabic on page 481 reflects the same. It says the numbers 26, the word September is literally translated or literally written in the Arabic language, and 2020. Okay. So it looks as though, in fact, that the report was commissioned before the investigation took place. When I say an investigation meeting of FAIZAL.
If this is the date, yes.
But you didn't tell FAIZAL about the Parker-Russell report.
No, actually, I didn't see this report at that time. The first time I saw Parker-Russell report, that was in the time that I mentioned to you before, which is around late 2021, September 2021, October 2021.
And the
exactly
report,
when the group, when there was an action by the group to initiate a police case against the people involved in this case.
what was at the same time as the police case?
To be honest, I'm sure, I'm sorry because I'm not very precise in the dates, but as I said, around that September, October, or November 20.
No, I know, but what you said, this happened at the same time as the police case, but what happened at the same time as the police case?
The time that I have seen this report.
Right, okay.
That's why I was saying the report issued at that time, but because that's the first time I have seen that report.
Hmm. And even though on page 468, the report says it is directed to EXPRESSO, am I right that in fact the instructions were given by Sudatel?
The instruction to issue the report.
Yes.
Yeah.
By Sudatel.
Yeah.
Am I also right that you cannot say exactly what was and what was not readily available to Sudatel when it made its decision to dismiss FAIZAL?
Can you repeat the question again?
Yeah, you're not able to tell us what the decision makers at Sudatel had in front of them, what material they considered when they made the decision to dismiss.
I was not aware.
No.
I cannot say what was in front of them to make that decision.
No. Do you know why nobody from Sudatel is giving evidence?
No, I don't know.
I want to ask you about your paragraph 6 of your first witness statement, which is at page 106 of the bundle.
Yeah.
You have outlined a payment procedure here.
Yeah.
My understanding is that you have not worked in accounts, is that right?
No, I didn't.
So the evidence you give here is simply based on some documents put in front of you, is that right?
No, I'm part of the authorization matrix for payments in Sudatel in EXPRESSO here in Dubai because I'm the one who is responsible of the company. So any payment is being made by the office. I'm part of that process, so I have the knowledge of that process.
Yes, but you're giving evidence here in paragraph 6 with reference to documents.
In paragraph 6.
Yeah.
Yes. So we have, as I said, we have the documents and we have the practice as well. It's not just based on the document. I'm practicing that with my financial director as well.
But you haven't explained in any of your witness statements the procedure when a request is made from Sudatel of EXPRESSO to get cash together and to be sent over to Sudatel.
I haven't explained the
that
procedure
process.
when Sudatel. Look, for me, it's no different. It's Sudatel or a third-party payment. Is at the end of the day, for me as Mustafa, as like responsible of Dubai, I have to receive from Sudatel instruction with the purpose of the payment. And when the money handed over to a third party or Sudatel staff, I have to receive a recipient note from the person who is being appointed by Sudatel to receive the money.
And you're relying on which document to come to that conclusion?
This is the practice, and this is basically plus the authorization metrics that I have, and this is the standard practice that we do.
Can I ask a question here, please,
Yes.
Mr. Abdul Malik? In paragraph 5,
Yeah.
you say Mr. MOORKATH was fired because he failed to follow the correct company procedures in making payments in 2016 and 2017. And then in paragraph 6, you say EXPRESSO implements the following payment procedure. Where you say in paragraph 6, EXPRESSO implements the following payment procedure, are you referring to the payment procedure in 2016 and 2017, or when?
Actually, to be very honest, I'm referring to the practice that we are doing.
You're referring to what?
To the practice that we are doing, the standard practice.
But when?
I was involved in, as a responsibility, I was involved in the payments since 2020. This is the first time I came to know this is the procedure and this is the standard.
So in 2016 and 17, you were the director of strategy, were you?
Yes.
And you didn't have involvement in the payments at that time?
No.
Oh, you shook your head just for the transcript. The answer is no, is it?
Yeah, it is.
I say that, Mr. Abdul Malik, because you see, we're recording what is being said. And of course, the recording can't pick up you shaking your head.
Okay, noted.
All right. Thank you for that. Thank you for that, Mr. Abdul Malik.
Thank you, Sajid. Thank you.
Yes, thank you. So just to clarify, you're referring to the standard. I think the words you used was standard practice from 2020, based on your experience from 2020.
Yeah.
You're not dealing with the rare occasion when Sudatel would require money to be gathered by EXPRESSO for use by Sudatel.
Since I took over, I don't remember since I took over that there was a request for such amount of cash or a payment to Sudatel.
So that's not the question.
That niche.
That's not the question. The question is that you're not in this payment procedure is not dealing with those let's just say unusual situations where Sudatel would ask EXPRESSO to gather cash or money to be sent over for its use.
For me, the procedure does not have any unusual payment. It's a corporate at the end of the day. Any payment has to follow a standard procedure where the nature is the payment is there, the recipient is there, and this recipient is the correct assigned recipient by the payer. So for me, there is no unusual payment, to be honest.
Well, there was no, other than obviously we know what we know about the Parker Russell, and I don't know if you heard the exchange at the beginning about what we can and cannot use that report for, but other than put that report to one side, there is no other evidence from an accountant or anything to show what was the correct procedure to be utilized when Sudatel made the request for money in the way it did in 2016 and 2017.
Actually, there is a procedure basically approved by the board of Sudatel. I didn't read it in details because it's not my job. But when I'm speaking about the procedure here, I'm speaking about something that I'm practicing on a daily basis since 2020. So this is the procedure I follow. I am being audited as a publicly owned company. And always it's the case that any payment has to have this set of document and has to have this process.
But on a daily basis, you're not being confronted with a situation where an instruction is received from Sudatel to send cash over.
No.
No. Now, dealing with the 2017 transaction, it's also correct to say that you didn't interview or speak with FAIZAL about the 2017 transaction. Is that right?
No.
It's also correct that you have not interviewed any witness or any individual other than FAIZAL in relation to the 2017 transaction.
Is correct.
And the only time that the first time that the 2017 transaction was mentioned to FAIZAL was in the dismissal letter. Is that right?
Through me, I didn't spoke to FAIZAL about 2017 case.
Yeah, but even in the dismissal letter, it doesn't. You had to figure it out. So why don't we look at page 287, just so I'm not being unfair to you.
Page, which page?
287.
It's yeah.
This is the 23rd of March 2022 dismissal letter.
Yeah.
I don't like reading out documents, but I think this one's quite an important one, Your Honor. So if Your Honor wouldn't mind. Dear FAIZAL, this letter is to inform you that your employment with EXPRESSO as corporate finance director will end as of 23rd of March. The decision is following this decision is following the action taken by EXPRESSO to suspend your employment, communicated to you on the 6th of May with immediate effect, due to the allegation or involvement with others in a financial wrongdoing during the period of May to June 2016. Next, based on internal investigations and the reports of the internal auditor and the chartered accountant, just pausing there, the reference to the chartered accountant here is the Parker Russell, is that right? You're nodding, but you do need to answer.
What was the question? Sorry, I was just reading the.
Okay, the reference to the words the chartered accountant. That's a reference to the Parker Russell report. Is that correct?
Yes, it is correct.
Okay. So based on internal investigations and the reports of the internal auditor and the chartered accountant, you and others caused the squandering and wasting of $2 million and exposing the company to the loss of the above amount. For this reason, a criminal complaint was opened against you, and that's the reference number.
Yeah.
Next line, next paragraph. The above mentioned is sufficient cause under DIFC rules to terminate your contract of service. Accordingly, this is deemed as a termination for cause, and then the rest of it doesn't matter. There is a reference to $2 million. I accept that. But do you agree there is not even an express reference to the 2017 transaction in this letter?
If you refer to the financial wrongdoing during period of May, June 2016, yes, there is no reference for the period of 2017.
No. We've now seen that there's a reference to a criminal complaint, and I think fairly you also mentioned earlier that in late 2021, I think you said, there was a police case that was opened.
Yeah.
And this police case is in the UAE. Is that the one you're referring to?
Yes.
The referral to the police, was that made by Sudatel or was that by EXPRESSO?
That was meant by EXPRESSO.
EXPRESSO. And obviously from the way you've given evidence today, EXPRESSO and Sudatel are, sounds to me like they're one and the same for the purposes of this investigation. Is that right?
But they have a different visibility level. I mean, the case is here in UAE and in Sudan as well, because it's involved the management in Sudan at that time.
I understand, but I thought you were saying earlier that maybe I misunderstood. But I thought you were saying earlier that they were both making that they are considered the same only in terms of this investigation. So the decisions taken, they're effectively the same.
Yes.
So the decision taken to refer the matter to the public prosecutor in Dubai is a decision that was taken by Sudatel.
And EXPRESSO jointly.
All right, and EXPRESSO jointly. Before, no, do you recall when exactly the matter was referred to the public prosecutor?
The public prosecutor, no. As I said, around that time.
Okay. So it's at some point in September, October 2021, from what you're saying.
If I remember well.
Okay. So certainly when FAIZAL was suspended, he wasn't subject to a police complaint. It was many months later. Is that right?
No, actually, you reminded me now. No, that's mean the police case was before the. No, the suspension, yes.
Suspension was before the police.
Yeah. The termination I was talking about the termination.
Yeah. When FAIZAL was investigated, let's just ask, let me ask you from perspective of EXPRESSO. When FAIZAL was investigated, was EXPRESSO considering these transactions as potentially fraudulent?
When we investigated FAIZAL?
Yeah.
Yes.
And did Sudatel have the same view?
Actually, Sudatel is the one who basically asked us to do the investigation because they are the one who is suspecting that there is fraudulent in this case.
Okay, understand. So it starts off from Sudatel asking EXPRESSO to investigate because they suspect that fraud has taken place.
Sure.
And the suspicion was that FAIZAL was involved, correct?
Yes, correct.
That suspicion continued throughout the rest of 2021, including when the referral was made to the public prosecutor. Is that right?
Yes.
The decision to dismiss FAIZAL was made before the public prosecutor made its decision. Is that right?
To be honest, I do not remember the sequence of the time.
If you bear with me 1 moment. So if you look at page 305,
yeah.
Have you seen this letter? This is if you need the original, it's on 307. It's a letter from the public prosecutor.
Yeah.
Have you seen this before?
Yes.
Okay. Whichever you prefer in terms of the Arabic or the English, but the date is the same in both versions, 24th of August 2022.
Yeah.
As I say, it's a letter from the public prosecutor, and it is to, it states that the public prosecutor in Dubai issued an order that there is no reason to file a criminal complaint, criminal case versus the aforementioned accused, which is FAIZAL. And so the search order for him should be stopped and his name should be removed from the travel ban. Yep.
Yes.
This is the date upon which the referral to the police, the public prosecutor, concluded. This is the date that they said the investigation is over. Is that right?
Yes.
And so then it follows, does it not, that the decision to dismiss FAIZAL took place before the public prosecutor made its decision on the criminal complaint. Is that right?
The decision to dismiss FAIZAL made before the decision of public prosecutor. This is what you mean?
Yes.
I did not have, actually, we did not have any decision. The moment that I received the decision to terminate FAIZAL was in March 2023.
Yes,
sorry,
that's my point. Yes, that's my point.
Yeah.
The decision was taken in March 2022 to dismiss FAIZAL, but that was made before the police actually came back with an answer.
Yeah, you're right. Yeah.
Yes. So if you go back to the dismissal letter, page 287.
What was the page number?
287.
Yeah.
So we've got the reference to the allegation of financial wrongdoing, and the wasting of $2 million, sorry, the squandering and wasting of $2 million, which gave rise to the criminal complaint. Do I have this correct, based on the evidence you've given today, that the decision taken to dismiss FAIZAL was based on the suspicion that Sudafed and EXPRESSO had that FAIZAL was involved in a fraud?
Yes, plus that there is that FAIZAL did not do his duty of care in terms of performing the right payment procedure. So as EXPRESSO, for us, it was clear that the payment procedure was not followed properly. And that payment procedure, even if the money is not lost, is risking the money of the company. So there is a procedural issue. And on top of that, there is a suspicion of the losses of the 2 million. So in my opinion, and this is how I thought about it, and this is how the decision is being made, that at any point, it's not related to the loss of the 2 million. There is a layer before that, which is basically the wrongdoing in the procedures of basically practicing the payment.
Okay. I want to move topics, please. Sanctions. Do you agree that the Sudan was under sanction by the United States at the time of 2016 and 2017?
Unfortunately, yes. Yes.
Okay, sure. But fine, we don't need to look into that any further. Sorry, I'm just looking through my notes. That's why I'm pausing.
That's all right, Mr. Cashel.
Yes. What action, if anything, has been taken against Tariq Ramatallah in respect of the 2016 and 2017 transaction?
When this happened, Tariq was already terminated from the company. And then he had a legal case with the company. I think that there was a counter claim as well in that case. But if I recall, well, this is the first action with specifically for this incident. It's being taken against Tariq Rahmatullah, which is basically the police case in UAE.
But has there been a civil claim against Tariq Ramatallah for the $2 million?
I cannot remember. I don't think so. I think that the only claim is through the police case here in UAE.
Mr. Abdul Malik, you made reference to a case and a counterclaim. What were you referring to?
I think that was a different case for Tariq Rahmatullah, because Tariq Rahmatullah, when he's being terminated by the company, he had a case against the company. Then there was a counterclaim by the company as well. So that was a separate incident. But the point I'm making is, at that time of uncovering this case with FAIZAL, Tariq already by that time left the company.
Just to be clear, I don't. The case with Tariq Ramatallah, there wasn't a claim against Tariq for the $2 million, was there? My understanding was that was for some company.
That was different.
Yeah.
That was
something completely different. It was about money being taken from a side business or something like that. Anyway, we don't need to get into the details. The point is,
you're right.
You're right. Yeah. So no civil claim against Tariq. Sami Yusuf, any civil claim against him for the $2 million?
To my knowledge,
no. And the same goes for Tariq Zain. Tariq Zain.
What do you mean by the same goes?
Okay, sorry. There's not been any civil claim against Tariq Zain for the $2 million, has there?
No, I think Tariq Zain, Tariq Rahmatullah, FAIZAL, and the fourth person who received the money, the case here in UAE were against them.
Yeah, you're talking about the public prosecutor case.
Yeah.
No, I mean, so you know, in these proceedings, there is a claim against FAIZAL for $2 million.
Yeah.
No such claim has been made against any of the other individuals.
Yeah, the claim is not for FAIZAL. I think the claim is as FAIZAL part of the group of the people involved in that.
I don't understand that. FAIZAL is the only individual litigant in these proceedings.
In the to be honest, because I'm not familiar with the proceedings terminology, but as far as I know, the police case in the public prosecutor was against FAIZAL and 3 other people.
I don't want to go back. I don't want to have to keep going over this, but you said earlier that you were giving instructions for the defense document. As part of that document, there's a counterclaim, and in that counterclaim, there's a claim for the $2 million. So presumably, you know that there is a claim against FAIZAL for $2 million.
Yes.
And no such other claim has been made against other people whom you would say were responsible.
No.
But you do think that others are responsible, don't you?
Because of the facts that we received from the group, and because the police case is being opened against all of them. So that's mean they are involved.
But yet you want, if I understand this correctly, you're asking FAIZAL to pay for the $2 million to cover the entire loss when you think that 4 people are responsible. Is that right?
I was not the one who asked. Should have done an EXPRESSO Telecom group.
Okay. I mean, all right, Your Honor, I think we can deal with this later in submissions. You also brought a police claim against Awad Ala Khalaf. Is that right?
Yes.
Did you have his Emirates ID? I think it's in the bundle, if I'm not mistaken, at page. It should be. Well, it should be in the bundle. Oh, I know. I'm looking at the wrong section. Sorry. It should be under request to produce, and at page 574. Have a look at 574.
Yeah.
Let me know when you've got it, please. Do you have it?
Yes, I do.
This is the Emirates ID, is it, for Awad Ala Khalaf?
Yes, it is.
There was a police complaint opened against him, right?
Yes.
But again, no civil claim has been brought against Awad Khalaf in the DIFC courts or any other courts. Is that right?
Yeah, that's right.
As in, yes, I'm right. Yes.
Yeah.
This document, whilst we're on it, sorry, I know we're jumping slightly, but this document has been produced to suggest that this is a delivery note, correct?
Yes, it is.
But it hasn't been translated. Is that right?
To be honest, I'm not sure, but I did not see a translation for it.
No, but you produced it, didn't you?
Yeah, I did.
When did you have this document in your custody, control, or possession?
That was March 2021.
From March 2021, that's been with you. Why was it not translated?
Not sure, to be honest.
Okay. Right. Sorry, I'm just navigating. Paragraph 16 of your second witness statement, please. So that's at page 132.
Yeah.
Yeah.
Yes.
Just hold on, sorry. Just my screen. Yeah, so you say there, at paragraph 16, as set out in paragraph 16, the public prosecutor in Sudatel conducted various investigations into these withdrawals, where it was evidence that the funds were not properly used and were lost to the company. What do you mean by paragraphs, your reference to paragraph 16?
As set out in paragraph 16.
I can tell you it's not
I think it's a typo. I think it's 15, yeah.
Right, okay. Do you mean the 50, as in 15 above?
Should be investigations are also ongoing to the public security. No, I think it's referring to another paragraph, but it's a typo error.
Okay. Do you know which paragraph? It would look like it should be paragraph 15, but if you're saying it's not, then just help us.
Before the public security, also before such an item by the service transfer. Yeah, I think I'm referring to 15.
Okay, fine.
I'm just referring to the fact that there is ongoing investigation by Sudatel, and they deem that this money were not used properly. That's why they basically triggered the whole investigation.
Yes, but from looking at paragraph 16, do you now accept that because the public prosecutor has decided there's no case, you can't say that there is evidence from the prosecutor to show that the funds were not properly used? Do you agree with that?
No, that's the public prosecutor, I think, in Sudan.
Right, but there is no documentary evidence that you have provided in relation to the Sudan proceedings, is there?
Yeah, it's not in my custody. It's not my authority as well. Basically instructed by Sudatel, and I basically received from Sudatel.
Okay. I want to ask you about the use of the money itself. So can we look at page 240?
Yeah.
We've looked at the court has looked at this earlier, but this is a letter written by, I think it's by Sudatel. Yeah, by Sudatel. And there are a number of board resolutions taken. Have you read this document before? You haven't? Do you know if the investigation committee looked at this document?
At Sudatel level?
Let's talk about EXPRESSO level first.
At EXPRESSO level, no.
And Sudatel level, I suppose you can't say, can you?
I can't say, yeah.
No. All right. Is this are these proceedings the first time that you are seeing this board resolution?
Yes.
Do you agree with me as a proposition, given that you were part of the investigative committee, that had there been an invitation, a further invitation to Sudatel, had there been a further invitation given to FAIZAL to attend for another interview after all the information and reports had been gathered properly, for him to explain and present his evidence to the committee, that this could have been one of those documents he could have produced?
If he's being called for another interview or investigation.
Yeah.
Yeah, probably yes. To be honest, I don't know if he, if he had when he had these documents.
Yeah.
But probably any chance to be interviewed again, he will put forward whatever basically can clear his side.
Looking back now, do you think it would have been a better idea to interview him again?
Look, it's I'm here just to respond on the facts, not to give my opinion personally. Right. My opinion is the opinion of the company.
Fair enough. Does EXPRESSO have any insurance policies to cover for any employee negligence?
Come for employee what?
Does EXPRESSO have any insurance policy to cover for employee negligence?
To my knowledge, no.
Okay. Do you know if it also exists or does not exist at the Sudatel level?
I don't know. I cannot say.
Okay. After FAIZAL was dismissed, he sent a letter. He sent an email by Gmail. Do you recall that?
Yes.
Yeah, that's that. It's at page 288. Yes, you have that?
Yeah.
Was that sent to you as well? I think that's you as Mustafa, but I'm not sure.
Yes, that's
yeah, okay. Am I right that neither you or anybody else responded to this email?
Neither me or who?
Or anybody else?
No, I think Mr. Malla, the legal department, has responded to that official letter.
In these proceedings, the DIFC court's proceedings, are you the main person who is dealing with the production of documents from EXPRESSO's side?
As a focal point, yes.
But so you would agree that you have not provided any documents showing the response given to this email?
There is, we received 2 emails from FAIZAL. One is this one, which is, I think it's March. Then we had actually, we had 3, March, May, and September. Yes. I remember that our legal department has responded to him at least once. I'm not sure, to be honest. I'm not sure, but I have seen a response from our legal department for his emails.
Well, there's no dispute between us that HFW acting for EXPRESSO responded to the second correspondence from FAIZAL, and in relation to the third and final correspondence from FAIZAL, there was a letter from EXPRESSO. So that one's at page 301. Do you want to look at it? 301?
Easy.
Yeah.
01. Yes,
Yeah. Is that the letter you're referring to?
this is the letter I'm referring to.
So that letter came, I think it was the 6th of October, 10th of October, 2022. Yes?
Yes, as the date is suggested.
Yeah, good. Prior to this letter being sent by EXPRESSO, FAIZAL at least twice has asked for his visa to be cancelled, didn't he?
He asked for his visa cancelled twice in the letters that he sent. Yeah. But should I answer further? Or?
Well, you probably will in due course when I ask, but just hold on because there may be a context.
We received the visa cancellation, but it was always in relation to the benefits of
it was, sorry, sir, I didn't hear that last bit.
We did not receive a visa cancellation standalone request at all. It was always that he is claiming the benefits, the due employment of services and cancellation of the visa.
Okay, fine. The response by HFW at 2293 you have that. Were you involved in the? I know the lawyers wrote it and they sent it, but they would have done it on instructions. Were you the one giving instructions, or somebody else giving instructions from EXPRESSO?
Yes, we were basically the one who gave the instruction to the lawyers.
Who's we? I just want to understand. I'm asking the right questions.
EXPRESSO money.
Which includes yourself.
It's including myself.
Okay. Now, in this letter, there is nothing said about the visa. Why is that?
I'm not sure.
Well, you give evidence that there was a request made of FAIZAL on the 28th of September 2022 that he cancel his family's visa. Do you recall that?
A request from FAIZAL to us or from us to FAIZAL?
You have given evidence at paragraph 26 of your first witness statement. Sorry, was it first witness statement? I think it was. Just hold on one moment. Yeah, paragraph 31 of your first witness statement.
Which page?
Yeah. Just 1 second. Page 110.
Yeah.
So you've given evidence here saying that you asked your colleague to email FAIZAL on the 28th, urging him to initiate the process for cancelling the visa.
True.
But this email came months and months after his dismissal.
Yes.
Is that right? Yeah, that's 6 months. Maybe, yeah, just a few days over 6 months after he was dismissed.
Yes.
And when he sent what I'm calling the first legal notice, but it's the second of his 3 correspondences, when HFW replied on instructions from EXPRESSO, nothing was said about the visa. Why is that?
Honestly, I really don't know why.
Well, why didn't somebody from EXPRESSO email sooner to say, look, FAIZAL, you need to cancel your family's visa?
To be honest, for us here in EXPRESSO, we received, this entire case at that time, we received the instructions from the legal department of Sudatel, and nobody asked us or instructed us to basically cancel his visa.
So that's the only reason, because you weren't asked by Sudatel or you weren't given instructions, you didn't cancel the visa. Is that right?
I don't. Yeah, it's not in my authority to cancel this visa. So I have to be instructed.
And the instruction comes from Sudatel.
Sure.
But did you chase Sudatel to say, look, we need to cancel this visa?
Yes, I asked for what are the next steps in terms of visa cancellation and subsequent procedures. And what I have received from Sudatel that visa is on hold, visa cancellation is on hold, and you proceed with the termination.
If you look at paragraph 33 of your witness statement, page 111.
111.
Yeah.
Yeah.
You're saying, you say there, it cannot be denied that FAIZAL benefited from having his visa kept open and was not in a rush to have it cancelled. But it sounds like you are trying to say that because his visa wasn't cancelled because it suited him. It suited FAIZAL. Is that what you're saying?
Yeah, as I said, the visa is not cancelled. This visa cancellation is part of the subsequent procedure for the termination. This specific action is being on hold, waiting for the instruction from Sudatel.
All right. Just looking through my notes just to check if there's anything else. Yeah, just a few more things. Just going back in time. So I know you. I don't know if you were you were listening into the proceedings yesterday. Were you, or were you offline?
No, it wasn't.
You weren't. Okay. Well, FAIZAL says that he was the only person effectively in the accountancy department. Does that accord with your understanding, or can you not
Yes,
say?
it's true. It's
So,
true.
okay. I think you said that you joined the company in 2015. I take it that you probably won't be too familiar with what happened or didn't happen before 2015. Is that fair?
I was familiar with what happened before that.
I take it that you are not familiar with what happened before 2015.
Yeah.
Okay, all right. Well, then I won't ask you about that. Okay, thank you. No, I don't have anything further.
All right, well, thank you, Mr. Costello. Mr. Doherty, do you re-examine?
I will very briefly, well, I hope very briefly, on a couple of points. Mr. Abdul Malik, I think you were asked right at the beginning of my learned friend's questions around Mr. Rahimtallah about whether or not approaches were made to him to interview him as part of your investigation of FAIZAL. Could I ask you to have a look in the bundle of documents at page 958, please?
950?
958. In fact, it might help you if you can go to 955 first of all, so you can see the context of this.
Yes.
So you should see there's a DIFC court. This is a judgment. I'm not going to ask you questions about the law in this case, but you can see at the top we've got claimant, Tariq Rahimtallah, defendant, EXPRESSO Telecom Group. And if you go forward to page 958, at paragraph 7, there's a sub-paragraph within that which is subparagraph 5. And it says, on 28th of April 2020, TR received a termination of employment letter from ETG, the termination letter. Do you see that?
Paragraph.
So that's the subparagraph 5 at the bottom of this page.
Okay,
so it says,
I can see.
On 28th of April 2020, TR, so that's Mr. Rahimtallah, received a termination of employment letter. Do you see that sentence?
I can see it.
Yeah. So the investigations and the issues against the claimant in this case, Mr. MOORKATH, those arise, as we understand, from March 2021 onwards. At the time those investigations arose, was Mr. Rahimtallah still an employee of EXPRESSO?
No, he was not.
If we can go forward to page 976 within this same document. You had explained in your evidence that earlier you referred to the fact that Mr. Rahimtallah had been involved in separate proceedings. You referred to a claim and a counterclaim. If you look at paragraph 101, you'll see it says ETG's counterclaim. And the sentence says, for the reasons already given, ETG's counterclaim succeeds in the following amount. And then you'll see breach of fiduciary duty, $71,000.
Yeah.
When you referred to the counterclaim earlier, was that a reference to this counterclaim against Mr. Rahimtallah for breach of fiduciary duty?
Yes.
And again, I think you said this, but perhaps this is just for clarification. So this was, in effect, to do with some form of financial mismanagement or wrongdoing, but it's not connected to the facts of this case.
Yeah, it's not connected to this case.
It's events that predate your discovery of the facts of this case. Is that right?
Yeah.
Yeah. If we go then to page 251. This is an extract from the interview transcript with FAIZAL with Mr. MOORKATH. And if you look towards the bottom half of this page, there's it's a recording of what's being said by Abdeen, starting with a sentence pointed out to the legal action being taken. Do you see that?
Yes.
So 9 lines up to the bottom, it says pointed out to the legal action being taken against the former Group Executive President and the Deputy Executive for Finance, requested to concentrate on FAIZAL and that he failed to follow the correct payment procedure. So looking at the context of that, when there's a reference to the former Group Executive President and Deputy Executive, at the time the investigation in relation to Mr. MOORKATH is taking place, are those individuals still employees either of EXPRESSO or Sudatel?
No, they were not.
And this statement, I mean, you can tell me if you can't answer this, the request to concentrate on FAIZAL, did you understand in that context, it's to mean that FAIZAL is someone who is still employed?
Yes.
If there are a number of former employees against whom legal action is being taken, would there have been any way that you, as a representative of EXPRESSO, could have made those individuals attend an interview with you?
As an EXPRESSO, I cannot, as the issue is being dealt with it at Sudatel level.
Okay. One final short question. I think that there was some questions asked of you around the Parker-Russell report and your recollection of the dating of that. And I just wanted to ask if you could turn up page 470, first of all.
Yes.
Now, I had understood in your evidence, you said you didn't recall exactly, but you thought that this report was sort of commissioned or produced sometime around September or October 2021. Please correct me if I've misheard you.
Yeah.
If you look at page 470, right at the top of the page, you can see it says scope of the mandate as mandated to us on the 19th of September 2021 by EXPRESSO Telecom Group. Do you see that?
Yeah. Yeah.
If you go over the page to 471.
Yes.
If you look at the bottom paragraph here, so it's under the section saying fourth, the basis and steps we've taken to implement the mandate. It starts on the 19th of September 2021. Yeah. The consultative expert moved to the headquarters of EXPRESSO Telecom Group. Do you see that?
Yes.
I was just wondering whether those extracts help you with the dating of this Parker-Russell investigation and report.
Actually, yeah, it's to be honest, as I recall, the Parker-Russell and the investigation activities being taken around that time. I was surprised when I saw that date, but my assumption that is I have just seen these reports at that time. That's why I'm under the impression that these reports being generated at that time. And I remember very well that those dates, because those are the days when the internal auditors of Sudatel Group arrived here in Dubai, and they did the investigation activities here in our offices.
Yeah. So they appear to be in your offices after the suspension takes place, but before the termination takes place.
Yes.
Okay. That's everything from my side, Your Honour. Thank you very much, Mr. Abdul Malik.
There's just one matter that I want to try and clear up before Mr. Abdul Malik leaves us. When Mr. Kostel was asking some questions to Mr. Abdul Malik, they both referred to the investigation report. Is it common ground what the investigation report is? No. All right, then I want to ask Mr. Abdul Malik, you referred to the investigation report. What was the investigation report?
When in what point I refer to that investigation report, you mean the one that is being taken by investigation committee here in EXPRESSO?
I'm sorry, say again. Well, I'm asking you, what investigation report was there?
The one I referred to you to it in my I was referring to the investigation report generated by the investigation committee within EXPRESSO that interviewed FAIZAL on 6th of May 2021.
Oh, so it's the document. Mr. Kostel or Mr. Doherty might be able to help me. What page do you know is that report that has the interview?
It's not. The interview is on page
251 will land you somewhere in the middle of it.
Yeah.
Sorry, what was it?
251. It begins at 250 actually.
250. Yeah, 250.
Emails. It actually appears twice in the bundle. I think there's a different version of it.
You see the document there, Mr. Abdul Malik, and you've been taken to this document, and you've been asked about parts of it, and it also has then some minutes of the meeting. Is that what you're referring to as the investigation report?
I cannot really remember which, because there are multiple investigation reports. So to my knowledge, this is the investigation report that I was involved in, and it's being produced by the investigation committee here in UAE. There is investigation report that's being produced by internal auditors of Sudatel as well. And then there is the third party or the external audit report issued by Parker Russell.
So there was also an investigation report by Sudatel, but that's not been produced to the court. Is that right?
Your Honor,
No, I think it's here. I have seen it.
Oh,
I have seen it.
I think it was referred to during evidence, but the context might be different. Certainly from the defendant's perspective, what is being referred to there, as I understand, is the document at 665.
Well, let's have a look at that. Mr. Abdul Malik can tell us if that's what he's talking about. 665. All right. Do you see that one, Mr. Abdul Malik?
Yes. So this is the one generated by the head of the internal audit department of Sudatel.
So that's what you were referring to as the Sudatel.
Yes,
Right.
this is the Sudatel investigation.
All right. Well, thank you for that. Is there anything arising out of those questions for either of you? No, thank you. Well, Mr. Abdul Malik, that completes your evidence. You are now discharged as a witness, but you're free to remain online and observe and listen to the proceedings if you wish.
Thank you so much.
All right, but you may now close your camera and please put yourself on mute.
Thank you.
All right, Mr. Doherty, you have another witness. Oh, you're on mute, Mr. Doherty.
Quite right. We have Mr. Aloob. I don't know if Your Honour was minded to take a break at some point, but it might be that if people feel the need to have 5 minutes, we can do that now and get Mr. Aloob set up and ready to go.
Well, I intended to take a break, depending on how long, of 15 or 20 minutes after we've completed the evidence and before we do the submissions. But if anybody needs, as it were, a 5-minute comfort break at this stage, we can do that. I don't hear anybody asking for it, so I think we'll continue on. We'll complete the evidence and then we'll take a break.
Certainly. Let me just check my instructing solicitors. Yeah. I think Mr. Aloob appears to be on the call.
All right.
Yes.
Well, I'll ask the court officer to swear him in. Yes, Ms. Norton.
Thank you, Justice Lemiere. Good afternoon, Mr. Aloob. Mr. Aloob, I understand that today you wish to give your evidence by swearing on the Holy Book. Is that correct?
Yes, correct.
And do you have a copy of the Holy Book with you?
Yes.
Thank you. Mr. Aloob, can you please confirm your full name and your occupation for the benefit of the court?
My name is Ala Hassan Muhammad Hamad Aloob. My current position is the Director of Quality and Compliance at Shingitel, Mauritania, which is part of Sudatel Group. And previously, I was the HR Director at EXPRESSO Telecom.
Thank you. And if you can please repeat after me, I swear by the Almighty God.
I swear by Almighty God.
To tell the truth.
To tell the truth.
The whole truth.
The whole truth.
And nothing but the truth.
Nothing but the truth.
Thank you, Mr. Aloob.
Thank you.
Ms. Norton. Yes, Mr. Doherty. You're on mute, Mr. Doherty.
Quite right. Twice in a row. There we go. Afternoon, evening. I'm not sure what time it is where you are, Mr. Aloob, but whichever of those apply. Can I ask you please to turn up page 112 of the bundle? Well, hopefully you should have a bundle of documents available to you.
212.
Yeah, 112. 112.
112. Yes.
Hopefully there you should find a document that says First Witness Statement of Ala Aloob.
Yes.
So is this the witness statement that you've prepared in the course of these proceedings?
Yes.
It runs to 12 paragraphs ending at page 114, if you can go there.
114, yes.
And at the bottom of that page, you should see a signature. Can I just ask you to confirm, is that your signature?
Yes.
And can you confirm the contents of this statement are true to the best of your knowledge and belief?
Yes, I do.
Thank you, Mr. Alub.
Thank
All
you.
right, well, thank you. I will take as read the first witness statement of Ala Alub and receive it in evidence together with the exhibits referred to in the course of the statement. All right, now, Mr. Ala Alub, Mr. Kostel, who is the counsel for the claimant, Mr. FAIZAL MOORKATH in this case, he is going to ask you some questions. Mr. Kostel.
Thank you. Good afternoon, Mr. Alub.
Good afternoon.
When were you employed by EXPRESSO?
I started working for EXPRESSO in April 2008.
Oh, okay. So you started in 2008. I think you were there until the 31st of December 2019. You say you were director of HR. Did you change roles or any before you moved on to Chingatel, Mauritania, or did you move straight over?
Well, actually, the actual relocation was for the same title, but after I reached here, it was changed to quality and compliance.
Right. And was that after the 31st of December 2019?
The start was, I think, January 1st, 2020.
Yeah. So when it came to the investigation of FAIZAL MOORKATH, it doesn't sound like you were, well, you clarify. Were you still working in HR, or were you fully part of the quality and compliance team?
No, at that time, I was already the head of quality and compliance in Chingatel, no longer the HR director of EXPRESSO, but based, I believe, on my previous experience and the fact that I started with EXPRESSO from the actual launch of the office in DIFC in 2008, Mustafa asked me to organize an investigation committee based on my experience in that area, and definitely I had to comply or to help him, to assist him.
At the time that you were asked to form an investigation committee, was there a HR director?
No.
Oh, right, okay. So it seems as though maybe that's why you were asked, because
Exactly.
there wasn't a HR director.
Yeah.
Fine. Even though you were not, strictly speaking, head of HR at the time, but you were performing HR's functions, did you have access to employees' records at the time of FAIZAL's investigation?
I'm sure if it was part of the investigation, yes.
Well, your role was to form the investigation committee.
Yes.
Correct. What
Yes.
was part of that role? What comprised that role?
Well, basically, in terms of conducting an investigation, first of all, we had to make sure that it is fair and to try and look at the incidents and all the actions taken by all the people involved in the investigation or being subject by the investigation. And in terms of the role of the director of finance or the head of finance, FAIZAL, it was also important to look at his fiduciary relationship to the company and his duty of care to make sure that he fulfills his role while in any transaction on behalf of EXPRESSO or the group as a whole.
My understanding is that also there was an investigation into a suspected fraud committed by FAIZAL. Is that right?
Is it considered called fraud? I don't think it was. I'm not sure if we use that term.
Okay, but any financial wrongdoing in terms of a criminal nature?
Financial wrongdoing, yes. I would say financial wrongdoing.
Okay, but you wouldn't go so far as to say of a criminal nature, or you would?
Well, actually, the minute that we started the investigation, since I wasn't part of EXPRESSO at the time, but based on the progress of the investigation, it became very clear that this involves other high executives in the company or in the group as a whole, and therefore our recommendation was to summon them or to make them part of the investigation before we can proceed.
Is that a decision that was taken after FAIZAL's interview on the 6th of May 2021?
Exactly, yes.
So when you say high executives, is that when you're referring to, is that you referring to Tariq Ramatallah, Tariq Zain, Sami Yusuf?
Specifically, I'm referring to Tariq Zain, the former group executive president, and Mr. Sami Yusuf, the former vice president for finance.
Mm-hmm. And the idea was to investigate these individuals as well?
Yes.
Was Tariq Ramatallah ever a part of that group of individuals?
Other than that was shown to us where Tariq instructing FAIZAL to conduct a certain transaction, I don't think he had any role in this actual investigation other than the email.
And of course, other than anything else that FAIZAL had said in his interview. Correct?
Yes.
Did you interview Tariq Zain?
Unfortunately, we couldn't get a hold of them.
Okay.
Neither one.
Do I take, you didn't get a hold of any of them?
No.
Did you try?
Yes, we actually approached the group in Sudatel through the secretary of the executive office to try and either provide their emails, personal emails, since they were no longer with the group. In addition to, and if they can actually communicate with them directly to see if they can be present for the investigation. However, that didn't proceed, since at a certain point, once we were told that I was informed by Mustafa Abdul Malik that an investigation or a police case is started against them, and therefore the committee is no longer required. And other than that investigation session and the transcript that we had in record, I don't think even we can say that it is an investigation report, because the investigation was just starting when we were asked to just put it on hold.
Okay. But no claim has been brought against Tariq Zain or Sami Yusuf for the $2 million. Is that right? Civil claim I'm talking about.
Well, actually, it was very clear that they were part of this incident, and no one can deny their role in it.
No one can deny their role in it, but you have not brought a claim for the $2 million against either of them. Is that right?
Well, that wasn't the role of the investigation committee. Well, our responsibility was towards FAIZAL, since he's employed by EXPRESSO. And in terms of jurisdiction, I'm sure Mustafa Abdul Malik was aware to the complexities that this can turn into if we leave the matter completely to to the group at the time with newly appointed legal office in the group, not quite understanding that this is an entirely different jurisdiction. We had to try and convince them that there is certain process we need to take. And the first step was sent FAIZAL while the police investigation was ongoing to continue to pay his salary. And basically that's it.
But why was the decision taken to eventually dismiss FAIZAL before the police investigation had concluded?
Sorry, but I wasn't part of that.
Okay.
I did not remain part of the committee or part of the investigation up to that point.
Fine. Was FAIZAL's good record as an employee made available to the investigation committee?
Yes.
Was. And when I say the investigation committee, I don't just mean EXPRESSO's. I want to be clear. Was it also made available to at the Sudatel level as well?
Can you please repeat the question again?
Sure. We understand that the investigation was taken over by Sudatel shortly after the FAIZAL's interview in May 2021.
Yeah.
Is that correct?
Yes.
Was Sudatel aware of FAIZAL's good record before it was Sudatel aware of FAIZAL's good record after his interview had concluded on the 6th of May 2021?
I'm afraid I cannot answer that because I wasn't part of any actions or any involvement in the investigation or the role as member of that committee, because I was far in Mauritania. So the minute that I was told that the committee is redundant, I just kept away and I didn't have any role.
In fact, I think you were conducting the meeting with a Google Meet invite on the 6th of May 2021. It was remote.
Yes.
Because I think you were in Mauritania and I can't remember, maybe some others were elsewhere. Is that right?
Yes. Yeah.
Okay.
Please, if I may say, just the internet connection is it is not that good. So sometimes the picture freezes and I don't hear you correctly. So bear with me.
No worries.
Yeah.
After FAIZAL was suspended.
Yes.
Did you have any further involvement in his investigation?
No.
Did you have any involvement in his dismissal? Sorry?
No.
Okay. Did you have any involvement in relation to post-termination settlements? By that, I mean financial. Post-termination.
In terms of off-the-record discussions with Mustafa Abdel Malik?
No.
Or even with, yeah.
No, I mean settling FAIZAL's dues.
Yes. Yani off the record, yes, maybe I discussed this with Mustafa. He asked for my advice a couple of times, but off the record.
Right, okay. Did he mention the visa at any point?
No.
Were you aware?
My understanding was actually that, if I may say this, my understanding was it was in his favor not to cancel his visa. So that was the whole idea, that FAIZAL was in Dubai with his family,
okay,
and therefore it was more beneficial to maintain his visa.
Okay. I'm just going to stick to things that you can and cannot give answers to, and I respectfully suggest you can't give that sort of answer. What I'm asking is whether you were asked at any point by Mustafa or even anybody else what should be done about his visa. I think the answer is you weren't. Is that right?
If it is yes or no, yes, no. since basically he was suspended with full pay, and it was understandable to maintain his visa.
Okay. What after you had stopped being involved, okay, who dealt with all the HR matters in relation to FAIZAL?
I'm sorry, can you please repeat the question?
After you were involved in the investigation, then you stopped being involved, correct?
Yes. Yes.
My understanding is you had nothing to do with his investigation, you had nothing to do with his dismissal. Is that right?
Exactly.
Post-termination,
yes,
sometimes off the record, by that I think you just mean a conversation, may come up with Mustafa about certain about payments to be made to FAIZAL, maybe about the visa. I think the answer to that is no, but certainly about the payments. Is that right?
Yes. Yes.
Right. The follow-up to that is, who was dealing with all HR related matters post-termination in relation to FAIZAL?
I believe between EXPRESSO and Sudatel Group.
Well, okay, well, not you by the sounds of it. Is that right?
Excuse me?
You were not involved.
No.
Okay. After FAIZAL was suspended, I understand Sudatel effectively took over the investigation. Is that right?
I believe so, yes. Yes.
Did Sudatel ever consult you about anything at all, even if it were off the record?
No.
Okay. Before you stopped being involved, before your involvement stopped, did you suggest to Sudatel or EXPRESSO or both that they should interview FAIZAL a second time or a subsequent time?
Well, actually, the final suggestion that was put forward by the committee, and I think I was part of that, except I think this was done verbally, is that they need to start a police investigation. They need to file a police case in the UAE. Even if Sudatel started one in Sudan, that they need to start one also in UAE, considering the complexity and the size of the incident itself.
Okay. You see, what I'm trying to understand is, at the same time, that you say you were asked to convene an investigative committee, you were not part of the investigation. Do I take it that you had nothing to do with his suspension? The decision to suspend him had nothing to do with you?
No,
correct?
Actually, I am the informed him about the suspension. The suspension was a decision taken by the committee. Yes, it was a decision taken by the committee.
Yes, but you were not part of that decision-making process to suspend him.
No, actually, I was part of that.
Right.
That was actually our suggestion to the group.
Right. So your suggestion to the group, you're involved in the decision to suspend him, correct?
Yes.
You have certain opinions.
Immediately afterwards, yes.
You had certain opinions on the answers that FAIZAL had given you, the committee, correct?
Yes.
You also decided that others should be involved, interviewed, yes?
Yes.
Was there a decision that, for example, there should be a full review of the reports and everything before a decision to dismiss was taken?
Well, actually, at that stage of the investigation, it was very premature to reach a conclusion. We just discovered that the former group executive president, vice president of finance are part of the wrongdoing. So we had to refer the matter to the group or to the newly appointed legal department to see the possibility of also following through with a police case in the UAE.
Yeah. Did you ever see the Parker Russell report?
No.
Okay. All right. Thank you very much. I don't have anything further.
All right.
Thank you very much.
Just a minute, Mr. Doherty. We'll, Mr. Al-Alouf,
Yeah,
we'll see
I'm
if
not
Mr.
going
Doherty,
anywhere.
we'll see if
Yes,
Mr.
Your
Doherty
Honor.
has some questions for you. Mr. Doherty?
I don't.
All right. Well, that does complete your evidence, Mr. Al-Alouf. Thank you for your
very much.
assistance. You're now
Thank
discharged.
you.
You can remain and watch if you wish, or you can leave us. But in either event, would you switch off your camera and put yourself on mute?
Thank you very much.
All right. Well, it is now 2:25 Dubai time. I propose to take a break of, I don't know, 15 or 20 minutes. By the time I stop talking, probably we'll go to 2:45 Dubai time. Now, we had the timetable provided for each of you to address for 1 hour. Clearly, that's going to take us beyond 8 o'clock, but perhaps I should just check with Miss Norton if we can continue on until about probably 8:45 or thereabouts.
Yes, Justice Lemiere, it's fine. We can accommodate to whichever schedule you prefer.
All right. Well, thank you. All right. So we will adjourn to 2:45 Dubai time. And at that time, you'll each have 1 hour. Thank you.
Thank you very much. Thank you.
All right. I can see both Mr. Costello and Mr. Doherty. Thank you. Now, I think the arrangement is that Mr. Costello should address first.
Sorry, I was just trying to unmute myself.
Yes.
Yes. Well, Your Honour has had the benefit of hearing openings, the evidence in a short space of time, and has had the benefit of written openings already. So I don't propose to repeat what's already in writing, but I do want to make the submissions in the following order. Limitation will need to be addressed. Dismissal for cause, and by that I mean the legal framework. I should say at this stage, there's nothing in dispute between my learned friend and I as the legal framework to be applied. I think we're on the same page on that. But I do think it's worth revisiting, certainly as part of my submissions on how the facts that you've received by way of evidence fit in the framework. 3, coupled with that, will be negligence, obviously. And I know that there has been an authority.
Well, just before you leave that, Mr. Costello,
yes,
you may be right, but as I understand what you call the legal framework, as I understand it from the submissions, you're both proceeding on the basis that the relevant legal test is that set out in Section 63 of the Employment Law, and that in turn that has a 2-step or a 2-part test. The first part being where the conduct of the employee warrants termination. And I think from what I've seen, your submissions seem to be much the same as to what that means or involves. The second part is where a reasonable employer would have terminated the employment as a consequence. And one matter which you might come to is I'm not sure whether you say and rely upon the process by which the dismissal was effected as being relevant to that question and the decision-making process of the employer, whether that's relevant to those questions. So those are matters arising out of your cross-examination today, which caused me to raise those questions. But let me not take you out of your planned course.
Certainly, I will come to deal with those matters in the course of my submissions on dismissal of cause. I mentioned the negligence claim because I think logically it would make sense to deal with it at that point. And then fourthly, dealing with what I'm going to just say loosely called the other claims, but I think we know what we mean. What the court will know what I mean by that. I will within the other claims, I will deal with loss of earnings perhaps first because it's the most substantial. Then deal with the other remaining residual claims for tickets, childcare allowance, and medical. Sorry, childcare allowance, air tickets, and and then the follow-on, the final point will be penalties. As a final topic. Dealing with limitation, then, I know we touched upon this already, but to make a fuller submission, may I take you to the employment law at 715 of the bundle?
Yes.
So the starting point for limitation period is Article 10. And so Article 10 is subject to two other articles, Articles 20 sub-article 2 and Article 61 sub-article 2. For the purposes of my submissions, Article 61 will not trouble you. So it's Article 20 that we need to consider, I submit. Starting point, therefore, is that the court shall not consider a claim under this law unless it is presented, my emphasis on the word presented, to the court either during an employee's employment with an employer or not later than 6 months after the relevant employee's termination date. My learned friend has set out in his skeleton which the definitions that appear at the schedule to the law, and if we want a page reference for completeness, the definition of the termination date is at page 748.
If it saves you finding the page references, I've got a hard copy in front of me.
Well, I'm grateful for that. With that, if we look at the definition of termination date, where it is an employment, so where we're dealing with notice, then the termination date is the date on which notice period expires. Where we are dealing with an Article 63 termination with cause, then it's the date on which termination of employment takes effect. Now, Your Honour will know that Mr. Moorkath's claim in the primary sense is that he is owed various sums of money, one of which includes notice pay. Now, looking at Article 10, therefore, the expiry date appears to be at the end of one or the other, depending on which scenario you consider as appropriate. So it's either going to be at the 6 months from the date at which notice expires. That would be the 23rd of June 2022, or it would be from the date of immediate dismissal, so summary dismissal, which was the dismissal letter was the 23rd of March 2022. If the matter were to stop there, the claimant's claims are out of time. But in my respectful submission, the next stage is to look at Article 20, and specifically Article 20 sub-article 2, because that is the specific provision given in Article 10. And of course, the court can read that for itself. But may I emphasize the following, that this is a claim brought by an employee in relation to a failure, so says Mr. MOORKATH, by EXPRESSO to pay his remuneration, to which he says he's entitled to under the employment contract or the law. I just want to pause there because yesterday there was the idea floated in relation to whether a breach of contract claim may be brought. I think it's only right for me to say that I don't think that is right, actually. I think it is. I think I have to fairly concede it if it's an employment, given the wording of this provision and given the fact that there is an employment law. I think it would be difficult for me to say that every single employment claim that fails, where it's a claim for a contractual entitlement, any claim that fails would be saved, as it were, by the contract law. So I think I have to make that point clear. And so when one looks at the rest of this provision, Article 20,
well, what caused me, and in a sense, I don't want to waste your time by going on a frolic of my own, but I can't resist. Yeah. What caused me to raise the matter was that Article 10 says, as you've read out, a court shall not consider a claim under this law. Now,
yes,
if the claim, if an employee or employer for that matter, but if we take an employee, brings a claim saying the employer has breached the contract of employment and I seek damages under the law of damages, is that a claim under the employment law?
Well, it's an interesting question because I'm in thinking about this aloud, it might look to be one. Whether an amendment is necessitated in these circumstances to plead as such, probably will have to be an amendment, because I can't say right now the claim has been brought in that on that basis.
I haven't. It's brought in terms under the law, is it?
So when the particulars of claim have brought this claim under the employment law, this paragraph 4, page 4.
So the applicable law to this claim are FAIZAL, the employment law, and the law of damages and remedies.
Yes, and the law of damages and remedies.
Made me think.
Yes,
that made me think that the claim was being made in part under the law of damages, providing for damages for breach of contract. But
in fairness, I think, and I acknowledge this is counterintuitive, but obviously as an officer of the court, I have certain duties.
Yes.
The claim for the loss of earnings is brought under the law of damages and remedies. I'll find a specific reference to that.
I see. All right.
But
all right. Well, I'm not going to talk you into anything, Mr. Costello.
No, as much as I would like to.
I wanted to raise the matter because it troubled me a little.
Yes. No, well, as I say, as much as I would like to have the claim brought within that, I don't. Right. It's not been pleaded that way.
All right.
And certainly, in fact, my point is, when one looks at Article 20, 22. Yes. Can I just get the reference back up again because I've lost it? Yeah, when one looks at 20 subarticle 2A. And it should be AI. You don't even need to be troubled. because in the case, this is a case where the claim relates to a non-payment of remuneration by the employer. And so time runs from the date at which that remuneration should have been paid.
Well, when should it have been paid?
So if I take you to paragraph, I think it was 50 of the particulars. Yes, paragraph 50 of the particulars of claim.
Yes.
Now, given the dismissal date, the date of dismissal was the 23rd of March 22, that's not in dispute by the claimant. All of his dues were required to be settled within 14 days from the date of termination. But given that his claim is for 3 months' salary, because of notice, it would be 3 months plus 23rd of March 22. That gives you a date of the 23rd of June 2022,
Yes.
plus the 14 days, which is when we come to the 7th of July 2022. And so by virtue of Article 20, the final
claim. What? Oh, sorry. Carry on.
No. I think you're ahead of me. So your Honour's asking the next question, which is the pertinent question: when was the claim presented?
Yes.
Page 1252 of the bundle, please. That is a screenshot showing that the claim was filed. We say that that's the presentation of the claim form to the court on the 30th of December 2022.
Sorry, I'm in difficulty for some reason accessing the page. Let me just try again.
Yes.
All right, let me try something different. Oh, maybe it wasn't in the original bundle, was it?
No, it wouldn't have been, because this was necessitated after receipt of submissions.
Okay, let me go back. I just need to go back in and find the sorry, if you just bear with me.
Yes.
I'm afraid I downloaded the bundle to avoid having to sit looking at spinning wheels for the time, which I'm now doing.
Yes.
But perhaps whilst I'm doing that, you can tell me what is it,
Yes.
page 1252.
So what it would show is it's a screenshot showing that on the 30th of December 2022, the claim form was filed with the court.
Ah.
Now, I don't know, it may be that there's an argument coming, well, the issue date is the date which matters, and the issue date is the 26th of January 2023. However, in my submission, that would not fit harmoniously or naturally with the meaning of the word present a claim to the form. Present the claim to the form. Sorry, present the claim to the court. The presentation is the filing. As we know, the form will need to be issued, the claim form, that is. That can take time. In England, there's a stamping exercise. I don't know if it's the same in Australia.
Yes.
But it would be stamped, issued, and then, yeah. I think it's electronic
depending on what sort of online system you've got.
Yes, exactly. So in that sense, that's why I say you don't need to be troubled by the contract or anything else. The claim is within time in that respect, and that being Article 20 being an exception to the general rule in Article 10, that would maintain the claims, the relevant claims, for your consideration. The loss of earnings claim is separate because that claim doesn't depend on the employment law. The employment law provides the article requiring the cancellation of the visa. However, a cause of action doesn't arise as a result of that article of itself. The cause of action arises as a result of the employer assuming the responsibility in order to have the ex-employee's visa cancelled. The authority we have on that point, sorry, I'm just going through my tabs, is the Georgia against Gloria Beauty Lounge LLC case. If Your Honor would like a page reference, that would be page 866. Can I ask Your Honor to just park that for a moment? Yes. Only because I would just want to give the principle, which is that there is an obligation bestowed on the employer to cancel the claim, an ex-employee's visa. And I go back to one of the points I made earlier, which is that the loss of earnings claim is a claim under the law of damages and the law of damages and remedies, and that claim arises out of a breach by EXPRESSO to fulfill its obligation to cancel the visa. And accordingly, we say under Article 23 of the law of damages, the claimant has his claim for loss of earnings. We'll go into the detail of that in a moment because there are some evidence.
Can I just go back? Yes. Can I just go back now that I've got the screenshot up in front of me? And can you explain to me the process?
Yes.
So what physically happens? You go onto the court portal or something? How does it work?
This is anecdotal and it's not for me, but my understanding is you go into court portal, you file your documents, or in this case, a claim form, you submit. Once you submit, the court has effectively then received it, but you wait. You normally get an acknowledgement email to say something has been filed. Now, in the case of a claim form, the claim form is then issued and sent back to the claimant, and then there are the usual time limits on the service of claim form.
So what I'm looking at here, this screenshot, that's a screenshot of what? What's on
okay. Yes. It's a screenshot of the portal. So I can, I'm part 1 and part 2 as it happens. But as a part 1 practitioner, I can log into the portal. When I go into the portal, I can then select the case, or any case. So in this case, I can select FAIZAL's MOORKATH's case.
Yep.
Once I open that case, I'm given a list of events.
Yes.
And within those list of events, I can scroll all the way down to the claim form. I click on that particular entry, and then this screen will come up.
Even before the claim form has issued.
Yes, sorry, because the claim form, when it's issued, appears as it does at page 1.
Yeah.
Of the bundle.
Okay. Yes. And after it has issued, does what I'm looking at page 1252 remain on the portal, or is that gone?
Yes. No, it's there, and that's how it was obtained on Friday, I think it was.
Oh, I see.
Because if you look at the screenshot, Your Honor will see, obviously in the middle of the screen it says filing date 30th December, but on the left there's a document section, And under the document section, one can view the document, as it says. So if you click on the claim form, what you then find is the claim form itself.
Yep. Okay.
And that's at page 1.
All right.
So there is a difference between the filing date and the issuing date.
Yes,
but
I see.
my submission is the issue date is not relevant. It's the presentation, and so it's the filing date.
And that's defined on the screen as filing date. That's the description that is used by the court system.
By the court system.
I see. Yes.
So as I say, on limitation, what affects limitation are the claims made under the employment law or under the employment contract, but the claims made, for example, loss of earnings, are unaffected.
All right. I want to go back a step on your Article 20 argument.
Yes.
You say that Article 22A1 refers to, in the case of a claim relating to non-payment of remuneration, the date which the deduction, the date on which the remuneration should have been paid.
Yes.
Now, is not the date on which it should have been paid 3 months after the 23rd of March?
No, because the date that you get in terms of the 14 days, that comes from Article 19(1) of the employment law. So if Your Honour has Article 19(1), so sorry, my version is hyperlinked, so I've clicked by mistake the hyperlink. If you're on just both.
No, I read an employer shall pay to an employee within 14 days
after the termination date.
I see.
And one of the termination,
you say that's the date.
Yeah.
It's not a sort of grace period. That is the date.
That is the date, and that is the date as pleaded in paragraph 50 of the particulars of claim.
Yes, I understand.
Yes. So that is my submission on limitation. I don't propose to say anything more on that. Can I now turn to dismissal for cause, staying with, if I may, the employment law?
Yes.
In Article 63, Your Honour's rightly referred to.
Yes.
And as Your Honour says, there's a two-stage test here. So an employer or an employer, in this case, an employer may terminate an employee's employment with immediate effect for cause in circumstances where the conduct of the employee, in this case, warrants termination, step 1, step 2, and where a reasonable employer would have terminated the employment as a consequence thereof. Can I please now have a look at the Elesco case, which is at section on legal authorities, page 828. And specifically, paragraph 21 of the reasoning, which is at 839. Essentially here, my learned friend is referred to the McDuff
Sorry, I was
case.
scrolling. What page, what paragraph number did you say?
Paragraph 21, it's on page 839.
Yes.
Your Honour may recall that my learned friend rightly referred to the McDuff case, and what this authority does here for you is adopt the principles from McDuff and quotes from paragraphs 22 of the McDuff judgment.
Yes.
Yeah. Yeah. So if one especially considers paragraph 22 that's been quoted from the McDuff case, so it's actually paragraph 21 of this judgment, but he's quoting paragraph 22.
Yes.
Then there must be a positive finding of that the employee's conduct warranted termination. So
Yes.
Your Honour will have to decide, based on the evidence in this case, whether Mr. Moorkath's conduct warranted termination. We'll go into the detail of that in a moment. The second limb is a bit has a bit more discretion about it, I would say, impolitely. It requires a reasonable employer. It requires the court to find whether a reasonable employer would have terminated Mr. Moorkath.
When you say that, is of course strictly not discretionary. It would be, in a sense, an evaluative judgment.
That's right. But it's the circumstances that were at the time. Now,
Yes.
there is no real definition of what that means in terms of the circumstances, but I don't think there needs to be one. It is as simple as the circumstances which existed. So it can be, as I think the Chief Justice Huang did in the case, at paragraph 23 of the Macduff judgment, and I think this captures it, where he gives the example in the final sentence. Yes. Thus, for example, if the actual employer has known of the relevant conduct for some time and has done nothing, it should be asked whether a reasonable employer who had known of the relevant conduct for some time and had done nothing would have terminated the employee. There may be some hallmarks of that in our case. It's not quite the same, but there is some.
It depends whose knowledge you attribute to the defendant, doesn't it?
Oh well, that's a whole issue of itself on its own, which I'll have to come on to. But that's right. I mean, it is this. There are so many problems in my submission with this dismissal, because now the court is being asked to construe the decision of Sudhatel as the decision of EXPRESSO, and that's very clear from Mr. Abdul Malik's. In fact, I have to query what was the point of either of these two witnesses coming to the court, when in reality there should be somebody from Sudhatel. But anyway, I'll deal with that later. But for the purposes of this test, this would also, in my respectful submission, also include matters such as the claimant's record, his record at the time, the fact that 5 years had passed since the actual transactions had taken place. So I say 5 years, roughly 5 years.
What it sounds, I must say, at first glance, in most Australian jurisdictions, and I think probably similar in England, unfair dismissal cases, as distinct from unlawful termination cases, unfair dismissal cases go into all those things to do with the process of dismissal,
right,
and so on. But now I've seen some cases to the effect that this law does not equate to the unfair dismissal law. Yes. But it seems to perhaps to verge into some of the same considerations that are taken into account.
I would respectfully agree with that. I would suggest, and I don't suggest that where there is a breach of procedure there is an unfair dismissal. I don't say that at all. But what I do suggest is that a reasonable employer would take into account certain facts or certain circumstances, such as, and I'm going to speak colloquially, we didn't interview him more than once. We didn't show him the reports. We didn't actually ask him for evidence of, for example, the use of the transferred monies. We didn't do many things. Now, I would suggest a reasonable employer would consider those circumstances in deciding whether or not to dismiss. But there are.
One thing I'm not sure about, Mr. Costel, in the way the two, if I can call them the two limbs of the test, operate together. Under the first limb, I think I simply look. Well, the first limb is directed towards the conduct of the employee. And looking at that, I look at the evidence now available as to the conduct of the employee. And if I determine, looking on the evidence now, that his conduct warrants dismissal, if I then come to consider what a reasonable employer would have done, and if one of the matters, as it were, brought up against the employer is that the employer failed to give the employee an opportunity to give a further answer and further material. But if I've decided the first limb against the employee, doesn't that lead to the conclusion that even if he had put up that material, it still would have been a dismissal?
That is a possible outcome. I don't deny that.
Hmm.
What I suggest is that it rather depends on what that conclusion is. If one is to conclude where that there is it depends, because if you conclude there was a fraud, for example, that's quite obvious. No amount of explanation is going to do anything about it. But it's difficult with negligence because the finding may not have been gross negligence. It might have been negligence. It might have been something short of negligence. It might have been serious enough where an employer would potentially consider dismissal.
I think, like many, I have difficulty with gross negligence. I think
yes.
It's often
What
said
is
the
gross?
best you can do is to say it's a serious
Yes,
case
exactly.
of negligence. But
Well,
anyway,
exactly. But in the context of this case, one might even one would expect an employer to consider the fact that Mr. Moorkathe was instructed to do certain things,
yes,
as opposed to him being the only person
yes,
with the only authority, as in an instruction is given from him to him from Sudatel, or went on a frolic of his own, which is the classic example to negate vicarious liability where damages occur to a third party. But it's different in different. I know it's a cliche saying, but it just depends. And in my submission, it very much depends on the finding. I don't, as I say, I don't, as a principle, I don't disagree that it is potentially possible that a certain finding on the first limb will inevitably reach a certain finding on the second limb. But it will come on to submissions on why that is not the case in this particular matter.
yes. The example that Chief Justice referred to there is, I think, the sort of condonation principle that we see coming up in common law and indeed in unfair dismissal cases. So one can see that's probably the easy case.
Yes, yes, I agree, and I suspect that some of the previous cases, it could have been, it was probably easier once the finding of fact had been made.
Yes,
but I respectfully submit that Mr. Moorkathe's case is not that straightforward. That may conclude what I wanted to say on. Oh no, I should. Sorry, I recall now. I think it's only right for Your Honour to look at the employment contract itself, and that's at page 272. That's the start of that's the front sheet of the contract. Clause 12 will need to be reviewed because that's at page 278. Contractually, there are circumstances provided for termination with cause.
Now, how do we get there? That's why I said if the framework is that the question is whether or not the test in section 16, Article 63 is complied with, how do we get then to the terms of the contract?
The simple answer could be that it's a problem for my learned friend and not so much for me. But what I suspect the answer is that Your Honour will see that there can be breaches of contract as a result of a potential breach of clause 12, one of the conditions of 12.1, yes. And that may give rise to circumstances that satisfies the statutory test. So assumes a false identity or nationality or submits forged certificates. That's I think we're generally dealing with fraud here. In fact, as it happens, 12.1c has been cited, which relates to a fault. But I don't think you necessarily need a breach of contract, as specific as these circumstances, in order to satisfy, for Article 63 to be satisfied. But it's probably evidence that you can look at, is what I imagine. Or at least, if that's the pleading, if the pleading is we terminated for cause because Article 63 has been satisfied as a result of a breach of Clause 12, that might be the argument or the submission that you would need to consider. But and those are the circumstances I envisage would be the relevance of Clause 12.
All right. Well, perhaps, as you say, it is a matter that I might discuss with Mr. Doherty. But,
yes. At this stage, I may as well deal with. I should deal with the evidence that you have.
Yes.
In relation to cause. I appreciate there's an overlap with negligence, but negligence is a different topic. Now, there were two types of transactions, broadly speaking, that Mr. Moorkhath has given evidence on, and you've slightly heard from Mr. Abdul Malik. These are what I'm going to very loosely call the transactions which relate to disbursements, quote unquote, where money is being sent to a supplier, for example, at the request of Sudatel, but by EXPRESSO, and transactions by EXPRESSO for the benefit of Sudatel, where cash is being gathered, collected, and handed over. That cash is said to be Sudatel's. I think Your Honour has a question.
I do, because I want to see whether it occurred to me in listening to the evidence of Mr. Moorkhath and thinking about what is the relationship between Sudatel and EXPRESSO, and I want to know if this is either part of or consistent with your case. And it seemed to me that the relationship or the basis upon which EXPRESSO receives, holds and disperses money on behalf of Sudatel is akin. It's like EXPRESSO acting as banker for Sudatel. In effect, EXPRESSO has received money. I think in the spreadsheet, I haven't quite got to the bottom of the Ghana one, but I understand, I think it's the case that that's a receipt that has come from Ghana to EXPRESSO, which is money belonging to Sudatel.
Correct.
And rather like making it, what struck me, it's like we see relationships with groups of companies where one of the group acts as, in effect, a banker to the group. And what happens then is that the company receives money which belongs to a group, another company in the group, keeps an account from it, and when it gives the money to the other company in the group, it records it as going out to that company. Whilst it may not be, and I'm not sure whether it is a legal relationship of debtor and creditor, it seems very close to that between Sudatel and EXPRESSO. EXPRESSO is receiving, say, the money that comes from Ghana. It is money paid to EXPRESSO on behalf of Sudatel.
Yes.
EXPRESSO puts it into its bank account, and it seems to me that the position then is that it owes that money to Sudatel, as seems to be what the meaning given to the account, which is Mr. Moorkhath has referred to, where it keeps the state of the account.
Yes.
And then when Sudatel either requires or instructs money to be paid to itself or directs it to be paid to some other party, that's either a payment to Sudatel or at the direction of Sudatel, and it's taken into account in the balance.
Correct.
Now, I don't know if that's, again, me going off on a frolic of my own, but that's the way it seemed to me, the evidence was painting the picture.
Well, can I take your honour to paragraph 17 of Mr. Moorkath's third witness statement at page 65? And it's probably worth just spending a bit of time here. So Sudocel has many international receipts, and the defendant, EXPRESSO, received those payments in its Dubai bank account. So that accords with your analysis, based on the evidence you heard. EXPRESSO would receive those funds from would also receive funds from subsidiaries on behalf of Sudocel. Okay, whether it's cash or bank doesn't matter for the purposes of this conversation. But once received, the defendant kept the funds in its custody, so EXPRESSO keeps these. It receives instructions from Sudocel on how to use those funds. If it received the instruction from Sudocel, then EXPRESSO would make the payments to the beneficiary, and we saw examples of that when my learned friend took Mr. Moorkath through various payment procedures. Where there were any Dubai-based agreements, payments would be received in a Dubai bank account, and there were and it goes on to tell us about some restrictions. So, yeah, that Your Honour's proposition in terms of the analysis of the evidence, I would agree with. I would also say that the procedures that Mr. Moorkath gave evidence on in relation to disbursements, which is my use of language, is as it would be as he's already described in paragraph 17, which is an instruction would be received on how to make the payments of Sudotel's money. And putting it very simply, Sudotel receives its money through EXPRESSO. Sudotel tells EXPRESSO what to do with how it wants to have its own money dealt with. EXPRESSO is a medium, and that's about it. The issue in this case is what happens when Sudotel says, I've got money, I want to use it, I don't know how I'm going to use it yet, but I want my money. And that's what's happened. In very simple terms, that's what's happened. To suggest that there are payment procedures akin to disbursement payment procedures is a bit ludicrous. Because
but against that, what does seem reasonable, seems to me, is that two of the matters that, or perhaps comes down to one that Mr. Doherty has referred to, is having adequate records of what has occurred.
Yes.
So there's two aspects to it. One, which I think probably I've led you into, is the question of whether the money has been properly dispersed. And for the moment, subject to what Mr. Doherty has said to me, my provisional view is that if Sudotel has given an instruction to EXPRESSO to give the money to Sudotel or to pay it to a third party, that is all that EXPRESSO requires. It's not, there is neither an obligation and perhaps no right on the part of EXPRESSO to inquire what it is that Sudotel is going to do with the money. But I think matters that Mr. Doherty has addressed is that Mr. Moorkath should nonetheless ensure that there are proper records of what has occurred.
Mr. Moorkath, what I would say is, on the evidence of Mr. Moorkath, he has submitted that the documents that were available to demonstrate the request and the use of that money were documented. In respect to the 2016 transaction, he had made references to the email, but more specifically to the check, which he says was recorded, to the memo, which was received by WhatsApp initially, and then notes were added, and that was also, he said, documented. And what I say is the upshot of Mr. Moorkath's evidence is there was nothing else to be documented, and he has executed the instruction as as he says, as was expected and as was usual for these sorts of.
The receipt. Well, I'm not sure if it was his terminology. He referred to the memo.
Yes.
It's not informed the way that one customarily receives, understands a receipt. I have received the sum of $1 million on this day, Tariq Zain. It's a little bit more oblique than that, isn't it?
Yes, but he did give evidence of the signatures.
Yes.
He gave evidence that both Tariq Zain and I think it was Tariq Ramatullah or Sami Yusuf, can't remember which one. That anyway, there were at least two signatures to indicate who had said what or stated what. So yes, maybe not conventional receipt, but evidence, documentation nonetheless to demonstrate one, that the money has been transferred and by way of the check, or sorry, not transferred, sorry, rewind, money that has been gathered, and two, that money had been physically exchanged. And one point that arises on that is that the evidence was that Mr. Sami Yusuf, Tariq Zain, and a third individual were present. So two people from Sudatel. And when the money, as Mr. MOORKATH says, was given to effectively Sudatel, what thereafter happens is beyond Mr. MOORKATH's control. And so there was a lot made of the point about the third unidentified individual, and I respect to submit that's not going to take matters any further. I should say that just on the point of the money, and Your Honour will remember the re-examination with Mr. MOORKATH as to the entry. He did enter quite clearly cash for STG as opposed to cash to STG, which I also suggest distinguishes transactions where cash is being handed over to STG, i.e. it's cash for STG, and that's a natural reading of the word for, as opposed to cash to STG, which might delineate some sort of a payment from a disbursement for that's going to STG because it's going to STG. It may also it also supports Mr. MOORKATH's evidence that he recorded the date on which cash was physically taken out, in terms of physically withdrawn from the bank. Withdrawn from the bank, or exchanged by exactly. Exactly. So and he's also given evidence of correspondence which he had with Shireen. Definitely he had correspondence with in 2016, and also Sami Yusuf, where he would be saying to Mr. Yusuf, I'm just trying to get the email up. If you want to just bear with me. Yeah, sorry, not Sami Yusuf, Sadisu, page 196 of the bundle. And there's a request from Shireen for documents. He then forwards it to Sadisu, EXPRESSO, saying, essentially, we discussed this matter. Please check it with VP. I'm not going to give any further documents to her because you should be checking it. And then he is told, as in Mr. MOORKATH is told, by I think it's a Mr. Jibrin, I hope, that the email was sent in error, and it was already discussed with her and how to treat the entry. So as far as he is concerned, being the claimant, he's done everything that was expected of him and has seemingly done nothing wrong. Now, just to deal with the point that if you find there is a breach of documentation, the next question is, well, where does that then take you in terms of termination for cause? Would that of itself, in my submission, be conduct which warrants termination? I would respectfully submit not. And these are any breach can't be of itself a sufficient justification of termination, especially when one looks at the circumstances, which is that he's worked at the defendant company for a significant period of time, was the only accountant there, seemingly no training, no training given to him in particular beyond that which he received early in his career, and that's evidenced by him in his witness statement. I don't need to trouble you with it. That can be read at your own leisure.
He doesn't really say. Not sure he says he received. Sorry, he does say he received some training, but gives no indication really what it was about. Certainly, he either says nothing about with. Sorry, I'll put that badly. He says that there were no procedures prescribed. So I infer from that he received no training in relation to procedures that were to be followed.
Yes, that's what I suggest. Sorry, I'm not being clear. That is my submission, which is bar any initial training, which I think he referenced a couple of weeks.
Yeah,
I need to find the reference now, but
I remember it.
Yes. Other than that, there's nothing else. So for a significant period of time, he's the only real individual there, figuring it out as he goes along. And even after these transactions, he's still in work until this May 2021. So what we're dealing with, if we look at a timeline, a small tiny blip in my, if you find that he acted properly but didn't record properly, then it's a really small blip in an otherwise unblemished tenure with the defendant.
Yes.
Anyway, so that's how I would say that would, if any such adverse finding were to be made, that would fit within the statutory framework. In relation to, I mean, a lot of what I've said is relevant also to the 2017 point as well. Sorry, 2017 transaction. Now, the reason why I wanted to, I do suggest that it is relevant to look at the wider circumstances is because he was investigated for a 2016 transaction, not ever interviewed about a 2017 transaction. That has to be a factor that is considered by an employer when considering dismissal, i.e. he hasn't had a chance to answer that. He wasn't given a further opportunity to come in and answer questions in relation to reports that the defendant had in its possession, which were damning in their conclusions. So it is relevant to consider whether or not a reasonable employer would have still terminated Mr. MOORKATH, knowing that they hadn't dismissed him, properly interviewed him in relation to at least one, which is the 2017 transaction, and I would suggest incomplete in relation to the 2016 transaction. Yeah. One fact which my learned friend may rely upon, I am anticipating, so we'll see, is that, and I make the submission on the back of the cross-examination of Mr. Abdul Malik, which is that at the time, the Parker-Russell report was available to Sudatel, certainly, at the very least. It's tricky because in these circumstances, as in terms of Your Honour and having to make a decision in these proceedings, Your Honour doesn't have the benefit of that report because, for rightly or wrongly, it's not in a proper format to be presented as to the truth of its contents and cannot be received in that to that extent. The most that Your Honour can do with that is to consider that a reasonable employer had a report, but whether it was properly challenged, whether it was properly a proper report, that's frankly not those are not answers in the favour of the defendant. Those are answers that tend to favour the claimant. Yes, sorry.
What do I make of Mr. Doherty may tell me I've misunderstood Mr. Abdul Malik's evidence, but putting it at a high level of generalisation, I took Mr. Abdul Malik to say the decision to dismiss was not made by EXPRESSO, it was made by Sudatel.
Yes.
If that is his evidence, where does that fit in?
Well, that's I was just about to come to deal with this.
All right.
That is extremely troubling because the contract of employment is between the claimant and EXPRESSO. I suspect the answer coming to Your Honour from Mr. Doherty will be that any decision taken by Sudafed was endorsed and upheld. I think that's difficult. That's a difficult submission. That would be a difficult submission to make with respect, because the decision-making powers were removed from EXPRESSO when Sudafed decided to carry on to continue the investigation after Mr. MOORKATH was suspended. And we don't even know what documentation or material was before Sudafed. We have an idea of what EXPRESSO had in its possession. Sorry.
It's probably not relevant to the first limb of the test, is it?
No, it's completely relevant to the second
limb.
limb.
Employee's conduct. Yes.
Yes. But what I suspect the answer may also be is that you would have to ask, what would the hypothetical reasonable employer do,
yes,
knowing the circumstances? What I would submit is that's a bit difficult still to answer when the hypothetical reasonable employer, using Justice Wang's words, is that it is the same employer in the shoes of the then employer. So I tried to explain that in another way, and it might be easy if we go back to the authority of Alesco at paragraph 22, the judgment. That's at page 839. It is the knowledge of the actual employer that is relevant in terms of the question that you have to ask, and it's not the knowledge of the parent company that is going to be of relevance here. Evidently, Your Honour has a difficulty of trying to decide what weight could have been applied to what, but I suspect that may be the way that Your Honour would have to approach it. Yeah, I don't think I can assist Your Honour any further on that.
I understand.
But I suspect that's the answer. So that, I think, deals with dismissal for cause. Let me just check my notes, sorry, Your Honour. Yes. May I turn to negligence, Your Honour?
Yes.
And looking at the defence and counterclaim, specifically in relation to the counterclaim, that's at page 227 of the bundle. The first paragraph to highlight, paragraph 48. Paragraphs 1 to 10 of this defence are repeated herein. The trouble here is EXPRESSO greatly relies upon that Parker-Russell report in order to make good its counterclaim. Because as we saw in paragraph 6 of the particulars of claim, starts at bottom of page 18, goes through to 19, but the pertinent paragraph is paragraph 6F, 20, where it says, as a result of these findings, the defendant had no option but to terminate. And when one looks at the dismissal letter as well, which is at, sorry, Your Honour. The dismissal letter is at page 287, wherein it says, based on internal investigations and the reports of the internal auditor and the chartered accountant, the internal audits and investigations are entirely self-serving and do not take matters further. So therefore, what it looks as though, I say objectively, is a great reliance placed upon the Parker-Russell report. I would submit no reliance is placed upon anything that Mr. Moorkhath would have said, other than the fact that that his account would be applied to various principles, etc., as discussed by the Parker-Russell report. But that's it. The dismissal or the claim for negligence at the time certainly seems to be very much heavily reliant on the report, and as I say, based on the counterclaim, similarly so. But you don't have that evidence. This is a good point at which we can deal with one of the matters raised yesterday in relation to the Article 59. Was it 59 or 58? I think about reasonable care and skill. And if I look at, I think it's Article 58 of the employment law.
Yes.
Firstly, no such breach has been pleaded. Certainly, no late. We have not made any sort of late arguments which will necessitate any sort of counter argument to the effect that there should be a re-amendment of a defence. So I want to make clear, it's not like a limitation argument where we've had to deal with it now. This is something very much should have been pleaded if it were going to be pleaded. The defendant nailed its colours to the mast and decided to stay with what I'm calling a general negligence claim. And in fact, in the reply to the counterclaim, or the defense, the defense to the counterclaim at page 38, paragraph 21, the claimant made it very clear that he notes that this is a general negligence claim in action for breach of duty under Article 17. This wasn't a claim under any other article. This wasn't a claim for breach of fiduciary duty, which perhaps one would have expected, nor a breach of Article 58 of the employment law. Now, if there is a duty, there is a duty of care between employee and employer as to the exercise of reasonable care and skill, that's perfectly admitted by the claimant, because that's in law. The law is the law, to quote one of my pupil supervisors. But that's not pleaded, and no such breach is being claimed for. The claim here is for general negligence or pure economic loss. In my submission, to impose a duty of care under Article 17 of the Law of Obligations over and above any duty of care that is owed under Article 58 of the Employment Law is not appropriate. I may have to wait and see if I can reserve my position slightly, just to see what my learned friend will say, because I understand I'm not sure if it was he himself. I don't want to speak out of turn, but the defendant asked for a Scottish case to be uploaded this morning, which is at page 1150, and that I think deals with pure economic loss. And that is the case of an employee, a former employee, being where an action is brought against in negligence for fraud that takes place where she is, for all intents and purposes, and I think rightly accepted by the court, as much a victim of it as may have been involved. But there was no suggestion that she was doing anything fraudulent. She was caught up in it because certain transactions took place on her watch. Now, if one looks at page 1151,
yes,
and this is it's still part of paragraph 1. There is a sentence that begins, had she exercised reasonable skill and care, she would have heeded the warnings and discontinued her attempts to make payment, etc., etc. So it seems that the claim was very much a contractual claim to exercise reasonable care and skill, as implied in contract. Paragraph 2, I think, would support that, where the learned judge states, "I acknowledge that employees have an implied obligation to exercise reasonable care and skill and care in the performance of their duties," and we've got the authorities there for it. I think Your Honour may have made a mention in passing yesterday that this is the normal term that's implied into the to employment contract, but not beyond that is the very simple point. Again, I'll have to potentially wait and see what my learned friend has to say about it, but I respectfully submit that a claim in negligence, well, at the very least, a duty of care is not imposed on, it cannot be imposed on the claimant. That sort of duty does not exist in circumstances where a tortious duty exists by virtue of the statute, and the statute has only codified that which was already implied by common law in other jurisdictions. If you're against me and Your Honour wants to consider whether that duty has been breached, again, Your Honour has the evidence of the claimant in relation to what he did, and we're probably going to go around slightly in circles because this is where there is an overlap with the termination of the cause. Obviously, the cause that is pleaded is negligence, so there is clearly an overlap. I don't want to repeat the evidence on that, but I would submit that if there are any errors made by Mr. Moorkhath, they're not such that the duty has been breached. If I remember correctly, in the case that we just looked at, I think in that case as well, no breach was found for various reasons. Again, I'll wait to see what the learned friend says.
One point, and I think it's a point probably for Mr. Doherty rather than for you, but of course one difference between the termination for cause on the one hand and negligence on the other is that it'll be necessary for the EXPRESSO to establish that it suffered loss.
Oh yes, and again, I think Your Honour's anticipating my next point, because I was going to deal with that, and I was going to submit that actually there is no evidence of loss. Now, there may be a suggestion made, well, on the claimant's own account, $2 million has clearly been moved from EXPRESSO, but that's not evidence of loss. That is evidence of a transaction, but not evidence of loss. And nonetheless, the claimant has submitted evidence to demonstrate, as far as he can do in the circumstances he finds himself, the use of that money to at least put a positive case as best as he can where the money went and to what it was used for. And by that, I'm referring to that long memorandum, which was the Board of Directors resolutions.
For the moment, it doesn't seem to me to matter where the money went after Sudatel. What seems to be the first step for me is whether they, in determining whether EXPRESSO has suffered any loss, one has to look at the state of account between EXPRESSO and Sudatel.
Yes.
And if what I think is Mr. Moorkhath's evidence, Mr. Doherty may tell me it's wrong, Mr. Moorkhath's evidence, I think, is to the effect that the various accounts and ledgers he showed us and the auditor's reconciliation at the end of the year leads to the conclusion that the amounts, the round figures $2 million, has come off, as it were, the amount which EXPRESSO owes to Sudatel.
Yes.
So whilst on the one hand, what's happened, in the credit and debits of a bookkeeper and the EXPRESSO side, it seems to me at the moment that what's happened is that EXPRESSO, $2 million has gone out of EXPRESSO's bank account, but the other side of the transaction is that that has been debited to Sudatel, so that the state of account between EXPRESSO and Sudatel remains the same and there's no loss to EXPRESSO. But Mr. Doherty might be able to lead me through the accounts to show me that's not right.
Well, at the only other point that I would make here is that there were exhibited to Mr. Moorkath's witness statement audit balance confirmations, but confirmation sheets from 2016, covering 2016 and 2017. There was no challenge to that. But in fairness, there's no challenge by Mr. Abdul Malik in his reply witness statement either, nor by Mr. I wouldn't have expected Mr. Al-Aloub to challenge anything, but so there's not a criticism, in fact, of my learned friend. In fact, I suggest there's no challenge because there can't be one. And in the absence of an expert to go through all these documentation, it's going to be very tricky right now for Your Honour to even conclude that actually on the face of the documentation and the unchallenged evidence, the balances are just fine. Anyway, so I make that point because I think I can properly make that point. Your Honour will need to consider whether the causation point as well, because it is raised as a defence. I submit this point is quite simple. An instruction is received by more senior members of the EXPRESSO team purporting to be from Sudatel, and money is handed over to members from Sudatel. And so if there is a loss that has arisen at all, it's not by Mr. Moorkath, where he has seemingly effected a transaction to Sudatel. And that money then goes missing as a result of Sudatel employees. There is also a serious question we raise over mitigation. There's no evidence of mitigation other than a police complaint which has been dealt with. But the fundamental problem on mitigation for the defendant is that not a single claim for the $2 million has been brought against any other individual who was clearly named and known to be involved in these transactions. It frankly beggars belief. But what this defendant wants from this court is for Mr. Moorkath, the individual who was the bookie, frankly, to pay $2 million for transactions which took place involving a number of other people, more senior and frankly, arguably with more to answer. Given that, for example, Mr. Ramatullah received the instruction and Mr. Zain or Mr. Yusuf, can't remember which one now, received the money. On either case, in terms of the apportionment of blame, that's an impossible task, I would suggest, where you haven't had a defendant before you bring proper claims against other individuals. Now, there is also a contributory negligence point to deal with here, as is in the list of issues, which is whether or not these transactions may not have been affected had there been proper policies, training, and the like. You've got the evidence on that, but I respectfully submit that should be sufficient to even bring any claim to nil, and if not to nil, then certainly a very small amount. I think that should cover negligence. May I move to loss of earnings? And the authority that I want to first bring to Your Honour's attention, I may have referred to it earlier, is the George against Gloria Beauty Lounge Authority. That's at page 866 of the bundle. And that's a claim where various employment related claims were brought for damages to failing to lift an absconding case against the employee, and a claim for penalties in addition to notice pay, interest, and additional damages. But what the pertinent sections to consider here begin at paragraph 103.
Say what?
103.
103.
So what this says here, but what the court is saying here, is that under Article 20, again, it's the same article that's relied by the defendant. There is an assumption of responsibility by an ex-employer to an ex-employee when the employment relationship was entered into to obtain a visa. But again, that also includes the cancellation of an employment visa. And so pertinent sentence is, thus, it is reasonable for the claimant to rely on the defendant regarding action on his visa. In fact, he has little choice but to do so unless he wants to refrain from working. Therefore, the claimant's claim for pure economic loss of income is valid. And then moving on to paragraph 104, the next paragraph. The second sentence, it is unreasonable to think that the claimant could have had his visa cancelled and begun alternative work before his effective date of termination, as determined above, passed. Now, I want to deal with the evidence, but I just wanted to set the scene with this case and to show that the obligation to cancel, as I was saying earlier, is not an obligation that derives from the employment law, in the sense of an obligation to the employee. There is a statutory requirement to cancel a visa, and that's at Article 57. Article 57.3 of the employment law provides that the employer and employee must cooperate to ensure the cancellation of the employee's UAE residency visa as soon as reasonably practicable following termination date, and we know what that means, and by no later than 30 days. Now, if there is a regulatory breach, I accept that's between the defendant and the regulator. But in the context of a request for or the requirement for a visa to be cancelled, that is very much a tortious duty that's imposed by the law of obligations.
It's also, doesn't it, under at Articles 67 or 68, as well as imposing a fine, a court can order compensation, in effect, to a person who's affected by the breach.
Yes. Just trying to pull up
Article 67.
Yes. Any penalty, so 67.2.
Yes.
Yes. Well, then that means there are two ways to get here, under the law of obligations and also under the employment law. Although under the employment law, to be fair, you would need to go through the process of going through the Article 67 tests first.
Yes.
Although that may not be difficult to do, but nonetheless, it would need to be done.
I haven't looked to see who can bring some action for contravention of the provision. I'm not sure whether it's dealt with.
No, although I think, admittedly, I don't recall Article 67 being pleaded in the particular claim, no. to be fair. However, the facts and the principles in effect have been pleaded, which is that there was a duty to cancel the visa. It wasn't, and it has always been the claimant's case that he has lost out on income. It may be that there's an argument coming that, well, the claimant hasn't pleaded Article 20 of the law of obligations, but when one looks at I think it was Article 20 of the Law of Damages and Remedies, and that's at well, the law of damages and remedies is at page 751 of the bundle. But Article 23 is at page 757. And that Article 23 was pleaded. It states that if there is a breach of an obligation under the law of obligations, which could be any obligation under that law, gives the in this case Mr. MOORKATH the right to damages to compensate the injured party for losses as a result of the breach. The right to damages can either be exclusive or in conjunction with other remedies. So I'd say it's clear from the wording that there is a breach of an obligation relied upon by the claimant. Whether or not he specifies Article 20 or not doesn't matter. When I submit, when one looks at the statement of case, he's effectively said the same thing. Now, actually here, dismissal takes place, as we know, on the 23rd of March 2022. Cancellation takes place on the 3rd of November 2022. And one has to ask what happens in the intervening period. You have evidence before. Well, let me put the party's position first. Claimant says defendant has acted unreasonably. Defendant says, well, the claimant's acting unreasonably and relying on the fact that he's got a visa keeping him and his family in the country for a period of time. But what is indisputable is that the claimant made two specific requests in two separate legal notices. And in terms of the page references, those are the first legal notice requesting cancellation of the visa is at page 290. That was in May of 2022. The legal notice itself is undated, but the evidence is, I think the accepted position is that it was in May. There was no answer to that point by Manon and Friends instruction solicitors in their response on the 15th of June 2022. Not blaming them, I'm just saying that on behalf of the defendant, no instructions must have been given. But either way, there's no response. That's an indisputable fact. Another indisputable fact is on the 22nd of September, there's a final legal notice requesting cancellation of the visa again by the claimant. That was at 297 of the bundle. And there is a response on the 10th of October 2022 at page 301. Where again there's no mention again. Now, Manon and Friend will say, well, on the 28th of September, Your Honour will recall, with the evidence being from Mr. Abdul Malik, there was an email sent on behalf of the defendant to the claimant asking to cancel his family's visa. And I would say this in support of the claimant. At that point, there were legal notices sent in respect of his entitlements. There was one specific request made before for cancellation. It wasn't answered. There was a second specific cancellation request made, and then comes the email to now say all of a sudden that please cancel the visa in respect of your family. But this is when the parties are embroiled in a back and forth as to whether or not Mr. MOORKATH can receive his entitlements. And I say he reasonably responded saying, well, I've already sent a legal notice about my dues and entitlement. We are awaiting a reply because the visa cancellation is part of that notice. And the email is at page 495 of the bundle for Your Honour's reference. At best, for Manon and Friend, I say that this limits any loss of earnings claim to around the end of September. But in my submission, this still shouldn't trouble Your Honour that much, because the context is that there was a pending legal notice that required a response The response was received, and eventually a decision was taken by Mr. Moorkhath to cancel the visa. Sorry.
Well, perhaps I was going to come on to the question of evidence of loss, but you mightn't be there yet.
Well, we can go there because the evidence of loss is very much fact dependent, because the reason why I say that is as follows.
Well, let me say, before you embark upon that, let me say ordinarily, I would expect a claimant to produce evidence of the jobs he applied for, the particular jobs on particular dates and the responses from the employers to whom he applied and the wages that would have been obtained and so on. But we don't have a single piece of evidence from Mr. Moorkhath about this. Correct.
He admitted the same. Now, it is what it is, as it were, because on his account, on his evidence, what he did is he used the word references, that he was trying to get other employment through references. Now, ordinarily, when one is applying for a job, there will be a formal application. You might see an email, for example. You might see a CV attached. You might see all sorts of evidence in that respect. But what Mr. Moorkhath's situation was that he was dismissed, and when you're dismissed, you don't you're all of a sudden available for work. One doesn't go in and say, well, I've got a notice, I've got a notice period, etc., because the notice wasn't given to Mr. Moorkhath, so he was immediately available. It's different to when one is working either their notice period or before being dismissed or before resigning. One applies for a job and then is asked, well, I've got a 3-month notice period, and obviously the usual about visa. But Mr. Moorkhath's situation is we skip all the preliminaries, we're straight to the visa. And so even if the evidence is provided to you that, well, he had these job opportunities, etc., nonetheless, you've got the evidence that he made an attempt. You've got his oral evidence.
Well,
you've got his.
He just referred to references. Yes. He didn't say I approached AXB personnel recruiters or I went to see whatever. It was at such a high level of generality that it's awfully difficult to give any weight to it.
I accept that. What I would pray and aid is the comment made in the case of George, in the George case that I referred Your Honour to earlier, at paragraph 104, where the dicta states, it is unreasonable to think that the claimant could have had his visa cancelled and begun alternative work before his effective date of termination. What I say that we can glean from that is that it's unreasonable to expect an employee to be able to necessarily not just secure work. I understand the point about the lack of evidence, and I can't make any submissions beyond that. But at the very least, to accept that even if such employment was obtained, for months and months, his visa wasn't cancelled, and it was only until September that the defendant, that Mr. Abdul Malik, decided actually, let's send an email. In fact, the evidence is Sudatel didn't give the instruction to cancel the visa. So in either way, he has lost out. We submit on that factual basis. That's all I had to say on loss of earnings. The remainder of the claims relate to childcare, air tickets. I just wanted to check there's nothing else. And childcare, air tickets. Oh, and unpaid leave. I think this is just going to come down to a contractual interpretation. The factual background is Mr. Moorkhath was suspended. So taking, for example, unpaid leave as a starting point, I think the defendant accepts that 34 days of prorated leave was paid. Mr. Moorkhath is seeking unpaid annual leave of 41 days. If it's dismissal with no cause and dismissal with cause in 35. But it's an unusual scenario to expect to suggest, well, Mr. Moorkhath is suspended from work, therefore there's no right to holiday pay, and it's as simple as that. When one is suspended, one can't take holiday pay, and so if let's just say he wasn't suspended and he returned to work, what would be the situation as to his entitlement that he had during the suspension period to that annual leave? If he wasn't suspended, he would have taken that leave. If because he was suspended, he wasn't able to take that leave. So on that basis, he seeks his annual leave. In relation to the round-trip air tickets and the child education allowance, one of the issues raised by the defence is that Mr. Moorkhath hadn't completed a year's worth of service. I submit that that's not what the contract says. Contract gives him an entitlement. In relation to the air tickets, I understand one argument coming against me is going to be that Mr. Moorkhath was out of the country for a period of time, but it's only a period of time. He didn't, for example, in one of the authorities that Malone Friends cites, I believe it was the Abdul Salam case, the claimant in that case had returned back to Sudan, and so but prior to his dismissal, is my understanding, and so it's obvious why that claim would fail. I'm just checking. Yes, it is the Abdul Salam case.
But in relation to when both the childcare and the air tickets become available, I haven't found it at the moment, but as I understand the issue between you is that you say on the proper construction of the contract, well, I'm not quite sure what you say, and on proper construction of the contract, when does the entitlement to the allowance arise?
I can answer it this way. When an employee begins a new cycle of employment in terms of a year, for HR purposes, and by that I mean a renewed annual leave entitlement and for example air tickets, etc., then from that moment the entitlement must begin, because for example if one has 24 days annual leave, that entitlement is renewed the following year, and from the moment it is renewed, the entitlement exists for an employee to take leave. But
well, the better contracts spell out when you can take leave during the year, but if they don't, it might well be that it accrues either week by week, month by month during the course of the year. But
could do.
Take the example you referred to the cycle. What about the first, when the employee first starts employment? On day one, if he's done 1 day's work, is he entitled to the air tickets? Is he entitled to childcare for the whole of the year? And if he resigns on day 3, he gets the whole of the air tickets and the childcare, or what?
Simply yes. What I would say, what normally one sees in employment contracts, for example, it's an obvious example, but annual leave. Leave can't be taken during a 6-month probationary period is a common term that's seen. But in respect of the air tickets and child allowance, if no such term exists, and incidentally, we're not in that situation because Mr. Moorkhath had been employed for a many number of years, then the entitlement would arise immediately, and especially when it comes to child allowance, it could be a good example here, where an employee begins employment and has told his employer, for example, I have 3 children, I want you to pay for my schooling, for my children's schooling, and they agree. When the children come over, which can be immediately, then the entitlement exists, and the employee is entitled to use that allowance, I say. So that's how I would answer that question from your.
The wording itself really doesn't offer us any help one way or the other, does it?
No, it perhaps doesn't. It perhaps doesn't. It could be argued that it leaves it open either way. I would submit that it would ordinarily favour an employee.
I think, am I right in saying there is no evidence of how, in fact, it was applied during the course of his employment?
I don't think there is evidence before the court of how it. No, I think that's right.
That doesn't.
That is right. No, it doesn't. No, but that's right. The only one other. There is an authority I just want to take you on to on the point of air tickets, and it's one that's cited by my learned friend. The authority appears at page 934. And there's a specific paragraph that deals with paragraphs, plural, that deal with unpaid payment in lieu of untaken leave. That's at page 941 of the bundle, paragraph 18 of the judgment. The judgment here dealing with
what
payment.
Paragraph was, sorry, what paragraph?
Sorry.
Oh, yes, 18.
Paragraph 18, yes.
Yes.
This is a paragraph. These are paragraphs dealing with payment in lieu of untaken leave. And the context of this case is that there were disputes as to whether or not there had been termination as in the context of I think it was periodic employment contracts. I think my learned friend was involved in that case actually, so he may be better. As it were, we may be able to receive an employment lesson from him on this. But that's my understanding of the case. And the conclusion was that there was no entitlement to pay in lieu of untaken leave unless the contract is terminated prior to the expiry of the fixed term. That's not the same situation as this present case. And on air tickets, paragraph 22 introduces the contractual clause, paragraph 23 deals with gross salary, but paragraph 24 is perhaps what we need to look at. Page 943 of the bundle. Where I think it was Justice Sir Jeremy Cook. Yes, Justice Sir Jeremy Cook concludes that the claim was odd for two reasons, at least two reasons. The terms make no suggestion of an entitlement to a cash payment if the entitlement for a round trip air ticket for himself was not taken up. But I would respectfully submit, first of all, this is only persuasive authority given that it's at the same level, i.e. court of first instance. But I would respectfully submit that may not be, I would disagree with Justice Sir Jeremy Cook and say because there is no suggestion doesn't mean that is in effect what is available to an employee. Because it's not said so doesn't mean he necessarily can't have payment in lieu. And he'll.
What's the legal analysis for that? Do we go to the employment law to see where that entitlement comes from? Is it a breach of contract? No, what is it?
Well, it's not so much. It's more that the claimant would. Well, I suppose it may even depend upon certain findings. But assuming your finding is that the defendant dismissed, thinking this through, the defendant would have dismissed either with notice or without notice, and so exercises a contractual right. The claimant is saying, well, I would have exercised my entitlement, or at least that is my entitlement, had I not been dismissed at that time. And that's probably as far as I can take it in that.
But what is the source of his entitlement? I mean, what Sir Jeremy Cook is referring to, or at least touches on there, he says the contract doesn't say that you're entitled to payment in lieu. Now, that may not be the end, but if it's not if the contract doesn't provide for an entitlement to payment in lieu, where do you get it from? Now, for example, if it could be said there was a breach of contract and it's damages for breach, or are you saying that I haven't gone to the employment law to see if there is some provision which says you should have got everything the contract was said you should get, and if you don't, you can get it, or something to that effect? I think I have to be able to find a source of an entitlement to payment in lieu. If it's not, if the contract doesn't provide it expressly, or even if it did, supposing it did, what's the entitlement then? Is it a contract claim, or because I think you've told me in effect that it's got to come under the employment law.
I think it still does need to come under the employment law.
So don't I have to find a provision in the employment law which covers it?
I'm just having a quick look again. I don't recall seeing anything under the employment law saying that any payment such as air tickets, annual leave is different. I think because that there is vacation leave that is specifically catered for in the employment law. But thinking on my feet now, I can't think of anything from the employment law.
Your Honour, for this, I was hoping to walk you through some of the employment law provisions that might give my own friend the opportunity to see whether he disagrees with what I say about that.
All right.
All right. Well, then I'll reserve my position if that's all right.
All right.
One final topic then to deal with is penalties, and I suspect that penalties will depend upon what your finding is on whether remuneration wasn't paid. I think my learned friend's going to make an argument about waiver, i.e. that the dispute was crystallised and clear for the parties. If we look at Article I think it's 19. Sorry. Yeah, Article 19 of the employment law. Article 19.4, a penalty payment pursuant to Article 19.2 will be waived by a court in respect of any period during which a dispute is pending in the court regarding any amount due to the employee. And what I say that's quite clear. It's whether there's a dispute pending in the court, not there is a dispute between the parties. The cutoff here is to prevent penalties from racking up even beyond the claim form being filed.
So the cut-off date would be perhaps either the 31st of December or the when you filed, or the date when the court issued the claim. Is that the point? Yes.
Well, I would have to say a fair analysis, given the arguments I presented earlier, would be the 31st of December 2022.
Yes. Yes.
Can I assist, Your Honour, any further on any of the submissions I have made?
No, I think that's they've exhausted both of us, I think, Mr. Costello. Which takes me to, if that completes your submissions, I thank you for that. But it takes us to the point, what we're to do now, Mr. Doherty. Mr. Costello has had, and I think, an hour and 3/4. It's now 4:32 Dubai time. What do you want to do? Do you want to continue on?
I'm happy to take instructions. Probably my preference. It really is going to come down to the court staff, I suspect.
Yeah.
I'm going
to ask.
It's 12:30 for me. I'm more than willing to crack on and get it done. I imagine that from a cost perspective, the parties are probably going to would prefer that as well. My clerks might prefer me to say go part out.
Well, the options I was going to give you was not a part heard, but either, depending on the court and depending on you, to come back tomorrow at an early hour, because I have some commitments in the afternoon. But if you can't do that, then I think it has to be it has to be today.
Yeah, and I think everyone's I think mine and my solicitors and my client's preference would be to crack on. Let's see if we can get
All
to
right,
the
well,
end of it. If the court staff can.
I'm going to ask Ms. Norton. Ms. Norton, you've heard the exchange. I'm mindful that there's a burden falling on the court staff as well. Are we able to continue? It may well be going on Mr. Costell's time. The hour for Mr. Doherty may well turn into an hour and 3/4 as well. Are we able to continue for that amount of time?
That's fine, Justice Lemiere. We're happy to accommodate to your schedule. It's absolutely fine.
All right. Well, I'm grateful to you. And in that event, Mr. Doherty, you have the floor.
If Your Honour wouldn't mind if I just switch off my camera, because
yes,
I think I need. Yeah, thank you. I don't mean no disrespect. It's just this cold that I'm nursing.
As long as we know you're there listening.
Yeah. No, I'm here. Thank you.
All right.
Thank you. I'm grateful to the court staff, but probably a professional hazard of working across so many common law jurisdictions at the same time. I'm sure this happens all the time. It must be very frustrating, but I am grateful. Your Honour, rather than signposting everything, I'm just going to get into the headings in the same order that I've dealt with them in the skeleton. I'm going to start with limitation. The summary of that's at paragraphs 24 to 31 of the skeleton. In truth, we say this is really as far as you need to go in your consideration of this claim. We looked at the relevant provision of the employment law during opening. I'll just reread it, but it's subject to Article 22 and Article 61(2). A court shall not consider a claim under this law unless it's presented to the court either during an employee's employment with an employer or not less than 6 months after the relevant employee termination date. So as I'd already said, the terms here are mandatory. It's the court shall not. This is different, for example, from the English Limitation Act provisions. There are then narrowly defined exceptions to that. And so the examples are, first, if you just want to pull them up, Your Honour, it's 61(2). It's a page 734. I think you've got a hard copy of the employment law.
I do.
But these are Part 9 claims, so it's discrimination and victimisation. And what
we
are
can put that to one side.
Yeah. So what the only point I make there is 61(2)(b) says you can satisfy the court that there are circumstances which justify disapplying. So there you have a discretion to disapply, but the corollary of that is that the court has no discretion to disapply limitation in respect of other claims. And we would say that that much was clear when we look at what the Chief Justice said in the Abdul Salam Court of Appeal case that we looked at yesterday. Again, for your reference, it's 920 paragraph. So that's page 920, paragraph 83, which says an employee, an employee who had not commenced a legal proceeding under the 2005 employment law within 6 months of the termination of his or her employment at the time of the 2019 law coming into effect, they would not be able to have it considered by a court. And then the final point, which is something I'm going to circle back to when I deal with penalties at the end, remarks that the evident purpose of this provision is to pick up employees who may be, as it were, resting on their rights in order to gain the benefit of claim for penalties which might accrue against the employer following the termination of the employment. So in short, if your claim is late, that's that. The court doesn't have discretion to entertain it. And that's completely fatal to this claim. So if we look at...
I think, as I understand, Mr. Costel accepts all that, but he counts the 6 months differently.
Yes, and we explain why that is wrong as a matter of the interpretation of the statute. So the starting point is if so it's 748 of the employment law, but if you've got the hard copy, it's the definitions section dealing with the defined term termination date, which gives you two options. A, in relation to an employment contract terminated by notice, it's when the notice period expires. B, in relation to an employment contract terminated without notice, it's on the date the termination takes effect. Now, based on that provision, the only relevant termination date here is the one that takes effect under B. And we know that from the termination letter, page 287 for your note, which says this letter is to inform you that your employment with EXPRESSO Telegram Group as a corporate finance director will end as of March 23rd, 2022. And 6 months after that takes us to the 23rd of September. And there's no proper answer to that, where the issue date on our case is the 26th of January 2023. And there's still no answer to that if the issue date is the 30th of December 2022. There's no way to make this claim in time, even if one applies the most generous possible allowances from the claimant's perspective, including where one were to make assumptions that were frankly wrong in law. You still can't get around these provisions. So to give you the first example of that, let's say the claimant here is arguing, well, I shouldn't have been dismissed for cause, that was wrong, and so the termination date should therefore be taken to be upon the expiry of what would have otherwise been my notice period. That sort of submission would lead you to an error of law, because even if the contract is wrongly terminated for cause, and that then gives rise to an entitlement that you bring a claim for, so here notice pay, the date on which the contract actually comes to an end, and therefore the actual termination date, remains what it says. So in the letter terminating the claimant here, it says 23rd of March 2023. The employee can go and have an argument about whether that was properly for cause or not, but it doesn't change the fact that their termination date remains the same. So the cause element only informs what the extent of your entitlement is post-termination. It doesn't change the termination date. Otherwise, one would find circumstances.
But the exception, Sir Doherty, under Article 22, it's not concerned with termination date, is it?
No, and I'm going to explain why that is. But just if I can finish on that point, if my learned friend's analysis was correct, and if you come to the conclusion that actually maybe there wasn't enough here for a reasonable employer to terminate with cause, so I'm going to allow him his 3 months notice, you would end up in a situation in these sorts of claims where you have a great deal of legal uncertainty as to whether the applicable limitation period is 6 months or effectively 9 months, depending on how an employee argues their case. And that would mean, for example, that you couldn't deal with limitation by way of a preliminary issue, or on an application of you couldn't apply to strike out a case on limitation grounds, for example, if that analysis was correct.
It's been the in Australia, at least, the courts have said for many years that that's a reason why limitation points should not be determined as preliminary issues. Different contexts, of course.
But they often, different context.
But they often, limitation points often depend upon factual findings, and it's for that reason courts often won't hear limitation points as preliminary issues.
That can be true if you're dealing with, sort of latent defect, states of knowledge sort of arguments that arise. Well, they certainly arise in the UK under the Limitation Act, but they're not those sorts of arguments don't really apply here. This would be more akin to where you've got a point of law. If someone makes an application to strike out based on limitation, you grasp the nettle, as it were, and deal with it. But putting the procedural aspect of it to one side, the way it's framed, the wording of Article 10 says, subject to, a court shall not consider a claim under this law. If what my learned friend says is right, and you have to work out whether the relevant limitation is 6 months or effectively 9 months, the court, ironically, would have to hear the case, and it would have to entertain it in order to come to that decision. And that can't be the intention of a provision which is ultimately there to give employers a sense of legal certainty as to whether or not a claim can still be brought. That to one side, it still gets the claimant nowhere, because the termination date on their best analysis is still the 23rd of June 2022. And the limitation period starts to accrue from termination date, So that gets you to the 23rd of December.
Well,
so
I don't think that's right, is it? The way Mr. Costello took me through it, if you go to Article 20, it's no longer concerned with termination date.
That is my next point to deal with Article 20 and what that is. The point is, if you're going to bring a claim for end of employment entitlement under Article 19 of the employment law, which is what this case is, the default position is limitation starts to accrue on termination date. And that's not assisted by Article 20 at all. So if your honour looks at the employment law, you can see, I suppose this comes to what you were saying, is you have to identify the source of the right.
Yes.
Page 720 of the bundle, Article 19, is the source of the legal rights being claimed in this case. So an employer shall pay to an employee within 14 days, so that's where the 14-day requirement comes from, these amounts. And this claim is therefore brought for those amounts pursuant to the terms of the employment law. Same thing goes, for example, if you look at 19.4, a penalty pursuant to Article 19.2. So the entitlement to penalties arises under Article 19 of the law. That's the source of the entitlement. It's the source of the claim. It doesn't arise under Article 20. What Article 20 is dealing with is something which is quite different. And you can see it deals with deductions from wages. So if you look at the terms, an employer shall not deduct from an employee's remuneration or accept payment from an employee unless the deduction is permitted by law, there's a prior written agreement, and so on. In relation to claims brought by an employee that an employer has made an unlawful deduction from that remuneration or otherwise failed to pay, that's when we get this 6 months beginning with the date when the remuneration should have been paid. What Article 20 is dealing with is a scenario where a deduction is made from your wage packet from within employment. So it's where you say you were entitled to something. So let's say that you're still employed, you haven't handed in your notice. An employer says, well, I'm not going to pay you your air ticket because, well, the company just doesn't have enough money to be giving out those benefits right now. If you say, I've claimed it, and they haven't paid it, you've then got 6 months from that point in time to bring the claim. And that provision makes quite a lot of sense. So the reason you've got this specific limitation provision at Article 22 as a carve-out is because of the way Article 10 itself is framed, because Article 10 says two things. One, 6 months from the date of termination. Otherwise, you can bring a claim at any point during the course of your employment.
I see, yes.
And so the purpose of the additional limitation period in Article 22 is to stop there being a situation where you can have had a deduction or you can go back and source a deduction from wages from within employment, say 10 years ago, or steal claims from a long time ago and still rely on those in pursuing a claim. So the point of Article 22 is to impose a 6-month cutoff. If you're saying you haven't been paid something by your employer, you've got 6 months to do something about it. Otherwise, the right is extinguished. So the short point is that this isn't an Article 20 case, and there's no world in which it could be. And we know that if we go to the particulars of claim, I'll give you the references if you want to go to it. Paragraph 39. Deals with protection of remuneration. It says, upon termination of an employee's employment, Article 19 of the employment law provides that, and it sets out what the entitlement is. It refers to vacation leave and relevant statutory provisions there. And it refers to the relevant basis upon which one should make the calculations. So the pleaded case is Article 19. If you framed this as an Article 20 case, it would be, we say, an error of law. And there are two subparts to that. One, it would be an error of procedural law, because we don't have a pleaded Article 20 case. And even if one were to take sympathy with the claimant's position and say, well, what if I was minded to allow them to amend the case to include Article 20? That doesn't help either. And that's because of what Justice Sir Jeremy Cook said his decision in Abdul Salam. So on that point, if I can ask Your Honour to look at page 952 of the bundle.
Yes.
Paragraph 52, starting with RDC 7.34a. And what this says is that the RDC require that all claim forms must state the law governing the dispute. In common law jurisdictions, a party is required to plead facts which constitute the cause of action and does not have to plead points of law. But he then says if the cause of action is statutory alone, however, such a breach of duty would be necessary to plead. And you need to plead its breach in order to plead a cause of action. Because the DIFC is founded upon statute, you do have to plead the statute upon which the cause of action is founded. And that's a foundational procedural requirement. So the step one of this analysis is if you wanted to frame this as an Article 22 case, you would have to make an order allowing the amendment in the first place. And the reason that doesn't then help the claimant in this situation is if you go to paragraph 54, which again arises from the statutory basis upon which the DIFC exists. So paragraph 54 says, Counsel for Expresso rightly submitted that the DIFC knows no principle of relation back, where a new head of claim is raised by amendment, so that it operates as if it had been made at the time proceedings were first commenced. In England and Wales, that's an established principle, it said, but none of this applies in the DIFC. So if an amendment is needed to include new facts and pleading for a different cause of action, and that cause of action is already time barred, the court would proceed on the basis that the new claim has no realistic prospect of success, and so you wouldn't allow the amendment on applying that test. So the effect of that is, if one were to introduce a Article 22 claim now, the date upon which it would have been introduced is the 23rd of January 2024, which of course is after 6 months from any date that is concerned with this. So it's wrong in law to frame it as a 22 case anyway, because that's claims from other employment. But even if you thought that potentially there is scope for some analysis through the gateway of Article 22, it's still out of time because it hasn't been pleaded. And if it hasn't been pleaded, you don't get this relation back. So it's still out of time. So that's one example of the generous assumptions you could apply to the claimant's case, so letting them go through Article 22. Others, for example, relate to this print screen at page 1150. So this is the amended, well, the issue date being alleged to be the 30th of December. We make the point that it's questionable what the relevance of that document is. Rule 7.4 RDC says a claim form is issued on the date entered on the form by the court.
Yeah.
7.5 says where a claim form is issued, was received by the registry on the date earlier on which it was issued by the court, the claim is brought for the purpose of limitation on that earlier date. The date 7.6 says the date in which the claim form is received by the registry will be recorded by a date stamp on either the claim form held in the court file or on the letter that accompanied the claim when it was received by the court. And then at 7.8, there's a warning to parties effectively saying that if expired limitation is going to be an issue on that basis, you should note the importance of establishing the correct date of the claim form. I suppose the short point that we raise there is that you should take the issue date of the 24th of January, which is actually stated on the claim form as being the correct date in this case. But as I say, even if you don't do that, it doesn't bring the claim within time anyway. So as I say, the best that the claimant can do in this case is to get to an expired limitation on the 23rd of December. On any analysis, it's out of time. We can't retrospectively amend the case into time, and so it fails for that reason. If I can just, as a bringing that together, pick up the point which Your Honour flagged yesterday, but also today, about the 6-year, the potential for a 6-year time limit. It is an interesting point. It's one that I think is worthwhile answering, but I think there is an answer to why either the provisions in the court law or in the contract law can no longer apply to employment claims, whatever the historic position might have been, because originally when the employment law was codified, it didn't actually have a period dealing with prescription. The place that one might start is if you turn up Articles 3 and 4 of the employment law to fix the statutory framework. And I realise my learned friend doesn't take a point on this anyway. It's potentially to satisfy the intellectual curiosity of lawyers dealing with this case. But Article 3 deals with the purpose of the law and says this law is to provide minimum employment standards for employees, to promote fair treatment by employees and employers, to foster employment practices that contribute to prosperity in the DIFC. And then it's the application of law provisions. In 4, it says, subject to Article 4.3, this law applies to, and then you can say ... B, an individual employed by way of employment contract by a person referred to in Article 4.1a, who's either based within or ordinarily works from the DIFC, as in this case, or if you've agreed in the employment contract to be subject to this law. So these provisions fix the regulatory framework in which employment contracts as a special type of contract within DIFC law exist. And this law is said to be the law which applies to those employment contracts for workers, either if you're based in the DIFC or if you've agreed that it will be applicable. And what we say this means is that you've got within the employment law a regulatory code which applies to the exclusion of other statutory provisions governing what I'll call non-employment contracts. And
It seems to me, Mr. Doherty, that was a bit of a leap to from having gone to take me to Articles 3 and 4, and Article 4 saying that the law applies to an individual, in this case, that would include the claimant. But then you said this is a code which operates to the exclusion of other laws. Now, I don't know where that comes from.
Yes, that is from the case Lutfi, which I'm going to take you now to have a look at what I mean by this and why the Court of Appeal has in the past interpreted the employment law as effectively its self-contained code which deals with these sorts of disputes, and why other provisions, for example, dealing with other contracts, wouldn't apply. So the Lutfi case, you'll find it, the relevant parts are 1038 of the bundle. So this is the Court of Appeal, starting in paragraph 57. This also touches upon the principle as to why unfair dismissal or unfair dismissal principles can't be imported into the DIFC. So starting in paragraph 57, we've got the reference to another Court of Appeal judgment, Hannah Al-Hertz, explaining that. The relevant extract that is being cited that I draw your honour's attention to is paragraph 67, which says the relationship between the appellant and the respondent is regulated by the unamended employment law, which is a DIFC law. It sets out at Article 3 all the statutory rights and protections of the employee, and at Article 8 the minimum standard and requirements of employment which parties cannot contract out of. So that's why I showed you Articles 3 and 4 of the new law. Yes. It then says, in substance, then the employment law has a regulatory content and is the only law that governs the employee who works for any entity having a place of business in the DIFC. Therefore, there is no basis to adopt any other law other than the DIFC employment law to determine the rights of the appellant and his contractual relationship with the respondent is regulated by the DIFC employment law. In any event, the appellant is further failed to establish legal right to compensation for unfair dismissal. So the point there is the employment law has regulatory content. it's intended to be a complete codification of the rights of the employee, and it's only the DIFC employment law that governs the contractual relationship is what's said there, and then that's reconfirmed effectively at paragraph 59 of the fee judgment, which goes on to consider some arguments that were raised under the implied terms in contracts and unfair terms law. What the judge says is concluded above, the unamended employment law is regulatory competent, the only law. It effectively repeats what he said, and this the Court of Appeal's second stamp on it. It is the only law that governed an employee who works for an entity within the DIFC. There is no basis to adopt any other law to determine the rights, and so on. So what we would say is the upshot of that is that an employment contract effectively stands to be treated as a special
just a minute,
type of contract.
I read this case, although not as thoroughly as I might have done, and I might need to go back and read it. But the first thing that, on a fairly hasty reading of it, the first thing that struck me about it is that you've taken me to the judgment of His Excellency Justice Omar Al-Mahiri, but the judgment of Justice Roger Giles seemed to me is quite different. And the Chief Justice didn't tell us which view he favoured. He agreed with the outcome that they both arrived at.
Yes. Well, I suppose what I would say to that is the fact that it's been cited in the approved judgment effectively twice. You've got the reference to paragraph 67 in a Court of Appeal decision, which is then endorsed by another Court of Appeal decision, gives one pretty reasonable comfort that this is...
Well, except... so these two cases were cases that were heard, if not together, at the same time, because as I read it perhaps a little quickly, the two claimants in each case were both, I think they were husband and wife, and the underlying, they claimed they'd been dismissed because of that relationship. Anyway, the two cases we had, and what Justice Omar is citing his own judgment in the other case, and in the other case again, Justice Roger Giles took a different approach. So I don't know that that helps. To the extent that they're different, I think it's, and in the other case, once again, the Chief Justice said, I agree with the outcome of both, but didn't tell us which reasoning he applied. But it, so I'll need to perhaps read more carefully, but as I understand what Justice Giles was saying was not that the employment law is the only source of law which regulates the rights and duties of the parties, but that he was addressing the questions of whether there could be implied terms giving rise to the claims which the parties brought, and he found that you couldn't do that. But I think there was another comment. What else did he say? I'm sorry, I just wanted to see if there's something else I wanted to ask you about. No, perhaps it just comes down to that. It seemed to me that the passages you've taken me to support the proposition you've put, but the judgment of Justice Giles does not.
Okay, well, perhaps if I can put it this way, because I don't think I need to, I don't think I need for present purposes to put it as high as saying the DIFC law applies to the exclusion of other laws. What you would say is actually potentially the rung below that, which is that if you have a specific provision dealing with how one treats something that is specific to the employment law, then you should apply the employment law. If there's some kind of lacuna in the employment law, then one could look towards the outside sources to answer that, which is precisely how limitation was dealt with back in the pre-2019 framework.
Well,
I suppose one way that one...
But the difficulty with that, it struck me, is that Article 10 in its terms, and perhaps I'm going back to where I started on this, it's in effect applying a limitation period to a claim under this law. So it's not put in terms of in any case brought by an employer against an employee against an employer, it must be brought within 6 months. It's a claim under this law that must be brought in 6 months. So you come back to then, it seems to me, that whether or not the claim is a claim under this law. If it is, then the limitation period applies. If it's not, then it doesn't. So you go back to the
I suppose we will come back to this in more detail when we deal with the specific employment benefits. But if one considers what the source of what you're claiming under Article 19, for example, is, so Article 19 says, if you're terminated, you will be entitled to your remuneration. If you go and look at what remuneration says, it says your wages plus allowances. If you go and look at what wages say in the defined terms, I will come back to this so you can look at them in detail, but a wage means payment made to an employee in return for work done or services provided under an employment contract. So an Article 19 claim is a contractual claim. You just have to work your way through the statutory provisions to identify that, because it can be a number of things. It can be Article 19 is partly a contractual claim arising from an employment contract. Partly there's a purely statutory remedy, for example, penalties, which doesn't have any place in an employment contract. That's why you have to go into the weeds to work out what it is. And so the takeaway point we would say is that if you're dealing with something that is codified in the employment law as pertaining to an employment contract, that is the law that you go to in order to determine what the limitation provision would be. And a helpful illustration of the problem that might arise if that was wrong is if one were to look at, so for example, under the contract law, limitation is dealt with by Article 123. And it says any action for breach of contract has to be commenced within 6 years. The cause of action is accrued. It also says by the original agreement, the parties may reduce the period of limitation to not less than 1 year, may not extend it. So you would end up, if that was correct, effectively having a situation where employment contracts, by their very nature and by the fact that they have an automatic 6-month limitation provision that applies to them, in incorporating the DIFC employment law, would simultaneously be breaching the terms of Article 123 of the contract law. Because on the one hand, if you have a contract that says the 2019 employment law applies to this contract, that brings with it the application of the 6-month limitation provision. If that is right, that would contravene what Article 123 says you're not permitted to do in a contract, which is agree to a reduction of limitation to under a year.
But could you not approach, you took me initially to Article 3, and Article 3 tells us that the purpose of the law is to provide minimum employment standards and so on. So it doesn't prevent, of course, the parties entering into a contract which gives greater entitlements. So, for example, what if the parties were entered into a contract which provides that on termination for cause, they will still be, the employee is entitled to 1 month's pay or something to that effect? Or perhaps more realistically, if you just look at the provisions that are brought in about leave and so on, those are minimum conditions, aren't they? So an employee may still have a greater entitlement under his contract than the employment law would give him. And he's entitled to pursue those, isn't he?
If you have been given an enhanced contractual benefit,
yes,
beyond a prescribed minimum, so for example, annual leave,
yes,
that is claimable as a term of an employment contract, but it has to be claimable within 6 months, is the point. Because even though you're enhancing beyond the minimum standard, what Article 10 says is not limitation is at least 6 months. It says that a court cannot consider after 6 months. And it's those mandatory provisions that would defeat that type of argument. I mean, I suppose the only real answer that actually matters for present purposes is that the pleaded claim is statutory under the employment law. So it may well be that a lot of this is
I think I'd better leave that,
but potentially not relevant.
I think I'd better leave that phone alone.
Yes, and if I can just give Your Honour a couple of references to the Abdul Salam Court of Appeal case. I've already given you 83, which explains what has happened since the 2019 law has been enacted, and the fact that the 6-month law applies. The 6-month limitation period applies from the date of enactment to all employment claims, whether they're under the old law or the new law. It's not retrospective application. So, it doesn't apply if, for example, you had a cause of action that arose in 2012 and you brought the claim in 2014. It doesn't retrospectively make that out of time. But what it does is it sets a deadline for claims under the old law for 6 months. That's what it does.
I did read that case earlier, and that's one thing that stuck in my mind. I can't recall if there was only one judgment, but one of the points that was made by the court in rejecting the retrospective and the way it was put argument was the court went on to say, in any event, not all of the claims are under the employment law, which I haven't gone through to study what other claims there were, but that alerted me to that fact.
I would have to go back through memory. In that case, I think there were 7 different iterations of the particulars of claim, but the effects carried forward into trial.
As you've said, Mr. Doherty, it is interesting in a point of view, but perhaps we should leave it alone and move on.
I'm sure at some point someone will revisit the YouTube video of this to come and say, well, look at this interesting discussion when it comes before the Court of Appeal, but I'll move on. But it was just to give you paragraph 54 of that judgment. I won't go to it, but it explains the difference in what the old law says versus the new law, and then paragraph 83, which I think you already have about the effect of that. And so the simple point now is that all claims derived from the employment law have a 6-month limitation period as a matter of law. So that's the summary of that position. That'll deal with limitation. We say that, as I said at the outset, it's as far as you need to go. There's no way to get this claim in time, and that's that. Dealing with I suppose the substance of what we heard about during evidence, I'll call it termination for cause, which comprises the notice pay claim and the end of service gratuity difference. You've already looked earlier at the relevant statutory provisions in Article 63. To give the potted summary, what you have to ask is, was there conduct warranted termination? Would a hypothetical reasonable employer in the circumstances have terminated employment? And the grounds for termination here, we say, are obvious. You can't have the person responsible for handling your finances and your accounting going out and arranging or facilitating the handing over of, on any analysis, substantial payments, so 2 payments of $1 million here, without asking the most basic questions about that, or without performing any kind of independent due diligence or any kind of professional curiosity to that. One of the reasons.
What do you mean by that?
Well,
you say that do you mean what the people who receive the money are going to do with it? Is that what you mean?
I mean, without having a proper understanding of what this is. So when we got to the end of the claimant's cross-examination, it was put to him that effectively once he was told to go get this cash, it didn't matter to him where it was going. That was for Sudatel to determine. From his perspective as an EXPRESSO accountant, it doesn't matter to me. So he's in effect washed his hands of this. And we say that that cannot be a proper analysis of what the duty of an accountant is for a company. One of the reasons that there are both statutory provisions dealing with this, not just in the DIFC, you have the same statutory provisions in the company's law in England and in other jurisdictions. One of the reasons that companies employ proper accounting practices and therefore employ proper accountants is because they have to subject themselves to audit. It's because companies involve lots of individuals and lots of moving parts, and you need to have safeguards against precisely this sort of thing happening. So the position...
Against what thing happening? I mean, to cut to the chase, as I understand, Mr. MOORKATH's answer is, in effect, this was Sudatel's money, which EXPRESSO was holding. Sudatel instructed me to pay the money to Sudatel. That is my obligation. It's not for me to inquire what Sudatel is going to do with the money. And perhaps I mentioned to Mr. Cosdell, I'm not sure if it's the case or if it's just an analogy, but the company is holding the money for Sudatel rather the way a bank does. And if I go give an instruction to the bank to pay me my money, the bank doesn't inquire of me what I'm going to do with it. All the bank has to be satisfied with is that they've got a proper discharge from me for their obligation. So in this case, isn't it the same that there's an account between EXPRESSO and Sudatel? They keep an account. Sudatel instructs EXPRESSO to give it some money or directs it to pay some money to a third party or to a third account. So far as EXPRESSO is concerned, providing that it has a proper discharge for its liability, that's as far as it goes, doesn't it? It's no part of EXPRESSO's job to find out what Sudatel is going to do with the money.
The bank analysis is actually quite an interesting one, because, in your spare time, if you're interested, I'd encourage you to go read Justice Giles' decision in Aegis, which both I and my instructing solicitors
This is where the bank does have a duty to, when it's put on notice, that
the point is that even
the signatories may not have authority.
Yeah, but even if you ignore the kind of that Quince Care side of it,
yeah.
Banks in those circumstances have obligations other than just hand over the money. So they've got regulatory obligations. So they've got AML checks, they've got due diligence checks that they have to do internally to satisfy themselves and in due course the regulator that this payment has been made properly.
Yes.
And as you say, provided there's proper discharge by the bank of those obligations, they just make the payment. They don't have to, sit you down and say, well, are you going to spend this responsibly? It's just that here's your money, take it. It's opposite because one can compare here. Really, you have to think about what is the role of Mr. MOORKATH in this. Is his function, is the reason he's employed as effectively an administrator, you go do this, okay, I'm going to go do it, or is there something more than that? And that's why we say it's important to consider the function that he's actually employed in, because he's accepted that EXPRESSO has its standalone accounting function. So it has to maintain its accounts separately to Sudtel. And there are a host of reasons for that, but not least because the DIFC laws tell them that you've got to maintain company accounts. As an accountant, and as in this case, the only person in charge of that function and for maintaining those accounts, he, like a bank when it comes to performing sanctions checks or performing anti-money laundering checks or things like that, has a duty which extends beyond just doing what he's told or blindly following instructions. Companies employ, as I say, proper accounting practices and also proper accountants because they need safeguards against the unexplained disappearance of money that they can't subsequently, for example, explain to an auditor. You need people in these positions, amongst other things, to guard against the risk of fraud. So having an accountant who properly documents and makes sure that transactions are properly explained and also auditable, that you've got a paper trail, is one of the checks and balances that prevents a company from being exposed by fraudulent insiders, if I can put it that way. And the point that the defendant raises here is that we say, in the way he acted in this case, the claimant is effectively completely asleep at the wheel. He's taken instructions that, on any analysis, are completely bare and unexplained, and just carries them out without asking any questions, without any sense of professional curiosity or proper due diligence that's conducted independently of what he's been told by senior employees. And because the central point, as we say, it simply cannot be good enough for the person heading up the defendant's accounting function to blindly follow instructions given to him to effect large cash transfers without even having a semblance of an idea of what they're about. Just to break it down by going through.
How do I have to look at this in the context of the sanctions? And the whole context of these payments on the evidence is that Sudtel adopted this practice, if I can call it that. I don't think anybody spoke about sanctions busting, but it certainly, on the face of it, is a way of avoiding or getting around the sanctions. So whilst it might not be the way one would expect it to be done in London, although perhaps these days it might be. But there was a reason, or that there is a reason in the circumstances of this case, why large sums of cash are being moved around. It's because of the sanctions. And well, that seems to be a relevant factor.
Yeah, well, having spent some time in the enforcement division in the FCA, I don't think that London is necessarily any different. That's by the by. The companies can have a whole host of reasons for doing things or having processes for whatever commercial reasons, for whatever practical or logistical reasons. None of that displaces the fact that the claimant is employed here to be the accountant of a standalone entity, EXPRESSO. EXPRESSO has its own regulatory obligations of how it needs to act as a company. The claimant is, as I understand it, a qualified accountant who also operates within a professional framework of what he needs to do. And whether or not the parent company for EXPRESSO has in mind that they will operate their business in this particular way, it doesn't displace the claimant's obligation to carry out his duties to EXPRESSO properly. So he can't just say that, well, because Sudtel wanted their business operated this way, I, as an EXPRESSO accountant, just facilitated it and therefore didn't do what I ordinarily would have done in maintaining accounting records. I don't think that that sort of practice would cut it if you had an independent auditor coming in. I don't think it would cut it with regulators. I don't think that you can expect someone as an accountant for a company to simply turn a blind eye to, what could be in some circumstances or in some companies, illegal conduct, trying to get around. The point is, he can't just ignore his duties because he has taken the view that Sudhatel wanted him to do it in this way. If anything, that's the whole point of his position. It's a safeguard against the dissipation of money that no one can explain down the line. And during cross-examination, a lot of what his responsibilities were put to him. He set those out. So as I say, only person employed in accounting. He says he was responsible for handling data entry and the reporting of transactions. He said he was responsible for producing accounting records. He said that those accounting records he produced included the underlying documents and supporting documents as a matter of course. He said that he provided those records to Sudhatel, who then relied on them when they came around to preparing their own records. And all of that was given a regulatory underpin, if I can put it that way. So the claimant was also taken during cross-examination to what the statutory requirements are. And what we say form the absolute basics of what company accounting is supposed to do. We didn't get into IFRS frameworks or auditing standards or anything like that. This is accounting 101. This is the bare minimum of what a company is expected to do in maintaining its proper records. That is creating a true and fair picture of its financial position for its auditors, if no one else, and maintaining proper accounting records, which was defined to include those underlying source documents in respect of every transaction that it undertakes. And there's an obviously quite good reason for that, which is you need to have a sufficient paper trail so that the company can, if it needs to, go back and work out its transacting history. What we have layered, I suppose, on top of that, I suppose what I'll call the accounting 101, the strict regulatory framework in which EXPRESSO is operating, an internal operating framework which gives us another layer of explanation as to here is what you need to be satisfied. You have documented to show that particular types of transaction are authorized. So that's the authorization manual that we looked at, where you have particular volumes of cash disbursements, who needs to approve those. If the company wants to generate a liability of a certain amount, who that needs to be approved by, and so on.
You don't allege that the necessary authority wasn't given in this case, do you?
Well, yes, we do, because these were $1 million transactions, so they're above a €500,000 limit. And what the authorization matrix tells us is that if you want to create a liability, which we say this must be, because if the analysis is that this is Sudhatel's money in the first place, EXPRESSO wouldn't need to record anything in its accounts. It would just be an internal accounting matter for Sudhatel, because if it's right that the money is always owned by Sudhatel, it never changes hands, and so there's nothing to reconcile. But that's not what happens here. You have a transfer of money from entity A to entity B.
Yes.
That is, I think you used the words creditor and
debtor. It seems to me
earlier.
It's a debtor-creditor relationship, I would have thought.
Yeah. And what we would say is that if you have a creditor-debtor relationship, what that leads to is the creation of a liability. And it may well be we've got intercompany accounts which tell us why it is that EXPRESSO needs to pay Sudhatel this money pursuant to clause whatever intercompany agreement they have. But the point is if you're paying someone as a creditor, if you're making the payment in the first place, you're creating a liability on the company's books. It's going to another party, even if it's an intergroup party. And if it's over €500,000, what the matrix says is it has to be approved by EXPRESSO's own executive committee.
I must admit, I don't understand the creating a liability business. I mean, the simple example of creating a liability, which is what I thought it's about, if you're going to enter into a contract to buy something, to buy a building for $1 million, you're creating a liability. But if you're dispersing some money to Sudhatel, I don't see how you're creating a liability. In the same way as, I know analogies are dangerous and I've perhaps taken this one too far already, but when the bank pays me some money out of my account, it's not creating a liability when it does that, is it? It's discharging one.
When the bank holds it, as I understand it, would still be your money.
Well,
the bank might be holding it pursuant to contractual terms.
Yeah.
But here we would say the analysis is it's EXPRESSO's money, which then becomes, if Mr. Moorkath is correct, Sudatel's money. If our analysis is correct, actually it becomes a third party's money. But either way, we say that if you're dispersing money that is yours in that way, you're creating a liability on the company, which is we are paying off this amount of money to someone else, and we're not expecting the money to come back to us. And so that should be something that's approved at executive committee level.
Mm-hmm.
Putting the details of the matrix to one side, what we also saw during evidence was what appeared to be a consistent and eminently sensible process when it came to maintaining most accounting records. So what you have is, in the various examples we went to, some of them were EXPRESSO to third party, some of them were EXPRESSO to third party on behalf of Sudatel. But you get a request for approval of the payment from the relevant person, usually given by email, it seems. As part of that, you generate and then ultimately print out what you would call the underlying document. So that's the invoice in respect of the particular transaction. Once you have the relevant approval, what you then get is the money transfer instruction. So this is the approval matrix through which the money is then dispersed. So those were the documents we saw with the A signature, the B signature, and the company stamp. And then we get a document such as a SWIFT transfer showing the funds have actually been sent to the place they were intended to be sent to. And what Mr. Moorkath's evidence is that the normal practice is you effectively print this all out contemporaneously and you take it and you store it in a physical file, and that's how the company maintains its transacting record. And so as an audit trail goes, what you have is proof of the underlying transaction, the invoice. You've got proof that the payment's been authorized. You've got proof that the disbursement is then released in accordance with the company's matrix. And then you've got the confirmation that the amount has actually been sent to the intended destination. And so if one needs to go back in time and unwind a particular transaction and work it out, you've got the information that you need there. And the defendant's position is that stands in pretty stark contrast to what I've referred to in my skeleton as the irregular transactions. Running through the chronology that Mr. Moorkath was taken to in cross-examination, I'll take you to what I'll invite Your Honour to see as being the claimant's sort of best case surrounding his conduct and what he actually knew about all of this. And the starting point is the document that was at page 156. Feel free to turn it up if you like, but this is the original email from Mr. Rahantala to Mr. Moorkath on the 30th of May, saying, "Dear FAIZAL, please withdraw the 1 million handed to Hashem. Instructions need to be treated with a high level of confidentiality." So right off the bat of note there, we have the fact that the email doesn't mention Sudatel. It doesn't say that this is meant to be a cash transfer, which is intergroup. It doesn't say, you know, this is a payment that we're making to a third party on behalf of Sudatel. Can you go arrange the money so we can effect the transaction as we normally do? All it says is take out $1 million, hand it over to this person. And most concerningly of all, it says treat this with a high level of confidentiality. So get out $1 million in cash, don't ask any questions. And one might ask in those circumstances, well, sorry, but I'll come on to that. If I can just say, first of all, when one looks at this email just from an objective standpoint of someone who's not involved in the transaction, we would say that it's something that ought to have raised red flags to anyone, let alone an experienced finance professional. This is an unusual transaction because of this large amount, because it's cash. because you're being asked to treat it confidentially, and because no one is telling you what on earth this money is for. Having received that, the claimant doesn't respond saying, yes, of course, can you please let me know what this transaction relates to so I can record it? He doesn't say, okay, can you please send me the invoice or the internal memo in relation to this request? Instead, his evidence was that on the same day, he just draws the check and he arranges for the withdrawal of the cash. That transaction ends up being reversed because it's too soon, which is the next chain of documents that we come to showing that the request is premature. It's at, I think that's 189 to 190.
Yes.
And of note, again, in that exchange, the claimant himself uses the word, this is huge, considering it's a cash transaction. The title of the email is pretty oblique. It just says 1M. This doesn't really tell us much. He's told by others that there's a need to delay receipt. He's not sufficiently curious to say why. There's nothing in any of this part of the email exchange suggesting that it has anything to do with Sudatel. There's nothing in the exchange which tells us remotely anything about what this money is going to be used for. It just says 1M. And on the claimant's evidence, what subsequently happens is he arranges for this cash to be withdrawn a second time, again on the 15th of June. On his evidence, he says what happens is he makes the payment request on the 15th. A couple of days later, he collects the money. There's a reference in the Parker Russell report to that being on the 21st of June 2016. It's a 474. It would seem to accord with what the claimant says in terms of timing, but a couple of days after, if it's the 20th, if it's the 22nd, I don't think anything turns on it. But what he then says happens is it goes in a safe for 2 weeks. They actually buy a safe to deal with it, and then it's handed over. And in fact, his evidence is consistent on this, which is that it is handed over and is carried out of the room by a third party.
Well, when you say a third party, are you counting Tariq Zain and Sami Yusuf as being a third party? Or you
no, I'm referring to the other individual,
right,
who is said both in the interview and in the witness evidence to be the person who's actually holding the bag, quite literally.
Yeah.
And I'll come on to some of the documentary evidence that shows that even if one assumes that all of this happened by the book or in the way that it was meant to happen, it was always seemingly understood to have been a payment to a third party rather than a payment just to Sudatel. I'll come back to that. When we get to the point of the cash being physically taken away from Wall Street Exchange, there was a point at which the claimant's evidence got a little bit confused because we've seen reference to, I'll call it the approval memo. So that's the 30th of June memo, which in one unevidenced assertion about the receipt of a WhatsApp, the claimant suggested he actually received before he collected the money, which can't be right because the memo itself postdates his collection of the money. But what he otherwise says about it is, I was handed this memo at the meeting in which the money was handed over.
I thought, and I'm not sure if I'll have a transcript to check this, but I thought where his evidence, as you say, I think there was some confusion, but I thought where his evidence landed, if I can use that expression, was that he got the WhatsApp message after he'd obtained the cash, but before he handed it over.
I would have to go back to the transcript because I don't think that I don't recall having a clear answer to that. I suppose what we're going to invite Your Honour to find as fact is that the first time he's given any document, and the first time he's given the approval memo, is what he said back in his interview, which is, I was handed this document after I handed over the money. So the first time that document is in his hands and he can actually look at it was once the money had already gone. But in either event, what we say is clear is at the point in time the claimant drew the checks that were then submitted to Wall Street Exchange, and at the point in time he collects the money, there is no documentary record anywhere explaining what on earth this money is going to be used for, but he facilitates this conduct anyway. And worse still, if Your Honour's looked at it already, it's the intercompany statement of account, which is supposed to be, it's not the underlying evidence, but it's the journal entry, if I can put it that way, which records this transaction. As I said, it's at 140, you've seen it. There's not much to say. It says cash for STG.
Yeah.
And it's logged as being on the 15th of June 2016. And here we know that on the 15th of June, we don't have underlying documents supporting this accounting entry, or certainly not, there's nothing in evidence to that effect. What was put to the claimant, and what we say Your Honour should find, is that when you actually look at the transaction within that intercompany statement, it sticks out like a sore thumb, because it's the only one of the transactions that doesn't explain even remotely close to anything to do with the underlying payment, just says cash for STG. But also we know that the accounting entry, I was going to say the word false, which I think is supportable, but let's just say it's inaccurate to be as generous as possible to the claimant, because there is no transaction between Expresso and Sudatel on the 15th of June for $1 million. The only conceivable transaction relevant to Expresso on that date is whatever transacting it's doing with Wall Street Exchange. So it is wrong, it's inaccurate. And you can't glean any of that from this record because there's no underlying document to support it. What then we say is particularly damning is that the claimant has kind of gone around and about to try and come up with alternative hypotheses of why it is he thinks that all of this was above board and why all of this was fine. So if one looks at the 30th of June memo, so that's the documented 316, which you've looked at a couple of times. There are a number of problems with this document and what the claimant says about it. The first is, as I say, we're inviting you to conclude that this was effectively handed to him as a receipt after the cash had already been handed over, we say, to a third party. And specifically, the words he used in interview were, they gave me the receipt after they gave him the money. And if we take the claimant at his word there, what that means is the first time he ever comes to learn about the application of the funds, or certainly comes to learn of any documented use of the funds, is in a memo that is only handed over to him after the cash has already gone, as it were. And he confirmed that, I think, during re-examination by his own counsel, that that was the likely scenario, that he received this memo after handing over the cash. And just as problematic, on all of the different pieces of evidence, so that's the witness statement and the interview, the cash is carried away by a third party who at no time is said to have signed a formal receipt saying, I've got this money. We don't have a document formally acknowledging who he is or who he's receiving the money on behalf of. He just walks out of the room.
I've got difficulty with that, I must say, Mr. Doherty. You're proceeding on the assumption that because the third party, as you call him, the third man, for a movie title, because he's holding the money, even though Tariq Zain and Sami Yusuf, they were the ones in the room, they're the ones talking to the claimant, they're the ones that hand over the receipt. The third person has all the appearance of somebody who's, I think in America, they might refer to him as his body man, who's just carrying the bag for them. There's nothing in the evidence to suggest that this is money that was going to that person rather than being taken, rather than that he was carrying the bag for Tariq Zain and Sami Yusuf.
Yes, Your Honour. Perhaps if I could respond to that in two ways, and One is just to highlight this issue that you say there's nothing in the evidence. In many ways, that is precisely the defendant's point in these proceedings. It's unexplained. There's nothing in the evidence that makes it entirely clear how these events unfolded. And one can see the frustration, particularly in your position, Your Honour, of not being able to have the answer to every question that you might have. But this is the consistent thread that runs through the discovery of these issues through to the decision to terminate, which is the national auditor looks at this and says, don't know what's going on here. They go to Sudatel. Sudatel look at it in 2019 and say, right, well, let's do these retrospective board resolutions, but let's inquire from EXPRESSO what's going on. EXPRESSO look at it. They haven't got any documents to tell them what's happening. That's more or less the point. We can't work it out in part because there's a dereliction of the claimant's own duty in making sure that there is a proper record of what's happened here. That to one side. The way effectively I think the claimant is trying to rationalize this is to say, well, it doesn't really matter about the third party because as far as I am concerned, I've just given the money to Sudatel. It's Sudatel's to do what it wants with. And look, here's my evidence. Here's the memo which explains the use of funds. But if one actually looks at the content of the memo, so it's the bottom part of this, it talks about what the payment is going to be made for, so contributing to Mauritania. But the way it explains that the payment is going to be made is it's going to be paid in cash through EXPRESSO company, the holding company of Sudatel in the United Arab Emirates, and delivered to the representative of the presidency of the Republic. So the way the memo is certainly envisaging this transaction is going to happen is not that it's just Sudatel asking for cash that it's entitled to receive from Sudatel, but we're in precisely the scenario of actually, if you look at it and you take it on its face, it says EXPRESSO is going to make this payment on behalf of Sudatel because it's subsidiary. So EXPRESSO is making the payment for third-party use. It's not just an intercompany transfer, which is another reason why, if the memo is correct, the intercompany statement of account is wrong.
Can you just show me, where does it say it's going to be made by EXPRESSO?
So it's the final sentence. It's quite a long sentence beginning the Arab League, etc. But the relevant part is about 3 lines up. So we're going to contribute an amount of $1 million, and then after that to be paid in cash through the EXPRESSO company, the holding company of Sudatel. So they're not saying Sudatel has received $1 million from EXPRESSO and Sudatel is going to pay the money in cash. What this memo is saying, if it's to be believed, is we're going to pay the cash. It's going to be through EXPRESSO. So in other words, EXPRESSO are going to make the payment to the third party.
I see.
So I mean, one of the reasons I think the claimant kind of put himself in this corner is that he had to try and find a reason why, for example, this payment is different to the OpenReach payment, if you recall that, where we've got the invoice from a company called OpenReach. The claimant's evidence is that's a payment that we're going to make on behalf of Sudatel. And so I then got the approvals from Sudatel and I took over the payment process. We effected it. And with that transaction, we had all of the usual documents. We had the invoice, we had the SWIFT receipt, we had the transfer instruction that was signed by individuals at EXPRESSO. And he says this is outside that bracket because this is just me paying Sudatel. It's completely different. But on the only documents we have, that doesn't actually appear to be the case. The intention seems to be that EXPRESSO are paying this money to a third party themselves, and we just don't have anywhere close to the same level of documentation for this $1 million transaction as we had even for a 12,000 dirham transaction elsewhere. And that's the state of play when the money is handed over. We say we've effectively got nothing. The only thing that comes close to explaining what the money is going to be used for is handed to the claimant after the event. Worse than that, I think we found out today on Your Honour's own questioning, which I didn't think to ask, is well, could you actually read this Arabic document? And the question was, well, maybe not. So even if he'd been handed the document a week earlier, it doesn't mean that he's going to have either read it or understood it. So at the point in time he is conducting himself as an accountant of EXPRESSO, putting it bluntly, he hasn't got a clue what's going on. And we say that that cannot be the proper role of an accountant affecting a significant transaction like this. The wheels further come off the wagon as we work through this in time, because some weeks later we had the evidence about the 2 handwritten notes which were added to the document and which were seen for the first time in July. So the money's gone by that point. And they say that the CEO indicated he would submit a receipt. And also,
when you say the 2 notes,
the bullet point 1 and 2.
Oh yes, sorry.
The number of points.
The one that's at the sort of diagonal one was written on the day.
Yeah.
Yeah. Okay.
Well, sorry, I say yes. That's what some of the evidence has been. The defendant didn't know, which is part of the problem. But those 2 notes saying the CEO indicated he would submit a receipt and disbursement is suspended until approved by the executive committee, which means that even 3 weeks later, no one's confirmed receipt of these funds, and also that the payment itself doesn't actually appear to have been formally authorized at the Sudatel level, because you're still waiting on the executive committee to confirm the disbursement. And as I say, one can then lump on top of that the complete absence of the things that one would normally expect in these sorts of transactions, which have been the consistent thread of transacting history and the accounting records kept. So that's the formal authorization of the disbursement internal to EXPRESSO that we've seen for other payments for as little as a couple of thousand dirhams. So that's the stamp, 2 signatures, and so on. There's no underlying document from the Republic of Mauritania or anyone else saying, make this payment to us in this way, or here's a formal receipt. There's no email chain authorizing the release of the payments in that way. So the only internally authorized action that we have is Mr. Rahamdallah saying, get the cash. We don't have any internal authorization from Mr. Rahamdallah that's documented saying, give the cash to X on this date. So the third party who walks out with it is never instructed to receive the cash in that way. And Hisham isn't the person who the money was handed over to, so that doesn't help either. And given the size of the disbursement, to circle back to the point I've already made, there's no approval from EXPRESSO's executive committee, which we say would have been the proper order if this had been done under the authorization matrix. And it doesn't take, we say, a great deal of imagination to see why a lot of this is problematic, because there's no auditable evidentiary trail of how this payment was authorized, how it was released, who it was released to. And those issues in 2016, if anything, appear to be exacerbated when we come to the 2017 transaction, about which we know even less. So here, the only underlying document seemingly that we have is page 227, which is the March 2017, sorry, I think it's 3rd of April 2017 Sudatel memo. So it's Sudatel's board of directors. Your Honour has looked at it during the course of evidence.
Yeah.
And this is about the Guinea payment. A number of points bear obvious repetition, which is that it's a memo about the release of a different sum of money. It's 1.5 million. The memo doesn't mention EXPRESSO at all. It doesn't ask EXPRESSO to do something. It doesn't say, like the other memo, that this transaction is going to be effected through EXPRESSO. All it does is make some reference to Sudatel's executive committee agreeing to make a donation of a different amount, with there being no mention at all of how that payment is going to be made, or what relationship it has to EXPRESSO. And again, what is completely absent in this circumstance is any instruction which is internal to EXPRESSO authorizing the release. So we don't have an email saying, make this cash transfer for this reason. We don't have the payment request. We don't have what I call, as I say, an underlying document, so some kind of invoice specifying use of funds. This is an electronic transaction, and we've seen for electronic transfers, we've got those money transfer instructions signed by two people. We don't have that. We don't have any signed or formal confirmation receipt of funds from anybody, whether that's at Sudatel or whether it's from Guinea. We don't have approval, again, of EXPRESSO's executive committee, and in truth, we don't really have anything at all. You'd find yourself hard-pressed to make sense of this transaction from the documentary record, which, as I say, is precisely the point and precisely why the defendant's position is what it is in these proceedings. And fundamentally, it's the absence of the records, which is how all of this ends up being flagged by Sudatel. And just to give you the couple of documentary references for the what I'll call the contemporaneous acknowledgement by Sudatel that actually it didn't have the documents for this transaction either, or for either of these transactions. So the first is page 196, which is in reference to the 2016 transaction. So that's the email from Shireen at Sudatel saying, FAIZAL, please send documents below, cash for STG. So that implies she doesn't have it. And that's, if I can put it colloquially, fobbed off by Mr. MOORKATH for someone else to deal with. We have another example at 237.
Who on the evidence is her superior?
I believe so. But it's slightly unusual in this sense, which is Mr. MOORKATH's own evidence is he creates the record, he collates the documents, and that is then relied upon by Sudatel for its own internal record-keeping purposes. And the point is, if he hasn't done it, then no one else is doing it. So there's no one up the chain that he's filtering those documents to. And of course, he couldn't have replied to that email with the documents because he didn't have any. For the 2017 transaction, it's 237. And there are the couple of bits of the chain, including where Mr. MOORKATH himself is trying to unravel this transaction because he's realized, actually, this is a bit of a problem for me now. But the first email is back in 2017, where he says Shireen is asking for supporting documents. I know he makes the points that he makes about, well, maybe it was the case that some of these emails were deleted, but that certainly wouldn't have been the case in 2017. And if the documents existed and he had access to them, he could have found them back then. But in any event, he still has access to his email when he sends this follow-up on the 9th of December 2021 saying, I'm trying to prepare a summary of this transaction. Can you please follow up and see if there are any documents here? And if he'd had in mind that there was a particular document, he's like, oh, you know, I recall actually that at the time I received this, he would have said that. He would have said, I remember for this transaction that I had this document. Can you please send me this evidence? Instead, he's just going to someone else and saying, have you got anything? Because I don't. That turns up nothing. And the reason it turns up nothing, we invite Your Honour to say, is because the supporting documents were never acquired in the first place. And that all falls on the claimant's door. It's his fault that there's no document here. The chronology, as I have alluded to earlier, Your Honour, that follows this is what appears to happen is the national audit, Sudatel subject to public audit. The national auditor also, quite understandably, struggles to make sense of these transactions. We had the 243 document. is the resolution itself. The document begins at 240, but this is the 2019 Sudatel resolution, which the claimant had relied on to say, well, look, this had already been authorised. I think Your Honour understood the point of that evidence, that he couldn't have known at the time that this authorised the transaction because it's 2 years later. But if one looks at what the purpose of this document is and the opening paragraph, after reviewing management's letters, considering the comments and the financial administrative issues, held a number of meetings, etc., etc. What appears to be happening is that the board of Sudatel are retrospectively being put in a position of having to take some kind of action because the auditors identified these problems. These are unexplained transactions. Now you need to revisit them a number of years later to explain them, because otherwise, where have these payments gone? After we have this set of resolutions which frame that context, if we go to page 4, I think it's 474. Sorry, apologies. I think I'm taking your honour out of turn. Where I meant to go next was 248. Which is when we jump forward to March 2021, and we've got the email from Mr. Mohammed Al Hassan at Sudatel to the claimant. And here he's kind of come to what we would describe as being the end of where Sudatel has identified these issues have arisen, i.e. we need to come to EXPRESSO because that's where these accounting records should have been generated. And what he says is there's some financial payments during 2016 for $1 million as a donation to Presidency of the Republic. The external auditor gave a note on this and submitted it to the board of directors. Can you provide us with details of this donation along with attaching any supporting documents? So what appears to be happening is that Sudatel have now got around to coming to EXPRESSO March 2021 because they're still trying to unravel what's going on here. The point then is that by the time we get here, the claimant ultimately was the individual who was entrusted with maintaining these records of expenditures. The problems identified have found their way eventually back to the claimant. And in response to that, he's invited to a meeting in order to explain himself. And you've seen some of the extracts of that. 252 is the page reference. The question is put to him. The documents before us indicate that the money intended to go to Mauritania. Why did you give the money to someone else? And his response to that, the best he can do is, according to the practice, I was not obliged to know where the money would end since it was Sudatel money. None of my business. I mean, we say that sort of answer borders on flippant, but it's clearly not acceptable for the person in charge of EXPRESSO standalone accounts to just say, I don't know, and it wasn't my job to know where this money went. And the claimant, I think, accepted in his witness evidence that this is what he said, and this is what his view of the transaction was. And we say that that's effectively enough to get to the point of suspending and dismissing this person as the company's accountant, because it's not good enough for him to say this wasn't my problem or I'm just following orders. More was quite reasonably expected of someone who's being employed in this capacity. And beyond the suspension, we say that the defendant isn't behaving in a way that could in any way be described as impulsive, because they're not leaving the decision to chance. They're not just saying, well, look, that's not a good enough answer. I'm sorry, but you're out. Or for that matter, I'm sorry, but here's your 3 months notice. We don't want to work with you anymore. You're on gardening leave. What they do instead is what one might view as not being particularly financially sensible, but putting him on full pay for 10 months, keeping him on the payroll, keeping him at his normal salary while they investigate it. And there were the two reports which Your Honour was referred to. So there's the one that was called the internal audit. That was the 665, quite short document at 665. Again, not leaving that to chance. There is what we say is a quite reasonable attempt to go get a second opinion from someone who can perhaps be as objective as possible about this and has no skin in the game, as it were. So you go to a form of accountants, Parker Russell. They look into this. They attend EXPRESSO's offices, as they say in their report. And Your Honour will have read the report.
Well, again, it's probably not significant, that's that point, but I say again, I haven't received it as truth of its contents, even for such simple things as we attended their offices.
Yes, I can take that. I mean, obviously, in the same way that you could look at an email and say, based on that email, so-and-so was, this individual is suggesting that there was a meeting which took place on this date. You can take it into account as documentary evidence. I'm not saying that this is sworn witness evidence, but it's not. It's plainly not of nil value. And in any event, we're not asking you to confirm that everything they say is correct. What's relevant is this information was in the employer's hands.
I don't know that that's right, Doherty. It's not uncommon if somebody sought to tender an email which said on such and such a date there was a meeting, an objection may well be taken that unless the writer of the document comes and proves it, it's not admissible as to the, it's not evidence of the fact asserted in it. It's only evidence that it was received by the person who received it. It may be evidence also that the person who wrote it sent it, but it's not evidence of the truth of its contents.
Yes.
Unless of course, for the majority of the documents in this case, no objections taken. So they're in, and they're in, but objection was taken to this document.
Yes, I think there's an extent to which we're at risk of being at cross purposes, I think, because the point of this document is not to say that on this date this thing happened. It is to say there was a problem that has been picked up by the National Auditor. Sudatel have identified a problem. Sudatel have come to us with a problem. We've looked into it. Sudatel's internal audit have looked into it. We have reached much this conclusion about these events, but we're going to go to a third party and we're going to get them to have a look at it and see what they think. And based on that collection of material, that's the way one has to frame if you are a reasonable employer in those circumstances. So we're not here trying to strictly speaking, we're not here to prove each element of that report in court. What we're trying to prove is that a reasonable employer with this report in hand would have reached a positive decision to terminate. And so to that extent, what the report says and its conclusions are relevant because they would have informed our hypothetical employer in the decision that they made. Does that make sense?
Yes. Perhaps it's a point you'd come to later, of course, in all that. In this case, the hypothetical employer didn't make the decision to dismiss, but that's perhaps a different point.
Yeah, well, I suppose I could just deal with it now because, of course, the decision to dismiss is made by EXPRESSO and the communication that is sent dismissing the employment is by EXPRESSO. And what we would say
that's
is
not the way that's not the way Mr. Abdul Malik put it. The way he put it, as I understood, was the decision was made by Sudatel, and Sudatel instructed, I'm not sure if he used the word instructed, I'll need to look at that, or told EXPRESSO to dismiss him.
Let me perhaps put it in the as you say, the dangerous realm of analogy. But let's say you've got something that's particularly charged on it. You've got the CEO and senior employees who are personally involved in a particular thing. What a reasonable employer might do is go to an external HR provider. Sometimes they go to lawyers and say, can you conduct an independent investigation? I confirm as CEO that I'm going to act on the outcome of that investigation, whereupon it becomes adopted by the company and is an action by the company. And effectively what we say here is you've got something similar, which is
I would expect the company to read that report. If it may adopt the recommendation made by the external investigator, but I would expect it to at least read the report. But that's not what happened in this case on Mr. Abdul Malik's evidence.
Yes, well, point one is what effectively happens here is an adoption of the decision that's made. But point two is when it comes to the test that you're going to have to apply, it doesn't actually matter, because I'll come on to talk about procedural unfairness in a moment. But the point is, the procedure is actually a bit of a red herring. It doesn't matter, because what you have to do is to take the circumstances and plonk in a hypothetical employer. And so it doesn't matter what's in the mind of the specific decision maker.
Might it make a difference in this way, in that in looking at the hypothetical employer, decision maker, it has to be the hypothetical employer, a hypothetical employer who knew and had the information that this employer did. And I don't, well, the only information I know at this point that this employer had was it was told by Sudatel to dismiss. It didn't have, Mr. Abdul Malik said, he doesn't know what material was before the decision makers. So I don't know what decision was before the person who actually decided he should be dismissed.
Yeah, so I think my answer to that is it's not about what is in the head of the decision maker that matters.
No, but the information that they had.
Okay, if I can put it,
had some information, but we don't know what it was.
If I can put it this way, if one was of the view that a reasonable decision maker, a reasonable employer would have read the report, what we would say is that's something that doesn't affect the outcome. If anything, it reinforces the outcome of dismissal. So if the hypothetical employer in this scenario would have read this report that was available to them and made the decision, then they would have. So just because you've got an individual decision maker who doesn't read papers that are available, in the same way that would be irrelevant, Mr. Abdul Malik's evidence on that point is not relevant to whether or not the second limb of the test is satisfied. As I say, the conclusions reached are ultimately what inform the formal expression of EXPRESSO's outcome on the decision to dismiss. So that was the document at 287. We say it's a perfectly reasoned conclusion arising from what we invite you to conclude on the evidence were fundamental deficiencies. This is in relation to Lim 1, fundamental deficiencies in accounting. The defendant, simply faced with those findings, those conclusions, and the circumstances of this case, could not justifiably retain the claimant in a position of trust, which involved him overseeing and being responsible for the company's accounts. He failed to perform the very core of the duties of his employment to the defendant, and it was entirely reasonable for the defendant, we say, probably to have dismissed him back on the 23rd of March 2020. Sorry, that's not 23rd of March 2021, but back when his suspension took place in 2021. But going above and beyond that, they paid him for 10 months. It was looked at by the parent company, it was looked at internally, and it was looked at by third-party consultants. Everyone came to the same conclusion. And any reasonable employer, it's hard to see a reasonable employer who would have made a decision that is any different, if I can put it that way. Tying a few points together on dismissal for cause, the right to terminate under the employment law is freestanding, so it doesn't really matter what the contract says. We would also add to that the only real relevance of the contract is it's an augmentation of the statutory right. So it sets out a list of, here are examples of cases where we will dismiss you with cause and without notice. It's not an exhaustive list. It's the way one might view this is essentially the parties having pre-agreed that these circumstances would give rise to an entitlement to terminate without notice. So it doesn't change how one applies the test or what the freestanding right under the employment law is. It's probably a borderline relevance in this case. We say that the most you can take from it is that the parties thought about what sets of circumstances might well justify dismissal for cause and landed on something pretty close to where this case ended up being. With the additional words on clause 12.1c, as I say, it doesn't affect the freestanding right. It talks about provided that if the latter notifies the Labour Department of the incident. That appears to be a hangover from the equivalent onshore UAE federal law on this issue, because there is no Labour Department in the same way in the DIFC. So one could quite reasonably read it down as being a nonsensical provision that is of no application anyway. But ultimately, and I'll just give you the page reference, 498, was the communication prior to termination with the DIFC saying, we think we're going to do this. And so we would say, if even if you needed to comply with the formality, it's there. Again, last couple of points in tying together. I think my learned friend focused quite a lot of firepower on attacking the process rather than the facts. As I say, there are a few problems with that. We're not in the UK courts dealing with the Employment Rights Act, where you have the concept of procedural fairness that arises from case law there. In a nutshell, what the UK has is a position where if the dismissal is procedurally unfair, you as the employer can't say, well, it would have made no difference. And so you will get a paper decision for unfair dismissal, but it effectively gives rise to nominal damages. The first point, of course, is there's no such thing in the DIFC, and that's very, very clear from the Lutfi decision, which says we do not follow the UK employment framework, and it does not say you can be informed by it. It says quite the opposite in my submission. So the question of procedural fairness doesn't arise. The second point is a lot of the criticisms fall flat, in fact, because a lot of the points, for example, were, why didn't you interview Mr. Rahmatullah? Why didn't you interview Mr. Youssef? And there's very obvious and simple answers to that, which is those individuals were no longer employed by EXPRESSO and were themselves engaged in legal proceedings with either EXPRESSO or Sudatel. So it's not like you could compel these individuals to come and partake in an interview anyway.
You could have asked them.
I think Mr. Aloub's evidence is that they did try to arrange it, but
no, I understand his evidence to be that they asked Sudatel, and I think he may have said Sudatel legal, or Sudatel's secretary, or anyway, somebody in Sudatel, if they would provide the personal emails of those people, and Sudatel declined, said they would not, or didn't.
Yes, well, I suppose the highest we put it is to say, given that this is an internal investigation, Your Honour will probably be familiar with, you can even get to the stage of civil litigation. The chances of getting a former employee to come back and give evidence are minute. And the third, I think I've already dealt with, is just to say our position is legally it's irrelevant because the procedure and the mind of the decision maker here isn't relevant to the test. It's the hypothetical employer. And whilst one can see why the claimant would focus on procedural issues, we say because he's pretty weak on the factual circumstances, it doesn't get him anywhere. And so bringing those points together, as I say, the claimant's the accountant, he's the only accountant, and you don't need a policy to tell you that it's accounting 101, that if you've got a transaction, you support it with documents. That was bit of the claimant and he accepted it. It was also the regulatory requirement placed on the company for which the claimant was responsible. And he completely failed to keep accounting records here or to gather any documents which would enable anyone, not least the court, to try and work out what on earth has gone on with these transactions. And where your employee doesn't do the fundamentals of what they are being employed to do, and where the consequence of that is you misplaced $2 million, it's plainly reasonable to terminate them in those circumstances. I was going to move on to the isolated claims, just to take Your Honour through some of the provisions of the employment law. So I think that there was a bit of a focus during the Learned Friends submissions when it came to the contract. Actually, a lot of the answers to the issues you need to decide can be found in the law and the interpretation of the statute, not the interpretation of the contract. So I just want to signpost those for you. Dealing with the annual leave claim, the contract provisions for your reference are 276. So it's 24 days annual leave. The main provision that has any bearing is clause 7.3, which says, amongst other things, payment in lieu is exceptional. Leave accrued but not taken in any year shall not extend beyond March the following year. Any further extension of accrued leave will only be granted with the Vice President's express written approval. So that's page 276. A few points on the contract.
I thought,
first.
didn't it say, my memory is it said with the Vice President's approval or on termination?
Or on termination, sorry, yes, yes, of course. I'm dealing with how you count the numbers as opposed to the, I suppose, the crystallization of the entitlement, if I can put it that way. So the default position is that any leave accrued but not taken can't roll on indefinitely. So you can't just go back 5 years into your employment and pluck back leave you didn't take 5 years ago. It says leave accrued but not taken in any year shall not extend beyond March of the following year. And properly construed, what we say that means is that if you've got, for example, annual leave that's accrued for the year 2020, and you've got some left, you didn't have time, it was a busy patch, whatever, you have until the end of February the following year to use it or lose it, if I can put it in those terms. So it's not going to extend beyond March.
Okay, you say March. Well, that's interesting. You just said February then. I don't
yes,
know
you've got until the end of February to use it.
Is it the end of February or the end of March?
I think we would say the end of February because it is slightly oddly worded provision. You can see an argument either way. The reason we say February is because your leave is not extending beyond March. So as soon as it becomes March, your leave is not extending beyond that point. So you've got a grace period, a perfectly reasonable grace period, we would say, of the first 2 months of the following year to kind of take whatever's rolled over. And that's obviously more than enough time because let's say you've got the whole 24 days. You've got more than 24 days in January and February the following year to do it. But after that, it extinguishes subject to any statutory override, which I'll come back to. The way that the claimant calculates his leave is in his particulars of claimant page 14, but he says there are 5 days which carry forward from 2020. He says 25, but I think it's a typo. He means 24 that he was unable to take in 2021. He then says he's got 12 days that accrue to him from January to June 2022. So that's up until the end of the notice period, which gives you 41 days. And so at most, this head of claim is the difference of 6 days. So he's already been paid 34, I believe it is. And either his claim is for 1 additional day or it's for 6 additional days. Although Your Honour would want to flag that he doesn't calculate it like that. He actually puts into the dirham figure or the full whack for the 41, whereas it should be the difference. But dealing with those in turn, the 5 days in 2020 clearly doesn't carry forward because that extinguishes under the terms of the contract. So that's the point. You can't roll over indefinitely. So as a matter of contract, that right was extinguished as at the 1st of March 2021, which is before any of the suspension or anything else arose. But that's also true as a matter of law. I'll give Your Honour the reference to Article 27(3) of the employment law. And that says an employee is entitled to carry forward accrued but untaken vacation leave into the next vacation leave year for a maximum period of 12 months, after which any unused vacation leave shall expire. So you also have the statutory expiry if you linger on that too long. And the second part of 27(3) says the amount of accrued but untaken vacation leave to be carried forward may be agreed between the employer and employee, provided that, and this is where I refer to the statutory override, nothing shall preclude an employee from rolling over at least 5 work days for a vacation leave year. So if the contract says you can't roll over anything, the statute says actually you can roll over 5. That would be the statutory minimum. So with the 2020 leave, that has to disappear. So that's 5 days gone. So we're down from 41 to 36 straight off the bat. The 2021 leave claim, we say also, as a matter of law, but also as a matter of fact, can't carry forward into 2022 in the way that the claimant says. And the first point is that it's the clause 7.3 issue. You have to use your rolled over leave in those first 2 months of the following leave year. Otherwise, as a matter of contract, it extinguishes. So if you roll over 24 days and you don't use the 24 days in January and February, it disappears. The statutory override would say that you get to keep 5 days of that. So if the proper construction of the contract is that you can roll over, but only for 2 months, once you combine that with the statutory provision, it says you can roll over the whole lot for 2 months, but after that, you've only got 5 days. So that would be 5 days that rolls over for his 2021 leave. And that would mean that his 2021 entitlement that he can claim payment in lieu of reduces to 5 days, not the 24 that is being claimed. So that's, as a matter of interpretation of the statute and the contract, putting it to one side, we say there's obviously a degree.
I'm getting a little concerned. You've been going now almost 2 hours by my count.
Have I? Time flies when you're having fun, Your Honour.
I'm going to say, I hope you can restrain yourself and perhaps speed it up a bit.
Yes, well, let me give you the bullet points on these, because I think you'll probably want to go back and look at the statutes anyway. But some of it's a bit fiddly, which is why I think I need to take you to it. But I'll be quick, and I'll stop talking about how quick I'll be. The factual scenarios, we say, is pretty artificial as well, because from the 6th of May, suspended on full pay, he wasn't working, and the evidence in cross-examination is actually he travelled to India, where he stays until August. And to all intents and purposes, we would say he's on leave for 10 months, but if he remained in employment, he would have been in India until August anyway. So we say he can't now come to the court and say he wasn't able to take any annual leave during this period of time. And then the final point is dealing with...
He couldn't because the letter of suspension told him that he had to be available.
Well, I think strictly speaking, the letter of suspension says that you will retain all of your employment rights.
No, it said more than that. It said,
to give you 268, I think is the email following our meeting today.
It said in the third last paragraph, you're required to cooperate in our investigations and may be required to attend the workplace for investigative interviews or disciplinary hearings, and you are required to be available to answer any work-related queries.
Yes, but it doesn't say you need to be available at all times. And what it also says is during your suspension, we'll continue to pay salary in the normal way. You're also entitled to your normal contractual benefits until the end of the investigation or notice period. And one could quite reasonably infer from that if your normal contractual requirements entitle you to annual leave and you give your employer notice, I know I'm in suspension, but I'm going away for this period of time, that one, they wouldn't have said no, and two, that would have been him asserting his right to annual leave. And the fact is, he was in India for 2 or 3 months immediately following his suspension anyway. So it's one of those where if he'd asked, he would have been given it. And then the 2022 leave, I don't think it's in dispute that the amount should be pro rata. The statutory provision for that is Article 28(1). Which says when you're terminated, you shall pay the amount in lieu of vacation leave accrued but not taken up to and including the termination date. So that's how you get to the right being a partial right. So ultimately, the 2022 leave is, if he's terminated by March, it's 6 days, not 12. And so when you add together what has actually been accrued on our analysis, we say the maximum entitlement is the 5 days rolled over for 21 plus the 6 days accrued for 22. So that's 11 days. And actually, he's been overpaid quite considerably on annual leave. And the overpayment, just so you have the documentary references, 492. Next is the airfare claim. I'll deal with this quite quickly as well. Clause 2.6 just says we'll provide you with round trip air tickets. The provision doesn't assign any cash value to that. We say the proper construction is it's use it or lose it, and you don't get any crystallized cash entitlement if you end up not using it. So an identical provision in an EXPRESSO contract was dealt with by Sir Jeremy Cook in the Abdul Salam decision for the Court of First Instance not that long ago, 12th of May 2023. So the provision in that case was the company will provide you with round-trip air tickets to you and your family members in economy class once every year to travel to your home. And the judge says, in paragraph 23, I'll quote, the terms of that subclause do not suggest that there's any entitlement to money in lieu of the provision of round-trip air tickets. And 24, the claim is odd for at least two reasons. First, terms of the subclause, as already mentioned, make no suggestion to entitlement of a cash payment. So as an Abdul Salam, you don't get cash entitlement if you end up not using what's an in-kind benefit. And we would just ask you to follow what Sir Jeremy Cook said was the proper construction in that case. Putting it to one side, we also just don't have any quantum evidence, so we don't know what is said to support the 30,000 dirhams claimed here. It appears to be plucked out of thin air. Education allowance, you get tuition up to a maximum sum of $7,000. Again, the answer to this is more in the statute than it is in the contract. Just dealing with the contract, if I may, first though, at the outset, we haven't actually got any financial evidence of how much school fees actually cost. And the way one should properly construe the education allowance is it sets a cap, but what you get is money up to the cap. So if school fees only cost $6,000 per child, you don't get 7,000. And so in order to find this claim anyway, we would have needed evidence of what the school fees actually were, rather than just simply claiming the cap. That aside, the position in the employment law is you don't get the full year on dismissal. Again, just as a matter of common sense, employment's terminated in March 2021. It would be quite odd if you could effectively claim another full year's fees for the upcoming school year in September, despite the fact that he's no longer working for EXPRESSO by then, even if he'd been terminated just by the provision of notice. What Article 19 says about the calculation of these benefits, the starting point is 19A1 says, within 14 days, you are paid the defined term remuneration. That's at 720. Page 747, you'll find the definition of remuneration, which means the aggregate of two other defined terms, which is wages and additional payments. Additional payments are excluded from the operation of Article 19, so we don't need to look at what that means. But when one looks at the definition of wage, which is at page 748, I'll read it out. Any payment made to an employee in return for work done or services provided under an employment contract, including any allowance, which is a defined term, but excluding any additional payment. And then the answer to this point is at page 744 and the definition of allowance, which is any allowance payable to an employee pursuant to an employment contract. And it gives examples of what it includes. So it's housing, travel, education, and so on. And it says, where such allowance or any part thereof is not paid to an employee in equal parts for each pay period over a 12-month period, the aggregate annual allowances payable to an employee shall be divided by the number of pay periods for that employee over a 12-month period for the purposes of determining an employee's wage for a pay period. So just to break that down, if you're working out what are your entitlements at the date of termination, you need to ask what's the remuneration. That makes you ask what is the wage. That makes you ask what is the allowance. And the allowance tells us that it's a proportionate amount effectively. So what it means is that you prorate whatever that allowance is anyway. You don't give them the full whack. And that obviously makes sense. Otherwise, employees would wait until their school fees were paid, hand in their notice, go to another employer, get some more school fees, and so on. You can see the problem with not prorating it in that sort of way. Loss of earnings, I think I can deal with reasonably quickly as well. Article 57 does not contain a private law cause of action. It's a regulatory provision. It says if an employer doesn't do this, then it will commit a contravention, exposing it to DIFCA's power to implement fines under Article 9 of the employment law. So this is in some ways the nifty point. the DIFC employment law's got regulatory context, and what you don't do is take that provision and latch onto some private law remedy unless it's been specified. And so what we would say is that the pleaded basis for the claim
what about
doesn't
Article
work.
67?
I'll come to Article 67. I just want to deal with the Article 23 of the remedies law point first, because the first part of the submission is you can't take the regulatory breach in the employment law and then attach to it a remedies provision at Article 23 of the remedies law, because what Article 23 relates to is what is the measure of damages for a breach of obligations under the DIFC law of obligations. So you can't marry the two together. The remedies law doesn't give you a freestanding cause of action. And we say that the provision of the employment law doesn't give you the freestanding cause of action, so you have to find one. Now, on that, we say that Article 67 doesn't help. First of all, because it's unclear whether as a matter of law it's something that gives rise to a right of an employee to bring a claim. It doesn't necessarily put itself in those terms. I think, in fairness, I'd have to concede that that's an open question. It's not helpful in the present case, though, because there's no claim under Article 67. And so that brings us back to the limitation point that I referred to earlier, which is if an amendment was allowed to introduce an Article 67 claim now, even if that sort of claim was permissible, it would be out of time, because you can't have relation back when it comes to bringing the claim within time. And just to deal with very, very briefly the facts, the visa issue, we say, is also a complete red herring. It is commonplace for employees all the time to employ or to apply for a different employment within the course of their existing employment. The existence of a visa is no bar to that. You can still apply, you can still interview, you can still get an offer, and then it becomes an administrative issue at the end of the process. And as Your Honour has already observed, we don't so much as have a shred of evidence of what job applications were made, what interviews were intended, what responses were received by employers, or any confirmation that there's a single employer who said, well, we can't employ you because of your visa. In fact, the only positive evidence we have is that an offer was made on the day the visa was cancelled, which meant that the claimant had to have applied for and interviewed for the job before that happened, and it clearly wasn't seen as a bar. And as well as that, we have no financial or quantum evidence. We don't have an idea of what it is he says he would have made, and it's simply unsustainable for him to say that from the very next day after my dismissal all the way through to the day I was in fact employed, I would have been getting the same salary I got at EXPRESSO. It just doesn't work. It doesn't work in law, and it doesn't work in the facts. Penalties falls away with everything else. I don't need to say much more than that, other than, one, this would be exactly the kind of case where the claimant would benefit from his late filing if his claim was allowed to proceed. So this would be the windfall from resting on his rights referred to by the Court of Appeal in Abdel Salam. But in any event, we say this falls into the exercise of the court's discretion to disapply penalties. So we say that the sums engaged in this dispute have always been disputed. None of the amounts in this claim were accepted. It can't be right that the claimant can just sit on his claim for as long as he can possibly accrue penalties before bringing the claim in order to artificially inflate it. And this is a case where you should waive any penalty claim if it's applicable. The counterclaim, I'm largely going to skim over, Your Honour, because it follows, of course, from what I said on opening about the applicable standards. So I'm not going to address you on that again. We say that the elements of the tort of negligence are made out in this case. The remaining legal issue that I think you wanted me to address you on was, is there an example of a case where someone has brought a claim against an employee seeking pure economic loss? And that's just the extract of that case I wanted to take you to. So this is the Scottish case. Sounds like we're talking about Macbeth or something.
I did. It crossed my mind.
No, this is relied on really as the statement of the principle, which I think is what you're looking
what page is
for the
it?
answer to. So 1150 in the bundle.
Right.
So starting at paragraph 2, which is at 1151. We can see the statement of principle, which I think is what you alluded to yesterday. I acknowledge that employees have an implied obligation to exercise reasonable skill and care in the performance of their duties. That such a term exists is amply borne out by, and it refers to Lister, Janata Bank. It refers to some confusion in the way the case was presented there about whether the claim was in contract or whether it was a duty of care in delict or tort. And at the end of paragraph 2, continuing into 1152, there's an acknowledgement that there are circumstances in which obligations in contract and tort can coexist in the context of an employer and an employee relationship. Then at 3, it says, more generally, it can be observed that employers seldom sue their employees for damages other than Lister and Janata Bank. There are hardly any reported cases. Why that is beyond the scope of this opinion. One can see practically what the reasons are. Often the employee might not be able to make good the money anyway, so you're just throwing cost at something that isn't going to lead to recovery. But as I say, it's not whether or not there are lots of these cases that is relevant, it's the statement of principle. And so what's said here is, I accept that the directors of the pursuers in fulfillment of their duties to the company were entitled to consider whether an action was merited. I accept that in principle, an employee might be so careless in his handling of his employer's finances that steps should be taken to recover the loss. Thus, although the defender sought to argue that in principle remedy was not available to the pursuers, I'm not persuaded this is so. In my judgment, if the pursuers can establish that the requisite breach of contract, they'll be able to obtain damages. So the key point is that in principle, the claim is viable, and the fact that it's rare doesn't mean that an employer can't bring a claim like this, even if more often than not, they might choose not to. Paragraph 51 of the judgment says, so this is page bottom of 1176, top of 1177. He says, I'm persuaded, however, the defender acted in breach of her obligation of reasonable skill and care in transferring the funds. So we've got a finding of breach on the facts of that case. But ultimately, where this case gets to, paragraph 53, is it fails on causation. That's at page 1178. I'll maybe just leave Your Honour to read that. And the only final gloss is this case was considered on appeal, but the relevant point of principle remains undisturbed. So it's the appeal judgment, the relevant paragraph is at 1228, paragraph 27. It says, in a case called Woodhouse, in paragraph 31, having reviewed the authorities, set out the scope of a reclaiming motion against Lord Ordinary's finding on an employee's negligence. Although the duty in Woodhouse was quasi-delictual, quasi-tortious, and the damage was physical, the same considerations apply when the negligence averred is in the context of a contract and the losses are economic. So the point there is that just because this is a claim of negligence against an employee, it doesn't mean that.
So what page did you say the appeal is judgment is on?
Sorry, that's 1228, and the appeal is dismissed. So the actual case here is about an employee who processes a transaction on a whaling fraud. They say there's a breach, but they say there's no causation. The first instance court is upheld on appeal, so it's not a positive outcome from the employer's perspective, but it's the question of principle, which I wanted to draw you on to because you asked about it yesterday.
Thank you.
As I say, the counterclaim, I'm not going to go through the facts again. If there's any specific points you want me to address, I'm happy to do it.
Yes. But what loss was suffered by EXPRESSO?
Yes. So we say that the point here is quite simple. We have in 2016 a sum of just over 3 million dirhams, which is the $1 million amount. That amount of money goes to someone. We say that there is no requisite approval of that transaction from Expresso's perspective because the executive committee have not approved it. So you have a dissipation of an amount of money that was Expresso's property. That money has not been recovered. The same thing happens in 2017 and hasn't been recovered, and is the loss to the company.
The accounts as between Expresso and Sudatel shows that the money is Expresso's accounts showed the money's been paid by Sudatel. Sudatel's accounts accept that, so that the state of account between them is that the money's gone to Sudatel.
Yes,
there's no loss to Expresso.
Well, the problem with that analysis, we say, is what I approached with Mr. Moorkhath in his cross-examination yesterday. So he accepted that what ends up being in Sudatel's account is generated from the entries and documents that he prepares. And if what he does is wrong, then what happens in Sudatel's accounts is wrong.
But I don't think that answers it, because even if it was wrong, Sudatel have accepted it, and they've recorded in their accounts, and the accounts stay that way. So Sudatel are not claiming the money from Expresso. They've accepted on the evidence before the court the statement of accounts as between Expresso and Sudatel is as reflected in the accounts drawn up by Mr. Moorkhath. There's been no reversal of them. There's been no claim back by Sudatel against Expresso. On the evidence before the court, it stays the way it was when Mr. Moorkhath made his entries in Expresso, and when Sudatel made its entries in its books, albeit on information provided by Mr. Moorkhath. They accepted it, put it in their books, and on the evidence before the court, that's the way the accounts are.
That's the evidence of how the accounts were seen to be. So, for example, page 235 is the auditor's letter from 2018. So all that is evidence of, we say, is what the auditor's view was then, before these issues were known. So the fact that
there's no evidence they've been reversed or changed. So far as the evidence before the court is, that's the way it is.
Well, we say that the evidence before the court on this analysis, so if we get to the point of considering loss, the evidence we say before the court is that the claimant didn't know what this accounting entry was in the first place, that he caused a effectively false accounting entry to be created, which was then copied by Sudatel back in 2017. So that's the intercompany statement. We would know that because it's false, is therefore wrong as a matter of fact, and we would know that the money went to a third party and in any event wasn't in Expresso's possession. So the findings we say are that, as fact, the accounting entries are wrong and therefore not to be relied upon. And so the only fact that you have is that Expresso had the money and now it doesn't have the money. And so that is a loss. And the accounts don't repair that. It may well be that as a formality, they can be unwound. It may well be that Expresso recovers the amount of money in this action, and there's an intercompany reconciliation correcting it after.
That's speculation.
It is speculation, but it's
at this stage. If the accounts remain the way they are, and Expresso got another $2 million, it's got a windfall. It's 2 million up.
But it's not, though, because the accounts are wrong. That's really the point. If the evidence leads
they haven't been changed. Sudatel has not claimed from Expresso, you owe us $2 million more than shown in the accounts. On the evidence before the court, Sudatel accept the state of the accounts. They've done nothing to reverse them, to say there's no evidence that they've said to Expresso, those accounts are wrong, you owe us 2 million more than that.
But in my submission, respectfully, all that is evidence of is the fact that the accounts are wrong and no one has done anything about it. It doesn't tell us whether there's a loss. So if you're dealing with
they may not be. it may be that Sudatel accept that when the money was received by Tariq Zain and Sami Yusuf, that they accept that that was a proper, that was a legal discharge, albeit they might say that Sami Yusuf and Tariq Zain, they may have some allegation that they have misappropriated the money, but they may accept that they gave a proper discharge to EXPRESSO. They may do, they may not, but there's no evidence that they've chosen not to and claimed that the payment wasn't made to them.
That may well be the case. I don't think it changes the defendant's submissions that from its perspective and from it viewing its own accounts, the transaction has not been verified and is not proper. One way of putting this is, if there's anything that the DIFC court may have learned from some of the Abraj litigation, is that just because accounts say something doesn't mean that they're right. And if the court knows or has reached a conclusion that the accounts must be wrong, it shouldn't act as though they're correct.
Yes, thank you.
Thank you, Your Honour. Unless there's another point I can assist on, that's what I'm
No, I
supposed to
think
say.
I think you've covered everything.
Yes, thank you.
All right, so Mr. Costello, are there any things in reply?
There are only a couple of things I think I just want to quickly deal with in reply. Just in relation to the Labour Department point and the letter that was referred to, which is at page 498 of the bundle. I understand the defendant seeks to rely on this to demonstrate that a notification was made to the relevant Labour Department. However, I don't invite you to read it now, but it may be something for later. In my submission, that what the defendant is doing is seeking advice, not informing as to not informing the DIFCA that the claimant is in breach and is going to be dismissed, and these are all the reasons why. It is seeking advice as to what to do. But I think it might be best if I leave it for you to review and make a decision on whether you agree with me on that point or not. The only other point I just want to make is on limitation, and it is this, that where within the statement of case at the particulars of claim, at page, and I'll signpost this for Your Honour, page 11 of the bundle, paragraph 39, the claimant has set out his the legal framework of Article 19, and specifically that there is a protection of remuneration, i.e. that the employer shall pay to an employee within 14 days all remuneration, with the exceptions that are provided. But the pleading is specifically in relation to the penalty, and in my submission, the objective of Article 19 is to secure payment with the stick being the penalty. And in essence, where where wages or payments are not made, that cause of action lies at Article 20. Now, when I submit, when one looks at Article 22, and I've made my submission on that in relation to the distinction, the basis of a failure to pay that remuneration. What I'm suggesting is that the reading of paragraphs 48 to 51 of the particulars of claim gets the claim within an Article 20 claim, and so would be in satisfaction of the
48 to what?
51.
Right.
So not necessitating an amendment. So in essence, what I'm suggesting is that where a payment is due within 14 days, the failure to pay is subject to a penalty and indeed the cause of action under Article 20. So when one looks at the wording of Article 20, sub-Article 2, which refers to a failure to pay that employee remuneration to which that employee is entitled under their employment contract or this law, that wording is effectively replicated within paragraph 49 of the particular claim, where it's said the claimant is entitled to receive its full benefits pursuant to the agreement, i.e. the employment contract, or the employment law, which can be cross-referenced to a reference to or this law under Article 20, sub-Article 2.
If you have claimed it, but
Yes.
Mr. Doherty says, even if you have, Article 20 doesn't apply to claims for payments after termination. It's for amounts that the employer has failed to pay during the employment.
Well, I'm not certain I agree with that, because where the protection for remuneration, if one looks at first at Article 19.1, the employer is mandated to pay all remuneration except excluding where applicable. So not any additional payment deferred under Article 18.2 where it applies, where Article 18.2 would apply. So if Article 19.1 refers to all remuneration, when one looks at Article 22, the reference that I emphasized was otherwise fail to pay that employee remuneration, which is the same defined term. And therefore, there isn't a distinction in law on these two articles between remuneration that is payable during the currency of the employment contract and that, excuse me, the entitlements which are due after the termination of the employment contract.
Yes, all right.
Otherwise, it would have said so much clearer. Is the simple point. But
right.
But I say that Malone's distinction shouldn't be adopted. But those were the only. I don't want to go over other submissions. I think I've already dealt with them already.
All right. Well, thank you very much, Mr. Koshkal. Thank you, Mr. Doherty. Thank you for your assistance and those who've been helping you. And I thank the court staff for sitting on late. I will reserve my decision and we will now adjourn the court. Thank you.
Thank you, Honor.
Thank you, Your Honor. Thank you to my friend.